Hello, chat. Hi. Day 3 and day 4 of Ashley Benefield. We need to catch up, and we got a lot to do. So we are going to blow through this, guys, pretty fast. We're not getting all out this afternoon. I didn't realize I put down 225. I clicked 230. Oh, well. All right. Yes. I refresh this page. I still can't see Sean. It shows the ballerina. So, all right, guys. So as we were covering it, we are at the part where they're going through the text messages. I'm going to rewind probably a little bit if you guys want to go through those text messages, but there's a lot of them. And these text messages are pretty interesting as far as things go. Now, just so you know, for the rest of the day, there's going to be a little bit of this guy left. There's going to be some motion practice, and then there's going to be the chief medical examiner, a firearms analyst, and then the state rest. So this is actually pretty quick today. The state is done in 3 days. So Jeff got hammered. Oh, Jeff got trashed last night. He had a fun time. Jeff had a lot of fun. That was really good. That was really, really good. So anyways, guys, we're going to catch up on day 3. And remember, she's accused of murdering her husband and that it was all part of their custody issues. And we are going to watch this at a pretty good clip here. So let's go. All right, here we go.
And 45. Go to an early lunch. So if you could be back downstairs in the jury assembly room at 12:45.
Oh, okay. They're going straight to lunch, so we're starting to break. Okay. I think that's it for us. All right, so we're going to skip ahead to back in court. And I think we have subtitles now. Even better. Wait, is that how they have it? They have cameras in the back? That's nice. They have decent camera setups there. Okay. That's how they're doing this. Ah. Those nice little discrete remote camera setups. Good.
All right, good afternoon, everyone. We're back on the record in the state versus Ashley Benefield. We finished the lunch break, and before we bring Deputy Keyless or Detective Keyless back in, we had left off a bench conference with the defendant seeking to admit and then question Detective Keyless on Defendant's Exhibit 3, which I will describe as, and it's been told to me that these are from Ashley Benefield's phone. And the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29th, 2016, and a last activity of April 19th, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29th, 2016 through December 3rd, 2016, and the page numbers are not sequential. That is, it's page numbers 1, 786, 222, I'm sorry, 222, 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly, State, I'm sure you have these as well, and may
Well, I guess one of the issues, Judge, is that we aren't being shown anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB text, but they're not all the same. There's some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to go over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. What happened yesterday?
You shouldn't be sandbagged. You're the prosecutor.
You don't want to. Thank you.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million
IA report, internal affairs reports from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense. And the original witness lists were filed in the late June.
that probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the defense has 15 days. So,
I can enlighten you, Honor.
all right, please.
They attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded. What we received in our discovery, among other things, was what we refer to as a phone dump, DUMP. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, searching. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed, but at the deposition, I clearly presented these to Sergeant Keyless, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
All right, final thoughts. I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little, please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It is disingenuous for this defense team to say they are using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we come to the point where there are things being offered for evidence that have never been provided to the state that I can't even find the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem that we're having. And the obligations are different, as Your Honor knows. And I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations are not the same.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. The state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substance of statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided. I haven't heard specifically. It may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Keyless's deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached in his deposition.
Judge, can I just clarify real quick? The defense did not provide us a phone number. We provided it to them. They listed it and said it's in our possession. So they did not provide us.
Okay, because they already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing, and that's also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent, I think I can't find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing.
All right, guys, does that make sense to you? I mean, the defense has been playing a little fast and loose here. This isn't like a super technical, difficult issue here. The state's crying and moaning. I don't know what I did to fix this Demon's Wrath. I literally didn't do anything that I hadn't done before. So like I said, I don't know what the fuck the issue is. So the idea, it's like, oh, it's this or that, or it's in your cards, or my drivers. I'm like, I literally heard everything fine. It's literally what happened between, like, once it leaves my computer and it gets to you guys. So it's something in the middle. Either StreamYard or YouTube or something. I don't know what it was. I have no idea because I didn't change anything. I didn't change any settings. I didn't fix anything. So I don't know.
All right, so,
If we could just request that be done before we're in the middle of examining.
and copies need to be shown to the state prior to showing them to a witness.
Of course.
All right,
This
so
is
let's
impeachment, then you don't have
get
to.
going on what we were talking about, that being Defense Exhibit 3. And we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes, court wants to take up now the admissibility as it relates to specific instances.
Of Exhibit 3.
Yes. Okay, so we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Ms. Benefield that could be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024, with a memorandum use of discovery depositions as substantive evidence of criminal trial. I also had previously filed on July 10th of 2024, a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was ordered new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case. September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a second district court of appeal decision found at 290 Southern 2nd, page 73, goes back to February 1974, Your Honor. What was particularly interesting about this case is the second PCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases, and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol, immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying, and the witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting a hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Can I hear the citation again?
And I might remind the court, in addition to that, Ms. Benefield had the scratches on her side and the swollen eye.
A very
Here is
compelling
the
argument.
Judge.
A very
Yeah.
compelling argument. So, guys, they're trying to make the argument that there is case law down in Florida that, based on what they can introduce so far, Ashley is allowed to make these arguments of self-defense, and those are pretty good arguments to have. So let's see what the court's going to allow.
Do you mind?
290 Southern 2nd, 73.
And I have one as well. I don't know if you want to hand it up now. I'll read it.
This is what you just handed up?
Yes.
All right, I've reviewed Henry.
You want to comment on Britain, case that they just provided?
I haven't read it yet. You can if you want. But I'll probably let them go first. All right, go ahead, Steve.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So we don't have, I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overt act, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britain case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before. And I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value. Considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge and the speculative nature of any real connection whatsoever as far as any apprehension in Britton's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I can tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So if you would object, I mean, at this point.
Sir?
We expect to call to testify a domestic violence expert. That domestic violence expert is going to educate the jury, that he should educate all of us, about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun, punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of a 4-year relationship, that is why the reaction of Ms. Benefield was appropriate. It was not unreasonable, given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. In the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse, and you begin to develop a survival instinct for it. So that's why you employ the get along, go along. You do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. That Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal was actually Benefield concerned about the release of the Broder report. Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions, some people call them spontaneous statements, and therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's an issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent and substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order. And this is, again, Smith, 606 Southern 2nd, 641, and this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course, we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident, which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing, 577 Southern 2nd, 682. And in that situation, the evidence was kept out and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence approved by preponderance, that she was lawfully justified in using force likely to cause death or great bodily harm or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420. And this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it. And I looked at Henry, I was reading Henry that the defense produced to see if it explained factually how the information came in regarding the hand in the pocket. And it doesn't say. It just says that the trial judge excluded evidence. And unfortunately, it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the
I guess you can ask, but I'm in the middle of a ruling.
Well, I think it may be relevant, helpful.
I think he's trying to side with the defense here. I don't know why you're going to interrupt, man. Like, he's kind of going your way. I like this. Why would you get in the way of it?
Okay.
The court's ruling. I think what the court is saying is looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay. So,
Right, and that's what I'm making my findings about.
yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us, would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 ball, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt. And in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue. So I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Oh, come on. Well, I haven't said this is the problem with, I guess I was wrong. This is the problem with judges. They're risk averse. Well, the Court of Appeals didn't say I could do it. Oh, no. It's like, make your decision. Make your decision. Be a judge. You know, cut it towards Ashley Benefield. She's the defendant after all. But they're like, I don't know. Oh, come on, man.
Just for the future, if in fact these WhatsApp messages do come in another way, we could also be asking for the rule of country against the rest of what was taken out of the iPad.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
So I just to put defense on notice that may be an issue.
So we're going to bring
Nice little snark.
the witness back in, and you can resume your cross.
So that the court doesn't run the jury in and out for naught. I've shown Suzanne the remaining aspect of my clause, anticipating there may be some objection to it.
And I would have an objection.
You do? Okay, can you step back out? Sure. Same rules.
Yeah,
You stand. The witness is out.
I'm trying to interpret this as fast as I can, but this, then maybe the defense can confirm. I believe these are supposed Google searches or internet searches for certain subjects.
Yes.
They're on-
Yes,
Is
they're
that
on
what's
the phone,
And
that of which was extracted by this witness.
they are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry,
2020, Your Honor.
the first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, with a parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent
Yes.
by Dr. Benefield, which says, "For the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord." Romans 6:23.
Yeah, that one was shown by the state. They just moved past it over quickly.
So, Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020. And the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Carruthers' report. A few months before the shooting, searching the internet for how to co-parent with an abuser. And then on 5/11/20, asked Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project. And 6 tips on 5/11/20 to help you co-parent with an abusive ex. So relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being once the 9/11 tape came in, which said my husband attacked me and I shot him together with the swollen eye and the scratches, as the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing a murderous.
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not now,
So
at this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted. Now I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have, in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. And I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response.
Judge, the reason this should not come in is the exact same reason that you just ruled on last session. There are other reasons, if it becomes relevant, if it becomes admissible, but that would be my reason.
Could I please see the exhibit?
Of course. Yeah.
purpose of offering Defense Exhibit 4A is to prove that Ms. Benefield actually made those searches.
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
So
Previously, I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I
yeah,
was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone, and the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. You still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay. So at this point, I'm going to rule that they're not admissible.
I have no further questions of Sergeant Keyless. I would like to make a proffer if I could for the record.
Of course, do you want me to call him back in for the proffer? Or are you just going to proffer?
No, yeah, I'm just going to read Defendant's Exhibit 2, or anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Keyless.
Judge, can we just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
If we could just make a copy and enter it.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, I didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I marked it as Exhibit 3, text messages, and it did not make it in.
Okay, yes. These are text from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer.
Correct.
Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes, composite.
State, for purposes of the proffer, do you believe that
Keyless.
Detective Keyless would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe he would. Judge, I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes, sir.
Do you want Keyless to stay under subpoena? Because I want to give him the right instructions.
Yes.
All right, can you have Detective Keyless come back in? I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it makes you feel better, it took us about 2 weeks to get it.
It just looks nothing like
so
that.
different. Yeah.
That's why I did it.
Sergeant, I'm sorry. Just right in front of me. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding
just so we understand, when he talks about these proffers, remember, they're introducing these exhibits, and her attorney's introducing these exhibits. The judge is not allowing in, but he wants them on the record so he can say, Judge, had we gone to, for the appellate courts to look at it and say, oh, here's the exhibit, here's what's going on, it was offered. It's in the record, so we can look at it. Should Ashley be convicted, they can appeal. So remember, these proffers can be very elaborate at times, getting everything in and making sure it's there. So, will this be a circus trial, Haven King? No. This is not at all that bad. This is very well run. This trial is probably going to be over Monday, guys.
Sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Oh, hold on. All right. Look, the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
Text message.
the what's now apps, WhatsApp messages. All right. That's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
It's a composite.
composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want,
Well, I'd like to have it on there because
Stip.
they showed it, but they
Yeah,
showed it very
Stip.
quickly.
Defendant Exhibit 5, which is
Sorry, yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in.
Thank you, Madam Clerk, for catching that.
Well, it's,
Right, 5 is in, 3 and 4 are proffers.
when you say, Your Honor, that Exhibit 5 is in, for purposes of proffer,
No, for evidence.
it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible. And
No, I'm ruling 5 is admissible. Because it was shown. State you showed it.
Right, it was shown.
So this is just a printout of,
Okay, but I think he hasn't, do you want it admitted?
the witness is gone.
So maybe 5 should just be with the composite number 4 and not entered, just give it as a proffer.
all right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I don't know what its status is then. All right. All right, Sadie, you ready to call your next witness?
Yes, sir.
Ready to bring the jury in?
Yes.
All right, let's bring him in.
I think we are going to use maybe just open the blinds, but.
Jury's coming back.
The state called.
They both texted Bible verses, guys.
You solemnly swear or affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth.
Yes, I do.
Hello, sir. I'm Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, and right as you need. Speak in a loud, clear voice. We should hear everything.
I will. Thank you, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the chief medical examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an Associate Medical Examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal
Yes,
experience.
please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a chief medical examiner, or at least, yes, as a chief medical examiner?
So as the chief medical examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. The percentage, you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And is wound... I'm going to draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. Vega, I'm showing you the pre-marked states 86 through.
Can I see the photographs, please?
Yes, the same as the one you just looked at.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
All right, so we're gonna see some of these medical examiner pictures are gonna be, well, we're not gonna see them, but apparently they're the dead guy. So it's like, oh, that looks bad. We'll see what they are though coming up. Did she shoot him with a rifle? Nope, a pistol. Well, who are those guys? I don't think those are important. The guy trained long enough and deserves to be bald, unlike lawyers. All right. So let's see what they're gonna. I'm sure there's gonna be a couple of pictures of them just laying there dead, which.
Well, she's going to put them back in order for me. While we do that, during your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length. That's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you. Sorry, Judge, bear with me.
Dr. Vega, we're gonna try this one more time. I'm gonna show you from 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Yes, I do recognize them.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you, Your Honor. At this time, I'd ask to enter states 86 through 97.
No objection.
Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them up here in just a moment.
Okay.
Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. Okay, then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. And the chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back. And it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's in pre-marked at states 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you can see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter States 14.
Objection.
Received.
And Doctor, I'm going to show you States 95. Is this the same projectile that you have there in States 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
And where would the exit would be?
Well, no exit, but
I'm sorry, the projectile.
projectile,
Yes, sir.
my mobility is a little limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn it back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
And you said that the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal.
Yes,
It wasn't front to back like it went straight through. Can you describe it?
certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
The vertebral body.
Thank you.
The
So
spine.
his spine.
Yes,
And would that injury have been immediately fatal?
probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes,
And how so? And this, for the record, states 91.
yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then you said he was also shot in the leg. Is that correct?
That's correct.
So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation-wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it. The calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different
And how so?
because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently, that defect in the skin is paralleled by defect in the tissues that one can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast-moving awl or punch, in that it goes in and it almost drills a hole into the skin. But when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically, the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And so, and I have a close-up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the direction, the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out. And that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
Thank you, Judge. So on me, the entrance was here
If it helps, I can put my finger there.
and the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left and then from back to front. Yes, largely all three of those components.
Thank you. Well, you know, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that maybe you
Sure.
don't understand.
Entrance. Logical.
Would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you States 15. You'll take a look at that and tell me if you recognize it.
Yes, I do.
And how you recognize it.
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter States 15.
No objection.
Received.
Thank you.
Okay,
And
so we
Dr.
got
Vega,
the
I have a
bullets in.
photo
I mean,
Of States, this is States 97.
this is like every time we can't watch
Is that
it. So
the same item that is in States 15?
Yes.
Thank you. Did you find any, I'm going to go back to the, well, Dr. Vega, what is
I
stippling?
get the feeling that's the case too, Matt.
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
The absence it reflects the same principle in either injury. And what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require, the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel and we're still talking about the leg injury, for this leg injury, but does it tell you this path of travel anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And Your Honor, may I have just one moment?
Yes.
Dr. Vega, if hypothetically Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell when you conduct an autopsy, and specifically in Mr. Benefield, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And was there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also, there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
You only have just 1 moment.
Yes.
I mean, it's an acceptable cause of death. Nothing he said, guys, is different. This is bog standard stuff. And yeah, the bullets killed him. And the neat thing is, remember, we're not claiming the bullets didn't kill him. We're claiming whether or not Ashley Benefield had the right to do it. So, yeah. Needle shot's hard to explain as defensive. Yes, I mean, he could say that. He could say that. Did she use hollow points? I think she used ball ammunition.
I don't have anything else, Dr. Vega. Thank you, the defense may.
Mr. Taylor Cross. And of course, the question is, do you need this?
I do not.
Yes, sir.
Afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice. Thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct. Yes.
Muscular build.
I don't think I use that terminology. I think I just talked about the weight and the body length.
I want to ask you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's
to
right.
cause more
The
damage.
theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt.
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3 foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection to it, beyond his expertise.
I'll allow if the witness has the knowledge to answer.
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay.
Well, there we go. That's
In simple
nice.
language, it could be excusable.
Objection closed for legal.
I'll sustain.
Justifiable? I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because that's asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr.
Mm.
Baker, that you could not determine the
Fair
order
enough.
of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the leg. You've told us that the gun would have had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term,
Yeah.
and legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Baker.
State any redirect?
Yes, Judge.
Dr. Vega, I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes. So the weapon did have to be in front of him, but even more so, it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're releasing your subpoena. You're free to go.
Thank you, Your Honor.
Oh, Judge, while we're switching to the deputy pass 14 and 15, would you mind?
Oh, the pass, you mean
Yes.
to the jury?
Sorry,
I wasn't quite sure what you meant.
sorry. I meant pass through the jury. Yes, sir.
Members of the jury, as of yesterday, we're going to pass these around. These will go back with you during your deliberations. All right, state, your next witness.
Daniel Houseworth.
Do you solemnly swear or affirm the testimony about to give the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
So, guys, I mean, we listened to him. Does anybody? I honestly don't think this has changed anyone's minds. I mean, there was nothing there that made me change my mind. There wasn't really anything we were not expecting. Unless there's something out there you guys think you caught, I don't see it. I mean, like I said, we already know she did it. This is really kind of filler until we get to the defense's case. I mean, that's how I've been looking at it, because this is, we all admit this happened. We all admit she did it. We all admit the bullets went in. So let's just see more.
My name is Judge White. I preside over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. I'd like to have you about 12 to 15 inches away from that microphone. It does adjust up, down, left, right as you need. And if you just speak in a loud, clear voice, it should pick up everything.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your
Yeah,
full
I
name?
mean, he's
Oh, I'm sorry.
Go ahead. You
Even
all
with
finish up?
that, he said the gun had to be in the front and the side. I don't think that completely restricts Ashley at this point, especially if she could show that Doug's such a loon. She might have acted before he engaged her, like she kind of preemptively used self-defense. I don't. Yeah, nothing here convicts Ashley. Nothing he said right there convicts her. That's all I'm saying when I look at this.
Wait a second.
Yeah, I apologize, Judge.
I don't want anybody to feel rushed. But like I said, everything will go back with you all during the deliberations.
Oh, it's awfully suspicious, but yeah. It's awfully
Understood.
suspicious,
Judge.
but I still think she's not guilty.
Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorf.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearm section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say cartridge, well, we're going to get there. I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearm section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August of 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but that an intact live round.
Yes, ma'am.
Okay, so use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as,
A projectile.
thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases from firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time.
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab, where it's given a unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I received from my supervisor when I'm assigned the case, and that has all the details of the case, and everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence, where the custody of all the evidence is being held at that time, and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's not open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FDLE case number, item number, and my initials in my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block, all are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
It's empty.
I'm going to say there's gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. Hausdorff,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then like the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm.
So, guys, just looking at this, I mean, this is exactly what a firearms examiner does. He's testing the gun for operability, and yeah, I'm sure this is going to be pretty quick overall. I mean, like if you look, he's only got a very short amount of time here, so.
But it's also going to cause the slide to move rearward. The fire cartridge case is going to extract and eject out the side. As the slide moves back, it's going to
Very
the firearm,
true.
and then we'll go back forward again.
Yeah, I mean,
pulling another
very
cartridge from the
true.
magazine and into the chamber
Round
of the
of
firearm.
honor.
Fired.
Thanks, sir.
I'm sorry.
Very true.
You put it from-
Although I'm not gonna lie, putting a zip tie in a gun still makes me twitch a little bit. That should be a cable locked device. That's asking for accidents to happen.
And the testimony that Mr. Hausdorff, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up a scenario.
And the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3 through. You take a look at state 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLA case number, item number, and my initials in my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just so
Yes,
we can
ma'am.
talk about that part?
Yes.
We're really going. And so you said you first look at test to test. And can you explain slowly
Yes,
how what you're looking for to compare those, to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you look at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, making like an ink stamp on the ground. It's the same stamp, depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10. And 14. Would you like to take a look at these items
Yes. Thank you.
and tell me if they're items that you've previously seen in your lab?
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLA item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullet as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact, so I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in 45 caliber class.
And that's the same caliber as the casings in the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
No, I think the first time you said fired in, and then you said fired from.
The reason I just say in is the cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical.
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FTLA case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that there was no value for microscopic comparison because it was too small and there was no individual characteristics to rifling seen.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we received. In this case, I received 1 t-shirt, and what I will do is I will visually, microscopically, and chemically test the t-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was able to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is States 2. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
And I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
Gunpowder.
gunpowder. Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment? I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross.
Very briefly, so Mr. Houseworth, your testimony here today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
No, sir. Thank you.
Can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're releasing your subpoena. You're free to go.
Thank you, Judge.
Thank you. State.
Your Honor, this time the state rests.
All right. Members of the jury, the state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics you've heard anything about. Don't speak with anybody else outside of the jury about this case at all. All right? Leave your notes. All right, you all can have a seat. All right, when I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day. I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, I want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the
Sorry, chat. Sorry. So we're going to get to this fun part now. It's going to be the motion for acquittal. The state has not proven it beyond a reasonable doubt, that no reasonable jury can infer or convict. Remember, the state's going to say, viewing the light of the evidence, light of the light favorable to the non-moving party. I mean, it's going to keep going. I mean, obviously, we know there's a day 4, so let's just keep going from there. But yeah, this is where we're at, guys. We've seen this a million times. This part's kind of, and like I said, guys, I'm trying not to say this is boring, but this is kind of like the part we've already been through. We've been through this part a bunch, and this isn't going to be, I think, a highly contested hearing here. But the sky is a neighborhood for £2 sterling. That King Sterling says, Mary Leakin, law blogger, long live Clyde Coin. Clyde. Clyde. Click, 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 click. Oh, he's got his bullpen. He's eating his bullpen. Never mind. Never mind, chat. He's busy. So, anyways, let's keep going here. But thank you for the support. So let's keep going here.
Colloquy that I go through. I'm looking back to my notes. We've still got the issue of Vicky Mechanic, trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss, the expert. Ferris. I don't know where I got Bliss.
He's a police
You
officer.
smushed them together.
Ah, okay. We've got that, and I have another Richardson issue. It just says 391 emails. Okay, Richardson emails. And then we also have the issue of Faith Brown. And she wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own
To impeach.
her own explanation for them, which would be inconsistent with the testimony Ms. Murphy gave.
Yeah. And there's one other matter.
Oh, all right.
In an effort to protect Ms. Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday. So I've already heard from Ms. Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay.
Whoa!
Well, I guess we'll eventually just kind of wait and see if her presence is obviated by
Yes, sir.
Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So
Wait, what? Wait, we filed for sanctions? Damn! Holy cow!
we're going to kind of give you all the option. If you want to, I can give you the break that I'm giving them. You all can talk about, do we want to do some more work tonight? How late do we want to stay? Do we want to get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when is Mr. Ferris going to be available?
I would anticipate when we decide to call them, they'll be available.
Okay. All
I
right.
think we could do the JA, Your Honor, and the other stuff. We could do the JA, and maybe if you want to do the discovery now, I certainly wouldn't mind breaking a little early. I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA. Okay. I just want to clarify.
Thank you.
Well, yeah, I think let's at least get that done this evening.
Yes, okay. That was going to be, I was trying to figure out if you meant JOA or JA.
Yeah, sorry. That's
So now-
that's the reason why breaking early probably would be good.
Right. So let me give you all a break.
Thank you.
Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early. We've got stuff to do, and then we can hit the ground running tomorrow morning. Just so you know, because it's in. As soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that, but I will have a hearing at 8:30 because I've got motion for release of uncharged offender, 33-day motion. I'll have to hear first thing if it hasn't been obviated by the filing of the information or a null pros. I don't know yet.
And that's scheduled for 8:30?
I said it for 8:30 tomorrow. I asked for it to be set for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
All right, chat. We're gonna give him a couple minutes here, and then. All right. So they're on a quick break here. Let's. Outside the jury presence, says OJP.
So
Yes, sir.
it's never easy, Your Honor.
Okay,
We
so
have a witness issue, Faith Brown.
no,
is-
Samaj, literally nothing literally happened just now. They were talking about how they had filed, there were some motions to quash subpoenas that the defense had served. And on top of that, someone has filed, it sounds like the state has filed for sanctions against the defense. And sanctions are you're demanding the court punish the other party, whether it's the defendant themselves, or in a civil case, the defendant or plaintiff themselves as people, or you want counsel punished for doing some sort of action that wasn't proper. They haven't gotten to the dismissal part yet, or the judgment of acquittal. They took a break, and now they're coming to that part where the state is going to say, in light of the, light most favorable to the non-moving party, Your Honor, we think there is a case here, and the defense is going to say there clearly isn't one. It sounds like there's a couple different issues they're going to argue about tonight. So, yeah, a lot sounded like, I guess they talked about a lot of things, but they just didn't do a lot of things. So here we go.
Now, she's not available tomorrow. She will not be a long witness. I wonder if the court would entertain, however Your Honor wants to do it, while we have the jury here, I can call her. Or case law even says the Supreme Court case of Stacey Smith, the court could call her as court witness. And when she's done, then we could do the JOA or we could do it in reverse.
I'm sorry, did you say she's here?
She may be outside now. She's on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't know about it.
Yeah, of course, I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented before, not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the state. That's the other subject of the
Yes, it
Richardson
is
hearing,
actually.
is those emails from the sealed hearing that we've now had access to. I think had to have been obtained by the defense from his Faith Brown, and because the state's never got those until yesterday.
What was the date, September 30th or 20?
And Judge, those emails came from the state.
You're gonna have to show me where, because
I don't
I
know.
looked in my.
Well, we don't need the back and forth. I'm trying to figure out.
I don't know how we got access to this.
Listen, this is for me, who typically is just, let's start the trial, let's go, let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about, we make tomorrow a work day, I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be an outstanding idea.
My first one of the trial.
No, that really would work out pretty well because I got witnesses like planes stacked and my head is spinning over it. So yeah, that would.
And just so you know, State, this is also what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was, I can't remember what the other one was, then you have the entire weekend to go through everything. And we kind of get reset, and then defense, you can come forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but what do you think?
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't remember, and maybe it was actual seated jurors, I don't remember.
No.
There were conflicts that started next week.
But I don't know if it's sure what they were. Started Monday or Wednesday or.
I think the juror that, the gentleman we had last today, he had a conference starting Monday out of town. Not that we can do tomorrow.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
Right, but does that mean finish Monday or finish Tuesday?
Oh,
Fine finish.
Definitely don't finish Monday.
All right, so defense case done Monday. And
Then
then
we
you,
close Tuesday.
and then
That'd be the-
I think that might be optimistic. I think Wednesday probably is more realistic.
right, so finish defense case Monday, but then we have jury instructions.
Right.
Oh, can't. I apologize, sir.
Okay.
So you expect to finish Tuesday?
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
Yes, I mean, you're correct in identifying that some of the jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
I think we still should be okay. I know for me, I had some scheduling issues at or around the 1st. So
Right.
we can try to finish the case up Tuesday, if not early Wednesday.
And Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I would make the final decision, but that would be my opinion, is to not go a full day without doing any trial. But
All right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information was filed, so I do not have the hearing at 8:30. But we can start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock, and then we start the defense's case in chief around 1. We go as far as we can. Okay?
Okay.
You're nodding your heads, but
yes, sorry.
Okay. All right, so if you could, let's bring the jury back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with the goal of having them up here around 1 o'clock.
So, I'm sorry, Judge. I'm wondering, where does that leave me with Faith Brown?
On Monday.
Well, she's not available tomorrow.
She's not. Is she available Monday? No, she's out.
I'd say maybe call her Monday.
Yeah, that'd be fine. I just want to make sure she's available.
Sure.
Yeah.
Right, or is she under subpoena?
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements for their witness, who they have listed, seems outrageous.
No, hold on.
Okay.
This is me, because I want to get these, I got a bunch of hearings that I got to get done,
Okay.
including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to.
Listen, it's our 5 minutes different for us, Judge. Wow. It's like, come on, man. Come on.
Get a deposition done. Did he step out to ask? What's he asking?
You want me to bring?
No, I just need to know, is that the plan?
Yeah.
So, because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we could put her on today, then
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her because I understand the reason why you need her. But I think the state, again, harkening back to that due process concept, they have a right to speak with her and take her deposition.
okay. Can you give me a moment?
Of course.
All right, guys, we're going to skip ahead here. Like, she's just sitting there like, what's going on? So,
Tomorrow at 9 o'clock. She's got a little window, so we're going to.
All right.
So we're going to do a motion this afternoon?
Yep.
Thank you.
And hopefully she's available for you to speak with her. Do you want to step out and make those arrangements now?
Yes.
But while you're doing that, can one of you stay?
Yes,
And I'm going to tell the jury 12:45
Yeah,
tomorrow?
let 'em go.
Well, no, wait a minute.
Right now, we could have them here in the morning.
Now I need them here in the morning.
Yes.
Okay, all right. Hold on. I just want to make sure she's going to be available. Because you guys have every right and should be able to speak with her about her expected testimony. Did that come up during your conversations?
It might come up, but I'm sure she'll talk to them, Judge.
Go ahead.
Well, Your Honor, I feel like a vacation has been snatched away from me.
The what?
I feel like a vacation has been snatched away from me. I was picturing having tomorrow off.
It's kind of a joke, but not a funny joke. Like that bomb. So. Let's keep moving along here, though, chat. So.
Yeah. Is she out there? Okay, Judge. It's never easy. We have a small complication. It's an issue that Your Honor's going to have to deal with. She was not under subpoena by either side, and was not told that because she was expected to be witness, that she could not observe the proceedings. So she has watched some of the proceedings. Once I contacted her, told her that we needed her, we told her to stop, and of course she's conformed to that. I don't know if that presents an issue, but I want to disclose that to the court, and Ms. Brown wanted me to as well.
Okay. You don't have to say anything now. I'm just, you're on notice. We're just waiting for her, Ms. O'Donnell, to come back in and confirm that we can get, you guys can speak with her tonight or tomorrow. Yeah, just I need to know that answer so then I can decide, I can let the jury go. Because if you can't speak with her tonight, that'll be a whole other issue. Or depose her in the morning, one or the other.
Okay, thank you.
So they are now, the prosecutors out there trying to set up a time to interview this witness. They, yes, Fleek, this is, they're just getting they're getting through the last little bit of their day here on day 3. And we're just going to get past them discharging the jury because there's nothing here to talk about. Now we get to the motion for acquittal.
JOA.
I have several bases upon which Ashley Benefield at this time, Your Honor, moves for a judgment of acquittal. To begin with, as the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit. For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 911. And 911, of course, is what you do to summon help.
I hate that. It's
there
a
has been
911 call.
Nothing indicated
they call 'em
otherwise that
911.
Ms. Benefield displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is he attacked me and I shot him. There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield. And if they were properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden. The self-defense context, Judge White, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child, together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintal, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th. The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this. 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact, where's there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir. State.
And just at the onset, I disagree with a lot of the defense's recitation of the facts as they've come out. I believe a lot of what he said, witnesses said, were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said the things that he said. But anyway, Judge, clearly the state has shown that this defendant killed Doug Benefield. She shot him 4 times. He died as a result of that. There is no dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind, regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there's also spite or evil intent. And that is disjunctive. So it's or. And ill will is a very low threshold, to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically abusing his 1-year-old daughter. And none of these were sustained. And she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time. And she's frustrated that nobody's helping her. I'll do whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints, and the state does call them false complaints, of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state had said that this was the same exact judge that she had not had luck with before, and implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times, and the entrance wound of the fatal wound is not front; it is side to side. So he was turned away from her, and then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away. And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that the defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA.
Thank you. Mr. Taylor, would you like to place any rebuttal on the record?
Very briefly, thank you.
Or not briefly?
Yep, no, briefly. So here's what we have according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance as to what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick. I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed, and failed miserably to rebut it. And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right. Thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
Okay. All right. I just want to make sure. So, again, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by preponderance of the evidence. I don't find support in the law for that. And I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think, based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal. You're going to see Ms. Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson. You're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
I might be mixing apples and oranges. Something was 390 and something was 316. And
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked, and he showed me the part that was missing. And based on that part missing, I will go back now and try to find it. So
was it a header or something?
Yes, it was the top of an
The
email.
auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said, I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. And with the heading forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is? 277. 277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies or at least clue me into where it is and what exact pages are intended to be entered. And that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that they're looking to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be
So
safe.
do you want to do it now?
Yes.
All right. So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified
But
something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So without verifying that, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth.
So-
And now,
Guys, the Richardson hearing is the issue that the evidence was not being there was no notice in time of this stuff. But notice he's arguing, look, how was I supposed to know we were going to be at this point? I don't think this is going to work. I don't think he's going to win.
We're in this position where the emails clearly demonstrate beyond any shadow of a doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony. That can't be right either. So we have to find a happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. Well, I'll tell the court candidly, I never actually expected to see it again on the way to stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said, on page 4, I have an envelope to seal this. If necessary, I have Ms. Murphy's stand your ground testimony that I'll pass to the
You
court.
might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking that was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at the stand your ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, were these turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing.
Did they really know?
The state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private. And although they said it was about the mechanic, they're the same emails. It's the same email chain. And so the state feels that it wasn't intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said,
oh, wow.
I don't think ultimately the Richardson.
I am very surprised he's actually doing this. He's saying they told you they had them. They just didn't say what they were going to do. And that's wow. Most judges are like, no, you need to tell them. So it's like, whoo, boy, that's interesting. That's interesting. That's interesting. Very interesting.
Framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Ms. Murphy and Ms. Brown as meaning different things? Could it be received by the jury to be substantial in their decision-making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. more so than these 12,000, these 12,000 or whatever the number was documents. We could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules. The final analysis is the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently, but just at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there was any prejudice. So
yes, and that's a very important thing here. Well, we didn't know you were going to use it, but you've had it. So that is I'm surprised he still is letting him use it. But yes, the state's screaming, well, this is unfair. It's like, you've had it the whole time. You've known about it the whole time. That's a good ruling.
That's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about Lake Brown because she was not listed.
Yes. Okay. Do you want to be heard on that?
We just have a minute. We're just
Of course.
discussing.
I'll be right back, guys. Hold on.
Judge, we've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that, along with these emails, that it feels a lot like sandbagging to the state, or trial by ambush, I think as your honor called it. And that was our concern. But in the light most favorable, in our minds, to the defense, we'll assume that they realized once that Ms. Mechanic going to be called, then they listed they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic would be called.
Now that you've had it, you don't have to respond. Now that you've seen my order that has been unsealed, I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing and calling of Ms. Brown.
Yeah.
So hold off on Mechanic subpoena for now. The argument about it.
Yes,
Okay,
I think so.
I'm just going to put that on the back burner for now.
I suspect that's going to be resolved.
The sky is a neighborhood. You're kind of bringing up a good point here. For £5 sterling, the King sterling. Yes, is the state being mad the defense didn't tell them what exactly they were going to use in this big phone dump? I mean, yeah, but I think it was very clear they explained what they were going to use out of that, the specific conversations from specific people. So, I could, like, generally speaking, I have to disclose, like, I'm going to use Bob Boberson's conversation with the defendant. Although it sounds like now, as he's saying, the one witness has committed perjury. So I'm going to challenge that. And here's how I'm going to challenge it. We're going to have to see it come out more, because I'm not sure what piece of evidence they're talking about specifically. But it will be interesting to look at here. But a very good question. So here we go.
We still have a few minutes. I would like to, at a minimum, read my colloquy to Ms. Benefield regarding defendant testifying. I typically will do this in a trial. I'll do it early on. I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
If it does, Your Honor, I would ask that you
Skip that?
respectfully.
Fair enough. No, let me look. I don't think it does. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions will be asked. It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs. You understand what you're doing. You're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended. I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart, and I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney. And this is just piling the pressure on the client. I'm sorry, Your Honor. I find it uncomfortable.
You would be heard for that. I mean, it's my
I
decision.
would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is.
Okay, I'm not going to say it's offensive, but yeah, guys, I've heard this a million times, and you guys have all heard this a million times now. This is a little weird.
It's not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes a decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
I've heard it this detailed before a couple times.
I guess when we get there, I'm going to tell you what I say. And if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me. So if you say, hey, don't answer that, okay. But I'm going to have it on the record because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify. My lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll make sure that nobody's threatened you, forced you, or coerced you to make this decision. That nobody's promised you anything, any benefit or a particular outcome to make this decision, that you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it. And if you decide not to answer any of those, that will certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it, and then we'll have that conversation either tomorrow or next week. All right, anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law to support my position. And I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right. Well, I think whenever you had approached me about this case that you gave me the other day ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course. Absolutely.
So she's going to talk to her. They're going to do their talk, and everybody's talking at me.
All right, Judge White, we're good. Request withdrawn.
Okay. All right. Anything else we can talk about today? No?
What time are we starting tomorrow? 9, you said 9?
On my list.
All right, guys. So this is the end of day 3. We're going to back out and go to day 4. Let's see. The TV of courts. We'll just keep using their feed. Live. So day 5 starts Monday, but we'll start day 4 right now, chat. You know, we closed up 5 or 6 hours. Am I going to reach out to that Florida attorney? Yeah, I will reach out to him after this trial's over. I'd love to hear from him. Day 4, chat. This is when it's going down. She does testify today. Let's see how this goes. So, let's see. Let's see. So they are on the record. They're not on the record yet. Why don't they just say static? Like,
Officer attorney testimony about to give.
all right.
For anything about it. We call Faith Brown.
Faith Brown. This is gonna be her. This is gonna be Ashley's defense attorney or family law attorney. Remember, you gotta have faith, chat.
Peace officer attorney testimony about to give the truth, the truth, and nothing but the truth.
Good morning, ma'am.
Good morning, Your Honor.
Comfortable in that chair. Pull yourself up to about 12 to 15 inches from the microphone. It does adjust where you need it. If you just need a loud, clear voice, it'll pick everything up.
Thank you, Your Honor.
All right, guys, if it starts dicking up, let me know. Like, I'm here to break up a little bit. We'll switch over to Court TV and Long Crime in a second, but let me know if this is tolerable.
Good morning.
Will you tell us your name, spell your last name for the court reporter?
Faith Brown, Brown.
Ms. Brown, are you employed?
Yes.
How?
Am an attorney.
And how long have you been practicing?
Not quite 20 years.
Do you have a specialty?
I practice exclusively family law.
And in your practice of family law, is email communications traditionally used on behalf of you and
On a day, yes.
okay. Do email communications, are they employed in correspondence with the various courts that you have matters pending in?
Yes.
Is the exchange directly with the judge or representative?
Representative.
And their title is what?
Judicial assistant. Or JA.
And these emails, Ms. Brown, are they ordinarily sent and received in the normal course of business for your firm?
Yes.
And are they kept under your care and custody?
Yes.
Are the emails preserved at or about the time that they are either received or sent?
Yes.
I'm going to pass to you, Ms. Brown, now, Your Honor.
Yes, ma'am. Yes, sir. Sorry.
I'm going to ask you what I want this defendant to give Exhibit 6 and ask you if you would take a moment and review that. Ashley Benefield.
I was.
In
Yes, I was.
and what case do the contents of Defendant's Exhibit 6 represent?
This was in reference to the petition for injunction for protection against domestic violence that I filed on behalf of Ashley Benefield and her daughter, Emerson County.
All right. Are those emails an accurate, true and accurate reproduction of the emails that you sent and received on that day or those days?
Yes, they are.
Your Honor, I move at this time to introduce that as defendant's exhibit number 6 into evidence.
Any objection?
No.
Received.
Thank you. That is a string of emails that covers a range of dates.
Yes, it is.
Would you tell the ladies and gentlemen of the jury, Ms. Brown, what date the first email starts on?
Sure. The first date was September 17th of 2020.
And when is the last email?
The last email is when I forwarded the email to my client, Ashley Benefield, on September 23rd, 2020 at 9:30 a.m. But are you referencing the last email between the three of us in the email?
My next question indeed is, would you be kind enough to tell the ladies and gentlemen of the jury, who were the participants in this string of emails?
The participants in the stream of emails was Vicki Mechanic, who was the judicial assistant to Judge Diana Moreland, who was the judge presiding over this matter, Stephanie Murphy, who was representing Douglas Benefield, and myself.
And it's normal and customary, is it not, to the extent Ms. Murphy were representing the adverse party, that you would share all correspondence with between you and the judicial assistant?
Yes, it was a requirement.
Okay. Do you recall, having reviewed the email, was there a particular issue in play?
Yes.
What was it?
Initially, we were trying to stipulate to the release of Dr. Brad Broder's report.
And were you attempting to secure a date to do that?
Yes, we were. Well, eventually.
Okay. So I have some very specific questions for you. First, would you tell us whether or not, based on that correspondence, Dr. Broder's report was set for release on September 30th, 2020?
It was not.
In fact, based on those emails between you, Stephanie Murphy, and Judge Moreland's JA, was there even a date that existed at that time for the release of Dr. Broder's report?
There was not.
If somebody testified that the release of Dr. Broder's report was set for September 30th, that'd be accurate.
Oh, sustained.
Would you take a moment, if you don't mind, and read the emails?
Sure. Did you want me to read them out loud or to myself?
Yes, read them out loud and start with the string in chronological order. It covers a 6-day period. 17th to the 23rd.
The 17th to the 23rd, yes. The first email was on September 17th of 2020. It was a Thursday from Attorney Stephanie Murphy to Family Division 4, which was the judicial assistant's email address. I was on it, as well as my paralegal's email address, Sarah Hawk at myflfamilies.com, and Dr. Brad Broder. It states, "Good afternoon, Vicki. I hope you are doing well and have had a good week. Please see the attached joint motion for release of psychological evaluation and report and correspondence regarding same with regard to the above referenced case. Thank you, Stephanie." Shortly thereafter, same day, the judicial assistant responded, "Thank you. Can one of you kindly prepare a proposed order in case the judge wishes to grant your motion?" About 30 minutes later, Ms. Murphy responded, "Thank you, Vicki. I will work on that right now and send it to Ms. Brown for her approval." The next morning, Friday, 8 a.m., we received a response from the judicial assistant.
Okay, I'm muted. Thank you. If you're looking about the crying happened during the text messages, not the she's not going to cry during the emails. The text messages are when Ashley cried between her and Doug.
Marked importance high that stated, "Good morning, Ms. Murphy and Ms. Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation and report. The judge will allow an expedited motion hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. Broder and Manatee Children's Services must be present at the hearing as well, and must be present at the hearing as well," is underlined. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only, and only is underlined, matter being heard on September 30th day is the injunction hearing. And then the next sentence underlined. Please advise whether Wednesday, September 23rd will work for all parties. Thank you, Vicky Mechanic, Judicial Assistant to Judge Moreland. A few minutes later, Attorney Murphy responded with an email that said, "Thank you so much for all of this information, Vicky. I admit that I did not go back to check what is scheduled for that hearing, so please accept my apology. In my mind, these cases have always overlapped so much that I just took it for granted that the upcoming is just the DVI. I am available for that hearing. I will contact Dr. Broder, and we are trying to track down the correct attorney who represents Manatee County. This represents Sarasota only." The next email was actually assistant at the admin email address, my calendar, September 18th a.m., where she stated, "Ms. Brown is available at 9 a.m. However, she has mediation starting at 9:30. The next email was about 2 minutes later from the JA, stating, if this goes forward on the 23rd, it shall be via Zoom." Then at 2:09 p.m., Attorney Murphy emailed, "Good afternoon, Vicky. Ms. Brown and I are both available next Wednesday at 9 a.m. on Zoom. Dr. Broder is not available as he is out of town on an anniversary vacation with his wife. I've called into 3 different people from, Manatee Children's Legal Services, including the DCF regional headquarters, to find out who needs to be included from the organization in the hearing. We have been directed and redirected to the wrong people several times. Can we go ahead and set the hearing?" The next email was about 15 minutes later from the JA, stating, "Good afternoon. No, per my email this morning, the judge stated that Dr. Broder must be present at the hearing. Vicky." So that was Friday, the 18th. The next email was Tuesday, September 22nd at 2:20 from Stephanie Murphy, where she wrote, "Good afternoon, Vicky. Dr. Broder never got back to me regarding whether he could appear at the hearing, even by audio only, while he is on vacation. So I wanted to let you know that per your prior emails, we cannot have the hearing tomorrow morning. When Dr. Broder did speak with Attorney Faith Brown on Friday, he told her that returning Wednesday night. Is there any chance that Judge Moreland could schedule the hearing for Thursday? We will be in mediation in this case, but we can take a break to do the Zoom hearing."
And what is the JA, Ms. Mechanic's response to that request?
Unfortunately, no. The judge has a full docket on Thursday, and even if she didn't, Manatee Children's Services would need to be present as well.
All right.
That was Tuesday, September 22nd. So then on Wednesday, September 23rd at 1:02 p.m., Ms. Murphy, Attorney Murphy, wrote, "Good afternoon, Vicky. I've spoken with Attorney Kimberly Griffin, who represents CPS, and who confirmed that she is the attorney who will need to be present for the hearing per Judge Moreland's instructions. Now that we know who the hearing needs to be coordinated with and Dr. Broder is returning tonight, can you please forward additional hearing dates and times for this matter?" To which the judicial assistant responded about 30 minutes later, 25 minutes later. "Unfortunately, there's no availability before the injunction date of the 30th.
All right. Was there anything unclear about the fact that the only thing being heard on September 30th, 2020 was the injunction?
No.
Was there any chance, under any circumstances, Dr. Broder's report was going to be released on September 30th, 2020?
No.
I don't believe I have anything further, Your Honor.
Cross?
Yes. I just went through these emails along with you, and you say it's very clear that the release of it was not going to be heard on the 30th. In reading this, it's hard to get that because the last email says, unfortunately, there's no availability before the injunction date of the 30th. But it all means if the attorney got the doctor and the appropriate people present, that it maybe could be heard on that date, correct?
No.
Okay. So it was your understanding it was not going to happen.
Correct.
All right. What was your understanding of what was going to happen on that date, on the 30th?
The injunction for protection against domestic violence hearing was going to be held that afternoon.
Okay. So you were going to call witnesses. You were prepared to call witnesses?
Yes.
Okay. And have a full hearing on Ashley Benefield's motion to get an injunction against Doug Benefield. What?
I'll overrule.
I didn't.
I'm sorry, can you repeat the question?
So the hearing on 9:30 was, in your opinion, only to hear the motion to get an injunction that was filed by Ashley Benefield against Doug Benefield. And that was the only thing to be heard on that day.
Correct.
Okay. And through that previously, you had agreed to drop that injunction?
It's sustained.
No further questions.
That's all, just a request to publish the email.
Absolutely. By passing. Can this witness be released?
Yes.
And can the witness be released?
Yes, sir.
Ma'am, you're releasing your subpoena. You're free to go.
Thank you, Your Honor.
Thank you. No,
so sorry.
pass it around.
Thank you.
Well, that was quick. That was quick. Yes, unlike the other attorney, she was straight facts. No screwing around. No being snippy and catty. This lady was about business. So here we go. We're just waiting, chat. What are we waiting for? We're waiting just to suffer. Now they're coming up to the bench. And they're talking about a chat. We've got a whole long block of time here. We've got almost 3.5 hours of stuff going down, chat. Here we go. We're almost coming up to the main event.
Down, left, right. This is just defendant. All right, the jury is completed.
All right, chat, here we go. It's game time. Here we go. Ashley's taking the stand. Let's go.
The review of Defendant's Exhibit 6. Mr. Taylor, your next witness.
Yes, sir. The defense calls actual Benefield.
Ms. Thomas, bear affirm testimony about to give you the truth, the whole truth, and the truth.
As you've heard me tell other witnesses, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. And if you speak in a loud, clear voice, the electronics will pick up everything.
Okay.
Here we go.
Mr. Taylor.
Here we go,
Good morning.
chat.
Will you tell us your full name and spell your last name, please?
Ashley Christina Benefield, Benefield.
How are you feeling this morning, Ashley?
Nervous.
Try best you can, relax, and we'll get through this.
Okay.
Tell us a little bit, Ashley, about where you were born and raised.
I was born in Corpus Christi, Texas, and I grew up in Annapolis, Maryland.
What type of family values were instilled in you?
Objection, relevant.
Oh,
I believe in the importance of kindness and compassion, and hard work, accountability.
What type of work did your father do?
My
Objection, relevant.
I'll allow it.
Allow it. This is not.
my dad
Come
was
on.
a Naval Academy graduate who was a Navy pilot, and then started flying privately for the airlines, which is what he still does.
And how about your mom?
When I was born, my parents decided that my mom would stay home to take care of me full time since my dad traveled so much.
I want to ask you a few questions about your childhood. Did you have any siblings?
I grew up an only child.
Were your parents active in your development as a child?
Yes, they were very active in my schooling and supportive of my pursuit of the arts.
Yeah, hold on one second. I'm sorry. We need some headsets. How many?
Speaks very
Oh,
quietly.
I'm sorry.
so-
I apologize. I misunderstood. All right, Ms. Benefield, yeah, if you could scoot a little bit closer and speak up so the jury can hear you.
Okay, I'm sorry.
Do the best.
I apologize. Go ahead, sir.
Sure, do the best you can, Ashley.
Okay.
Do you have any hobbies?
I love art. I like drawing, painting, sculpting, ballet. I enjoy gardening, baking, cooking. Most importantly, I'm a mom.
What high school did you attend?
I'm going to sustain at this point.
Um,
I'm trying to establish her ballet, Your Honor.
If it's related to something specific, then yes.
Sir. Thank you. Tell us about your high school, Ashley.
I went to a small private Christian school.
And did you study anything in particular in high school?
I was focused on pursuing ballet.
And was ballet a large part of your curriculum when you were in high school?
Yes, I danced full time. I actually finished my last few credits my senior year with an homeschool program for athletes, so I could dance during the day.
Do you still dance professionally?
No.
Why not?
I retired after I tore my hamstring.
I want to ask you about Doug. When did the two of you meet?
We met August 25th of 2016.
And tell us what your impression of him was when you met.
He was very confident in who he was, passionate about what he was doing for work. He was fascinating to talk to.
What was it, if you recall in particular, that attracted him, Ashley?
He was funny, very smart, charming. We just instantly clicked.
Was Doug in the military?
Yes, just like my dad, he was in naval aviation.
Did he turn out to be who you thought he was?
No, not at all.
I want to direct your attention, Ashley, now, if I can, to the day of the homicide, September 27, 2020.
Okay.
Specifically, late in the afternoon. Would you tell us why Doug was at your home?
He came over to help load some of the larger items that my mom and I had kind of pre-staged in the garage into the U-Haul truck.
And were there any discussions between the two of you about the order that these things should be placed in the back of the truck?
Yes, we had discussed that my things would be going in last, right at the front, so they would be easy to get out first. At one point, he had me help him load one of the larger pieces into the back of the U-Haul truck. And when I was up in the truck with him, I realized that everything had been all like mixed together and it was no longer separated. And I pointed that out to him, and he got really offended and upset. He said, "It shouldn't be your stuff, my stuff, your house, my house."
Was there a particular demand he made at that time?
He said, "I needed to start acting like a wife."
Tell us at that point how you chose to deal with him.
I tried to change the subject. I could see how upset he was getting. So I wanted to kind of alleviate that.
And how was Doug reacting to your efforts to do that?
He was getting more upset and aggressive and threatening.
Do you attempt to avoid confrontation with him?
Yes.
What do you do?
I was trying to get him to leave. I kept suggesting that maybe we should be done, saying I was tired. We should just wrap it up for the day.
And what was Doug's reaction to that effort?
He heard me, but he completely disregarded what I was saying.
Ashley, would you tell us if there came a time shortly thereafter where there was physical contact between the two of you?
Yes.
Tell us about it.
We were in the living room, and as he came up to me, instead of walking past me, he walked like right into me, like a body check. He like bumped me.
His shoulder to your shoulder?
Yes.
And describe for us, if you can, the force of the bump.
It caught me off guard. I almost fell. I like stumbled.
How was he acting at that point?
He was clearly hostile. He was mumbling under his breath and was glaring at me.
What was your concern?
I could see that it was escalating, and I didn't want him to blow up at me.
Was there a second instance of physical contact?
Yes.
Tell us about that, please.
We were in the garage, and it was very much like the living room. I had just suggested strongly that I wanted to be done for the day, and he, as he came up to me, he walked right into me. Again, body checked me.
Finally, was there a third instance of contact?
Yes.
What happened?
We were in the hallway, and we were coming opposite directions towards each other, and he had a box. And as he walked up to me, he looked me in the eye, and he drove the corner of the box up into me.
Where?
My side.
Indicating on your right side?
Yes, sir.
In the hip area?
Yes, sir.
What was the result of that?
Scratching. It burned.
Moment, Your Honor.
Yes, sir.
Actually, I'm going to hand you what's been marked as defense exhibit numbers 8, 9, and 10. Approach.
Just do me a favor, whenever you're holding them up, they were facing the jury until they're admitted.
Sorry.
Yes, sir. Thank you very much. 8, 9, and 10.
Yes, sir. Will you tell us what exhibit 8 represents, Ashley?
It's a scratch, right here.
And was that scratch caused by the cardboard box that you just related?
Yes, sir.
When was that photograph taken?
The night of September 27th, 2020 at the sheriff's office.
Okay, and how about exhibit number 9?
Also scratches, on my side.
From the same incident?
Yes, sir.
Also taken that evening at the sheriff's office?
Yes, sir.
Okay, and exhibit 10?
The same scratches as in 9. They're just, it's a close-up.
Do these photographs actually truly and accurately reflect the scratches and bruises you received on late that afternoon on September 27, 2020?
Yes.
Do they accurately reflect how the scratches looked when they were fresh?
Yes.
Thank you. I move respectfully, Your Honor, defense exhibits 8, 9, and 10 into evidence.
Any objection?
No.
They'll be received.
What was your response, Ashley, after being struck by the cardboard box?
I apologized
Why would you have apologized?
because I could see how upset he was, and I didn't want him to get more mad at me.
Doug go after that incident?
He continued to the garage with the box.
And what happens at that point?
We started getting into a back and forth about being done for the day and what still needed to be packed and that I wanted to be done. And we ended up in our daughter's bedroom, and he started screaming at me. He said, "Shut the fuck up." He started calling me names. And he said, "I can see what you're doing. You're trying to get me to leave." He said, "I don't have to leave. I can stay and spend the night if I want to because I'm your husband."
At that point, Ashley, how did you feel with respect to your own personal safety?
I was scared.
Did you take any steps to try to avoid anything further?
Yes, I ran to try to leave the house
And where did you run to?
to the front door.
Did you make it?
No,
Tell us what happened.
he stopped me. He grabbed me by the hand and he yanked me back. I'm not really sure how he did it, but he spun around so he was in front of me, between me and the door.
So
He said,
I'm sorry, go ahead.
"Where the fuck do you think you're going?"
What was your response? Do you specifically recall? Tell us.
I just blurted it out. I said, "I'm done and you need to leave now."
What was Doug's reaction to that command to leave now?
He said, "You can't fucking leave me."
Then what happens?
He hit me on the side of the head.
Actually, I'm going to. It's been marked as defendant's exhibit number 7. Tell us what that represents.
It's a picture of my face.
Is it an accurate picture of what your face looked like on that night?
Yes, sir.
Who took that photograph?
I don't remember her name. She was at the sheriff's office.
At the sheriff's office? Okay. Now, what is it about that photograph that shows or reflects the slap or the hit that you got to the side of your head by Doug?
That side of my face is swollen, and puffy, and discolored around my eye.
And is your eyelid drooping
Yes,
on the side where you were hit?
yes.
Your Honor, I move defense exhibit number 7 into evidence.
Received.
What was different at that moment, Ashley, than at any time in your prior relationship with Doug?
He had never actually hit me before.
What did you do?
I ran
Where?
to my room
Why?
because I was scared.
Ashley, did you have anything in your room that could protect you?
I had my gun.
Did you grab the gun?
Yes,
As you're grabbing the gun, what, if anything, did you hear?
I heard the door hitting the doorstop.
As if it open?
Yes.
And what do you see, Ashley, when you look up?
Doug was standing in the doorway. His face was red. Like the veins were bulging in his neck. The way he was looking at me, it didn't even look like Doug. His eyes were.
Do you yell anything at you?
He said, "You're fucking done."
And what does he do at that point?
I held the gun like in front of me, and I said, "Stop." And he like turned and he got into this like, it was like a fighting stance. He like, I got low, and he started like moving his arms and his hands around. He was making these like jerking motions.
What were you expecting when you were holding the gun out in front of you and you told him to stop?
I thought when he saw it, he would leave.
Did he?
No.
At that point, Ashley, what are you thinking?
I thought he was gonna kill me.
Tell us what happens next.
He started coming towards me, and then he lunged at me, and I started pulling the trigger. And he just kept coming, and I remember trying to move to get away from him, but he kept coming at me.
Ashley, would you tell us why, if you're holding a loaded firearm, you were attempting to move away?
I was trying to get away from him. I was terrified.
All right, so you're firing. He keeps advancing. What happens next?
It was like his feet slipped out from under him and his legs went up in the air.
When Doug hits the floor, what's your immediate reaction?
I ran to get help.
Can you tell us how many shots you fired?
I have no idea. I was in a panic.
Do you remember anything about the shooting beyond what you've told us here?
It was a blur.
Where did you run for help, Ashley?
To my neighbor's house.
What's your neighbor's name?
John Sant.
Ashley, I have to ask you a couple of very difficult questions. You okay?
Yeah, sorry.
Well, Chad, I mean, this is an interesting one. Remember, they're getting down and dirty right into the shooting. What do you guys think? I don't know what she's putting on. She's putting on for the jury. She's doing a good job.
Ashley, tell the ladies and gentlemen of the jury why you shot Doug.
I was scared to death. I thought he was going to kill me. There was nowhere to go. I was trapped. In my own house, he wouldn't let me leave.
As you sit here today, Ashley, how do you feel about what happened?
Horrible. He's my child. Somebody, you have to explain it all to her.
Judge, I wonder, could we have a minute, maybe a brief recess, let have her compose herself?
All right. Members of the jury, if you can step out for a couple of minutes, we'll bring you right back. Just leave your notes where they are. You put them face down. Please don't begin your deliberations. You can use your phones, but don't talk with anybody outside the jury about the case. Don't do any research on the people, places, things we're going to talk anything about. Thank you.
I would be asking
All right, you all
for a
can have a
brief
seat.
recess.
Ms. Benefield, you can have a seat.
I'd be asking for this. This is not abnormal. Guys, remember, you might not believe, but remember, Kyle Rittenhouse needed a minute too. So, just saying out there, chat. Be like, I love this. Part of me though, she's peddling those shirts. I hope Ashley gets acquitted. That way, she can really only get that shirt.
Ma'am, there's Kleenexes here next to you. Right? Yes. All right, let's go to the jury.
Now remember, the jury's going to go to the bathroom and do their own thing for a minute or two, so they get a minute.
So the jurors are finished with their break. let's, well, it's 9:56. Let's say at 10:05 we'll reconvene.
All right.
Anyone at all during your testimony, do you understand? So you can step down and use the facilities, that's just fine, but you cannot communicate even with your attorney.
And that's true. She can't even speak to her attorney. He can just say, you're doing a good job. Like, all he could say is just keep doing it. Keep testifying. He said, just keep telling the truth. That's all he can tell her.
While you're testifying, all right?
You know what? If that's fake, she's doing a good job. And that's just a testament to how good y'all women are. She could do that.
Been with her.
Yes.
There we
Can
go.
anybody begin to do any research on the
There
people,
we
places,
go.
things, or legal topics or anything
There we
about?
go.
Everybody says no. Taylor, you can resume your direct examination.
Thank you, Judge White. Ashley, would you tell us where the pistol was in your bedroom?
It was in a storage bin. It was on top of my laundry basket.
Yeah,
Will you
I am.
describe the storage bin?
It was like a square bin with hard sides and cloth covering the sides.
Do you remember how old Emerson, your child, was at the time of this incident?
About 2.
Was Emerson able to access that storage bin?
No,
Whose firearm was
mine.
it? Did you have a license?
Yes, sir.
I'm going to show you, Ashley, what's previously been marked as Defendant's Exhibit Number 2. And Your Honor, I'd like to, if I could, put that up on the screen. Could we?
Are you from the Elmo?
For the blinds?
Oh, sure. Then what set of lights?
Thank you, Deputy. Ashley, take a look at the picture on your concealed firearm license. And in particular, are we able to zoom in on the portrait, the picture? Yeah. Ashley, do your eyelids look the same in that picture?
Yes, sir.
Do they look different in the picture that we admitted after you were slapped?
Yes, sir.
Let's put the, you see, now, let's put Defendant's Exhibit Number 7 up on the screen. Ashley, what side of your face did he hit you on?
The left side.
The left
The left side.
And as we're looking at this picture, it would be to the right.
Correct.
Is your eyelid on the right side the same as your eyelid on the left side?
No, sir.
And how about your eyebrow? The space between your eyebrow and your eyelid on the right side the same as the space between your eyebrow and your eyelid on the other side?
No, sir.
All right, thank you, Judge. I think we can lift the blinds. Was the firearm registered to you, Ashley?
Yes.
I'd like to now direct your attention back to your initial introduction to Doug. How long was it before Doug expressed his devotion to you?
It was about 4 days after we met that he told me he loved me.
Did any significant event follow after he expressed his love for you?
He flew me to South Carolina, where he was living at the time, and asked me to marry him, and I said yes.
Do you remember the date?
September 7th, 2016.
How old was he at the time on September 7th, 2016?
54,
And how old were you?
24.
When you finally moved in together, what was it like?
It was challenging. Doug hadn't told his daughter Eva that we had gotten married, and so when she found out, she was really upset. Just understandable. Our mom had suddenly passed 8 or 9 months before, and I was a complete stranger to her, and I'm moving into her house.
At that point in your relationship, Ashley, describe for us the man you thought you'd met.
100%. This is the underlying issue. They're both lunatics. They're both lunatics.
Married.
He was very loving and attentive. He was always with me. We did everything together. We laughed a lot. And he made me feel very special and loved. He always was looking for ways to be with me and to do things for me.
Was there a short time after that that you were separated?
Yes, sir.
And what was the reason?
Before I had planned a trip, and so I went on my trip. It was a cruise with my mom and one of my girlfriends.
Were you able to communicate with Doug while you were on the cruise?
Yes, sir.
How?
We mostly messaged each other.
I'm going to pass to you what's been marked as Defendant's Exhibit number 3, I believe, for identification.
No, wait, I'm sorry. Oh, the ones that need to get fired.
Yes, sir.
Take a minute and go through those, and I'm going to ask you about them.
Okay. Do you want me to read all of them, or? Yeah,
Go
okay.
through all of them. And then I'm going to ask you some questions about it.
Okay.
Looking through them, your life depends on it.
A true and accurate review of the messages you received from Doug Bennett.
Yes.
At this time, I would move Defense Exhibit number 3 into evidence.
Objection?
Yeah. All right. We're going to approach. Let's roll through this chat. She knew he did not have any money when this happened. Oh, okay. Apply the sacred unguents. All right, guys, hold on here. We're going to.
Introduce Defense Exhibit number 3.
Any additional objections?
Oh, I'm sorry, not other than what we discussed.
Admitted, subject to what we discussed at the bench.
Ashley, in this Exhibit number 3, who's represented in blue and who's represented in green?
I take a look again. I'm blue and Doug is green.
You're blue and Doug is green.
Yes, sir.
I want to ask what you thought and how you felt after this text message where he said to you, then respond. Like always being armed. And understanding them and how to conduct warfare in them for the kingdom. If I dwelt on it, I would go into a rage to remove them from the earth. I desire to exterminate them, and holding back is a challenge. They are rats that should be removed. Last night, just the jerks arguing near you about put me in sheer murderous mood, but I was stuck. I couldn't defend you. But could have been a fight, etc. Only you being with me will over time remove the images in my head. It is same, and knowing you were taken advantage of still in my mind makes me explode with anger to take them out. God made you for me. You haven't seen the war side and never want to. We went from joy and passion to now I'm in a testosterone rage inside. But kill the bad people. How long had you been married when you received these texts from Doug?
I believe it was about like a month or so. Probably thereabouts.
Do you recall approximately how long you had been married?
Well, we got married in the beginning of September, and this would have been the end of November.
Okay.
So more than that, I'm sorry.
What did you think? Was there anything about those texts that caused you to pause?
You know, at the time, I kind of tried to write it off that it was my new husband, and he was just trying to be kind of manly and, you know, be protective, and, you know, was trying to show that he really loved me. I think that was kind of what I
Did you
thought
think
at
it
the
was
time.
flattering?
Yeah.
Ashley, how long did this facade that you've described of Doug's last?
Probably about 3 months.
And what signs that he was not who you thought he was?
Oh, when I got back from the cruise, he's very, like, controlling and possessive. He started criticizing everything about me, like the way I would wear my hair or did my makeup or the way I dressed. I found about me to make him happy.
Did you pinpoint a specific incident, Ashley, early on that stands out to you? What would that be?
A friend of his had come to visit. We went out to dinner with him, and when we went to leave, Doug had had all too much to drink, and so I said that I would drive home, and he instantly got really mad at me. He was offended. He started screaming at me, and it continued all the way home. And when we got inside, I told him that he was drunk and he just needed to go to bed, and that really set him off. And he
go to bed.
tried to flip over the dining room table. He threw a chair at me. He kept screaming at me until he stopped, and then he apologized, and he said it would never happen again. He said he was really sorry.
And Ashley, did it happen again?
Yes.
Explain what happened.
We had gone to church one Sunday, and after service, after everyone was leaving, we talked to the pastor in the lobby area in front. And at one point, Doug stormed off, and by the time I caught up with him, I was in the parking lot, and he started cussing at me, calling me names. And when we got in the truck, he accused me of having a thing for the pastor, and he said I was a slut and a whore, and he screamed at me all the way home.
Are you?
Ashley, was he aggressive and threatening like that in other instances?
It started happening more and more with me and with our animals. He would hurt our pets.
On approximately how many occasions was he cruel to your pets?
A handful.
How would Doug react following a dark episode?
Well, he was either really up or really down. And after, he'd be very, very sick, and he'd be kind, and things would be good. And it was kind of like a flip of a switch, and something would set him off again.
Anything one day, Ashley, that gave you insight into Doug's marriage to his previous wife, Renee?
Yes, sir.
Tell us what it was.
I had been kind of cleaning and organizing, and I was going through a bunch of old devices and I found a texting conversation between Doug and Renee, his previous wife.
Let me pass to you, Ashley, what we've marked as defendant's exhibit number 11. Can you identify that, Ashley?
This is part of the texting conversation. This is a text from Renee Benefield to Doug.
Is that a true and accurate copy of what you came across that day that you just related to us?
Yes, sir.
At this point, I'd like to move that into evidence as defense exhibit number 11.
No objection.
Proceed.
I'm going to read it to you. Let me know if it's accurate.
Okay.
I was deeply disappointed that you distorted the truth about who you really were when I married you. I loved you, though finding out you weren't really what you pretended to be. You kicking me so hard on New Year's Eve on our honeymoon because you were having functioning in certain areas. You hold on to your head twice in my home that I opened to you with my children that still love you. Having to sell everything down to my wedding ring.
What the hell is
Finding
he
out
talking
you
about?
were on Viagra, which all of you had to do was tell me, you know I wouldn't care. Trying to film us making love on our honeymoon. Finding out that you wore eye pencil on and on. I loved you so much I didn't care. That's why I was shocked to think you would take pictures of me without asking. Is that accurate?
Yes.
Tell us, Ashley, how Doug would act when he would go off.
He would call it a fit of rage. Sometimes it was as simple as him just yelling and screaming at me or cussing at me, calling me names. Other times he would throw things or break things or smash things. He would come at me like he was going to hit me. He told me I was lucky that he punched walls instead of me.
Are there
That's
any
why I text-
incidences
I
in
don't-
particular, Ashley, that stand out to you?
I don't get what you mean. That
Yes.
doesn't make any sense.
Oh.
Hold on. That's not clear.
We were having an argument, and he came at me like he was going to hit me. And our dog, Sully, jumped up in between us. He was so hard that he knocked us. I just remember screaming because I thought he had killed him.
Were there other times that Doug hurt the animals?
Yes, he had kicked, punched Sully. He threw our cat. Sometime he threw Snuffy down the stairs.
What kind of impact did this behavior have on you?
I was always walking on eggshells, trying to do the right things. Because if I said the wrong thing, he would get mad at me. And so I always tried to do it right. If I wore the wrong thing, he would call me a whore or a slut. I feel like I couldn't do anything right.
Was there an incident, Ashley, in June of 2007?
He did admit, guys, yes, he did admit in text to being abusive to the animals. So there are things she can kind of roundaboutly corroborate. And I think that's what you mean. Look, you were saying the text to his ex-wife or his dead wife's text, but he did text to people that I did this shit. So
17.
like I said, Luke, I'm still not sure what you're talking about, the dead wife text something thing.
You vividly recall.
Yes.
Please explain it.
We were having an argument, and it started getting really out of hand. And he pulled a gun out, and he was like waving it around, and then he threw it at me, and it hit the wall behind me, punched a hole in the wall. And I went to run the trigger. He pulled the gun out and held it to his head. He said that he's fucking brains out, and I was gonna have to watch him. And he pulled the trigger and he shot a hole in the ceiling in the kitchen.
Ashley, at that point, what were you thinking of marriage?
he wasn't anything like I thought he was. I feel like I'd made a really big mistake marrying him. It was like I was just living in this nightmare. I never knew what I was going to get.
Did there come a time in July or August of 2017 when you found yourself with child?
Yes.
So let's be clear here chronologically. You became pregnant
Sounds like-
after this incident where you related that he shot the gun in the ceiling of the kitchen?
Yes, it would have been like right after that, I guess.
Was it planned?
No, it's the last thing on my mind at that point.
How would you deal with Doug?
I tried to do all the right things and keep him happy. Kind of just go with the flow. I didn't want to rock the boat ever.
Did you have a difficult pregnancy?
Yes, I was really sick.
Did you go home from South Carolina to stay with your mom here in Bradenton at 2000? Did there come a time when you returned to Carolina?
Yes.
Would you tell the ladies and gentlemen of the jury, Ashley, why you returned to South Carolina?
I had decided that I was going to leave him. And so I went back to get my things. When he brought me down, I didn't even have like a suitcase or anything. So I went back to get me. And I wrote and left him a letter saying why I was leaving.
I'm gonna have an objection.
All right, chat. Got a sidebar. I thought they'd tell us a little more chronologically, but yeah, it's checking out. I mean, if she's faking it, she's doing a really good fucking job, guys. Remember, they were able to confirm some of the things this guy has done. So this guy is a bit of a fucking loon. She's not without sin. I get that, but these people were crazy. I guarantee they're codependent as hell on each other.
All right, Ashley. Can you identify what we've marked for identification of defendants exhibit?
Judge, I object.
Sustained.
Identify it.
No, sir. I beat my ruling.
You told us you left him a letter? All right. I'm going to ask you a series of questions. Let me pass this to you. You can-
Judge, I'm gonna object.
Sustained.
Do you remember independently everything that you said in the letter?
Not everything, no.
Would it help refresh your recollection if you were able to see the letter?
Yes.
Judge, objection.
Sustained.
At the time that you wrote the letter, Ashley, were the contents fresh in your mind?
At the time, yes.
The letter was written in September 2017.
Yes, that's correct.
It's now 2020,
Yes, sir.
so 7 years ago.
Yes.
All right. Do your best
Okay.
to try to respond to a series of questions I'm going to ask you. What did you tell?
Objection, hearsay.
Sustained. So can we approach, please?
Yeah, she can't tell people. She can't introduce her own statements. That's hearsay. So she can't introduce those statements. No.
When you left Doug,
Scared.
what was it that made you uncomfortable?
It was a lot of things. Things that he'd done, like punching her dog and shooting the gun and different things he would say and do.
And were you afraid for just you?
Pregnant at the time. I was scared for the baby.
Were there instances that your own safety had been placed in danger as a result of conduct by him?
Yes.
Can you give us some examples?
One thing that comes to mind is sometimes he would be scary, yelling and screaming at me and like running up on.
Okay, guys, real quick. Somebody, who was it here? I just saw this. I was trying to get. Who's that bitch making? I think that might be one of it's family members of the dead guy. Brent said, can you explain? Oh, I didn't realize my camera's off. Okay, so look, the way it works is if the prosecution's offering her statements, it's a party opponent. If Ashley tries to introduce her own statements, it's considered self-serving. That, of course, you're saying these, and it's something that's been accepted forever in terms of the rules of hearsay, but I think it's bullshit. I should be allowed to introduce my own statements. I can back it up with other people there. So I don't always like this, but it's the way hearsay's been interpreted forever. So they're considered self-serving statements, so she's not allowed to introduce them. I mean, they're hearsay without an exception. And as much as I'd like to agree with Luke, I've tried to make this argument before. They're not being used for the truth of the matter asserted. Judges have never bought that argument. So kind of shitty, and it sucks, but that's the way it is. I hope that made sense. So thank you for Brent. That was a great question.
Curbs. Time me almost hit a tree.
Did you strike that?
I don't disagree with you.
Describe the kind of that'd be done to intimidate you.
He would yell at me. He looked like he was going to hit me.
What about breaking things?
He would break things, smash things, threw things at me.
How would you describe, if you were using adjectives, his behavior?
Possessive, controlling, manipulative, aggressive, unpredictable.
That's a pretty
Did you
fair
take any
assessment.
steps in the to protect yourself in South Carolina?
Yes. I filed for a domestic violence injunction, like a protective order.
Actually, I'd like to pass to you what we've marked as Defendant's Exhibit 13A and 13B and ask you if you can identify them.
Um, 13A is the
Objection, Judge.
Interesting. I wonder what that's going to be. We'll see. We'll see. Wow, there's a big collection of people in there. That's a big party. It's a bunch of people all hanging out. All hanging out.
Ashley, what was the date? Did the court grant the injunction?
yes, sir.
Was there a hearing?
Yes, sir.
Were you present at the hearing?
Yes.
Was Doug present at the hearing?
Yes.
Did the judge rule at the hearing?
From the bench, yes.
Peter,
November 3rd, 20,
I'm sorry?
November 3rd, 2017.
2017? Okay, now, was the judge decreed violated?
Yes.
By who?
By Doug.
How?
He sent me a package in the mail.
Sent you the package here in Florida? From
Yes.
South Carolina?
Yes.
What was the package represented to be?
A birthday gift, I believe.
And open it?
Yes.
What happened?
Well, when I opened it, there was an overwhelming smell, like a real strong chemical smell. Like an instant.
Did you report it to the police?
Yes.
Ashley, I'm going to pass to you what we've marked as defendant's exhibit number 14 and ask you to identify it.
Okay. So what do I do? Okay. Yes.
What is it?
It's a picture of the package he sent to me.
True and accurate picture of the package that you received on that day in November.
Outside, yes.
All right, Your Honor, on behalf of Ms. Benefield, we move that into evidence.
No objection. Received. Defendant's Exhibit 14.
What did you do with the package after you opened it?
I sealed it back. I put it in the garage before I brought it to the sheriff's department.
Now, you told us when you received the package, the contents giving you a headache, that it was in violation of the South Carolina restraining order.
Yes.
Did you, when you contacted the police, request that they take some action?
Yes.
What was the result?
No charges.
Okay.
I want to know exactly what was in the package, but we never got to that.
See it. Were you were you subsequently notified actually by the state office here in Manatee County that no charges were to be filed?
Yes.
Do you remember the date that you were notified?
Not off the top of my head.
Let me show this to you and see if it refreshes your recollection.
Okay. At the top, it says October 8th, 2018.
Ashley, when did you give birth to Emerson?
March 19th, 2018.
Where was Doug when you gave birth?
He wasn't there. It was during the restraining order from South Carolina.
So he wouldn't have been allowed to have back with you.
Correct.
Do you remember how long the South Carolina restraining order was to last?
I believe it was 6 months.
There come a time when you're concerned about the South Carolina restraining order expiring.
Yes.
So at or about the time that, what steps did you take to protect yourself?
I filed for a domestic violence injunction in Florida.
What was the result?
It was
And was there any directive entered with respect to Emerson?
There was a tent set up.
Shortly after that, or at or about the same time, was there additional litigation that you filed?
Yes.
Do you recall what it was for?
Divorce and termination of parental rights.
In the termination of parental rights petition, Ashley, did you tell the court?
Objection, Kirsten.
Go ahead and finish the question.
Did you advise the court in your petition about their domestic by Doug?
Yes.
Overruled. I'm sorry. You may answer.
I'm sorry.
You're okay. Go ahead.
Okay. Yes.
Do you remember? Can you tell us today what you told the court?
I mean, not all off the top of my head.
Overruled.
You can answer.
I wouldn't be able to tell it all to you off the top of my head from memory now.
Okay, let's see if I can refresh your recollection.
Would you like me to read?
I'm sorry?
Do you want me to read the whole thing?
No. I asked you, has your recollection been refreshed?
I'm just getting to that part now.
Okay. Referring to what's in front of you, tell us.
Can I finish?
Remove the document
Yeah,
from.
you need to remove the document if the memory's been refreshed.
I just finished reading that part.
Okay, fine, finish reading.
Okay.
I don't expect you to remember all the details. I'm going to ask you for the high points.
Okay. Sorry. There's just a lot in here.
Ladies and gentlemen of the jury, I
talked about him punching Sully and kicking, throwing our cat, trapping me, grabbing me, yanking me, tripping me, shooting the gun in the house, punching holes in the walls. He trapped me in the closet, smash things like that.
All right. As part of the domestic violence injunction that you filed here in Florida, that was before Judge Moreland, was a deposition taken of Doug.
Yes.
Were you present?
Yes, by phone.
Who else was present at the deposition?
My attorney, as well as Stephanie Murphy, Doug's attorney, and a court reporter.
Was the judge present at the deposition?
No.
Were you with the entire proceeding?
Yes.
Did Doug make
call for music.
Approach.
Chat, we got another. I think they're doing a great job right now. They are doing a great job about getting stuff in. You know, who was it here that said, "Oh, this guy's being shady"? This, his job's not to play by. His job's not to be nice and play patty cake. So, yeah, no contact means no contact, guys, and that's the thing. No contact means no third-party contact. Talking to your cousin, sister's hairdresser's wife's friend. No contact means no contact. So him sending anything is it means no contact. And yeah, what was in the box? I don't know. So I'd like to know. Yes, I can see her storming out of the courthouse, just saying it's not a fair look to the jury. Yeah. How do the facts stack up to the case stack up against her testimony? Well, we now learn that it's been confirmed Doug's a fucking psychopath. So, I mean, yeah, she's got to be reasonable fear he could be violent towards her, and it was an escalating thing. I think that's reasonable doubt to me. No, here we go. Wow, that timed out right.
Ashley,
Can approach based on this as well.
Okay.
Ridiculous how much crap they're going through. Jeez. No wonder it's like 4 hours long. It's her just sitting there for like 3.5 hours of like sidebars and like 30 minutes of actual testimony. Come on. Oh my gosh. There we go.
Ashley, I'm going to pass to you what's been marked as defense exhibit number 17.
Okay.
And ask you if you can identify it. Ashley, do you recognize that?
Yes, sir.
Tell us what it is.
They're text messages between me and Doug.
And do they truly and accurately reflect texting back and forth between you and Doug?
Yes.
On behalf of the defense, Your Honor, we move into evidence, defense exhibit number 17.
Objection overruled. Defendant's Exhibit 17 will be received.
Ashley, in defense exhibit number 17, the text messages, does Doug admit to shooting the gun in the house?
Yes.
Does he admit to throwing the gun at you?
Yes.
Does he admit to punching holes in the drywall of the house?
Yes.
And does he admit to punching the dog and rendering him unconscious?
Yes.
Objection, no, he does not. Those text messages do not say that.
I'm going to sustain. If you want to publish the exact
Yes,
exhibit that's been admitted, you can do so.
we intend to publish upon completion of the examination. I want to ask you, Ashley, if I can, about other instances of abusive conduct. Was a tracker at any time placed on your car?
Yes.
Was it done with your permission?
No.
Did Doug? No, hold on. While the state is reviewing that, Ashley, I'm going to pass to you defendants exhibits 19 and 20. Tell us, if you would, what they depict.
Holes in the drywall of the house, our house in South Carolina.
Refer to them specifically. Exhibit number
19 has a
what does that
picture
show?
of a hole in the drywall with my hand next to it. It's kind of been like pushed back in.
Is it a true and accurate production of what existed at that time?
Yes.
All right, and the next one?
20 has a picture of a hole, like a fist hole through the drywall in our home.
Okay, is it a true and accurate photograph of that?
Yes.
On behalf of the defense, Your Honor, we move them into evidence.
State, any objection to defense 19 and 20?
No.
Received. All right.
Every time I feel like I'm about to get one, she dodges me. It's definitely. Just look at this one.
Yes, please send it to me. I'd love to take a look at those. We'll show them.
Ashley, did Doug admit to placing an illegal tracker on your vehicle?
Yes, and a message to me.
Did you report that to the police?
Yes.
What was the result?
No charges.
Were there incidents, Ashley, where Doug would appear unexpectedly?
Yes, a lot.
And how would that come about? Can you give us an example?
I'd be driving down the road and I'd see him in the rearview mirror, a couple cars behind me, or he'd be right behind me. Or sometimes he would show up at places that I was just unexpected. I'd see him, or like in the parking lot.
And was this while you were living here in Manatee?
Yes, I was living here
And where was Doug living at the time?
in South Carolina.
How could he do that?
He was driving here,
Was this also during the time that the South Carolina Injunction was in place?
both then and after as well.
Did you report those incidents to the police?
Yes,
What was the result?
no charges.
Was there an incident with a neighbor, Ashley?
Yes.
What happened? Ashley, were
She,
you present
yes,
for the incident?
yes, he was outside in the yard at night looking in the windows of my house.
What is the neighbor's name?
Marianne Croft,
And was this reported to the police?
yes,
Did they respond?
yes, they came out.
Was it daytime or nighttime?
It was nighttime.
In your presence, was an identification made that it was Doug?
Yes,
What was the result?
no charges.
Was there an incident, Ashley, where you and your mother came home to find someone in the driveway of your home.
Yes.
Who was it?
It was Doug.
What did he do when he saw you?
He was on foot in front of the house, and when he saw us, he took off running.
Did you call the police?
Yes, I had to call several times before they sent someone out.
Did they take a report?
They did, but by the time they finally got there, he was long gone.
What was the result?
No charges.
I want to introduce what we've marked as Defendant's Exhibit 23 and 24. Can you identify that?
Yes.
What does 23 show?
23 is a picture of Doug with his shirt off. He's like taking a selfie.
And is that how Doug looked at or about the time of the shooting on the 27th?
Yes.
All right. And what does the next exhibit show?
It's also a picture of Doug with his shirt off. He's working out. He's like doing like a push-up, I guess.
Does that too accurately represent what Doug looked like on the day of the homicide?
Yes.
Your Honor, on behalf of the defense, we move those two exhibits into evidence.
Any objection? Received.
Just one or two more questions, actually. Was there a time back around May of 2000 where you wanted to learn about co-parenting with an abuser?
Yes.
Objection. Previous ruling.
Sustained.
To the question, Your Honor, or to the line of inquiry?
To the question.
Okay. Did you take any steps, Ashley, to try to determine how to co-parent?
Yes.
All right, and what was that?
I did some like Googling and reading to try to find helpful articles on what to do to make things
I'm going
good.
to pass to you what we've had marked as Defense Composite Exhibit 4, A, B, C, and D.
Objection, Judge. Previous ruling. Excuse me. It's the next one.
Can you approach?
We'll pass you Defendant's Exhibit number
No,
4.
I already ruled on authenticity in the past. So over the state's objection, admitted.
Thank you. Take a look at Exhibit 4A, Ashley. What's the date?
5/11/2020.
And did you do an internet search on 5/11/23?
2020. Yes.
2020, rather?
Yes.
And will you tell us what the subject you researched was?
Domestic co-parenting with an abuser.
All right, and would you go to Exhibit 4B? What's the date of 4B?
5/11/2020.
Did you do an internet search then?
Yes.
What was the subject you researched?
Ask Amanda. How do I co-parent with an abuser?
All right, and 4C?
Yes.
What's the date of 4C?
5/11/2020.
And did you do an internet search then as well?
Yes.
What was the subject?
Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
All right, and lastly, 4D. What's the date of 4D?
5/11/2020.
Did you do an internet search?
Yes.
What was the subject?
6 tips to help you co-parent with an abusive ex.
All right, Your Honor, I think I'm finished if you just give me one moment. Actually, I'm going to pass to you what's been previously admitted as Defense Exhibit number 6.
Okay.
Do you recognize it?
Yes.
What is it?
It's a whole chain of emails that were forwarded to me by my attorney.
And what is the date it was forwarded to you on?
It says Wednesday, September 23rd of 2020.
Did you read it?
Yes. I mean, do you want me to reread it now or?
Did you read it when it was forwarded to you?
Yes.
No further questions, Your Honor.
All right, go ahead to the attorney's approach, please.
All right, guys, here we go. We have some of these pictures here. They're doing a thing right now. We're gonna switch over. Oh, I gotta really add it off. Sorry, my bad. We're gonna switch over to this real quick. These are some interesting things here. So here's some of the pictures in the walls. Some of the damage Doug had done. It's a website called WeStandWithAshley.com.
About 11:45, so I'm going to let you go on your lunch break at this point. If I could have you guys back downstairs in that jury assembly room by 1 o'clock. And when I say by 1 o'clock, maybe 5 till, because the goal will be to go ahead and get you on up here.
So they ended up taking a break. So this is some of the interesting stuff here. So here's a text from Doug. And this is where Doug talks about it. And he says, like, I punched the dog because you got me so mad, like you wouldn't stop about Ava. Always about Ava, every argument about Ava. It says, you punch a dog because of your daughter. Sounds like you're unstable. And he's like, wow, look in the mirror, Ashley. And then he talks about, like, here's an example of, I just lost it. And he's like, you took it out of dog. He's like, fine, you can remind me. And then he threw a 13-year-old cat. And he's like, how many times do you want me to say I failed? Oh, this guy sounds like a real piece of shit. I'm sorry. All that all shows a man who has never done what was under too much pressure. That's what happens when you break. I broke. I lost it. I know it. I got help. Ugh. Not I'm sorry. I didn't mean to hurt these animals that were defenseless. Like, Jesus, Doug. You sound like a piece of shit, man. I mean, that, when she's talking about getting banged up in the hallway, she's got a good excuse, it sounds like, man. Sounds like she's got a good excuse. So, let's get back to court.
So I have States Exhibit 103 and States Exhibit
All right.
104.
Yes. It's their objection, sir.
Okay, yes, objection.
Relevance as to the
Oh, she's not
modeling
guilty.
photo. And mugshot, we submitted a memorandum to the court. It's pretty clear case law, mugshots are not admissible.
The case law is clear, the mugshot is not admissible. But the relevance of both of those is to show before and after this incident, so the jury can make their own determination if there's swelling on her face. And I did say when we had a pre-trial discussion about the mugshot that I would not intend to enter it unless the defendant made it relevant by testifying that she had swelling on her face. So I do believe now that she said there was swelling on her face, I can introduce the mugshot that occurred weeks later to show.
I apologize.
I was done, I'm sorry.
Objecting party, rebuttal.
I know I wasn't able to introduce in the state's case in chief. I don't think they should be entitled to introduce ours either.
Well, I think there was some evidence that was introduced. It all depended on what it was. Thank you both very much. 103, what did you refer that to, a modeling picture? Is a modeling picture showing the defendant's front face down to the chest area. And 104 is, I've not compared it, but you say that's the booking photo that was taken when he was arrested. Right, I was just checking because there's
later, though.
there's like a speck on it. I was checking to see if that
Photo
was
came months
paper
later.
speck
Like,
or
how's
the
that going to
picture.
help?
So yes, what we originally talked about, I don't think there's, I don't agree that there's a blanket prohibition on the entry of a booking photo. However, it is a bit of a more unique situation whenever, if there was an erroneous decision not to allow one party or the other to introduce evidence during the other side's case in chief. It's a fairly simple remedy that the other party can just call them in their case in chief or in rebuttal, lay the proper predicate and introduce the evidence if it's admissible.
That would still be
In this situation,
horribly.
it's a little bit different. Obviously, these would need to be authenticated by the defendant. If it's improper, I'll allow it. The only thing I'm going to require, however, is the 104 is just to be referred to by the date. On such and such a date was your photo taken.
And Judge, I respectfully disagree. There's no case law that says a jury cannot know that a person was arrested. The only case law is that
It's highly
a person cannot
prejudicial,
make
though.
sit at trial and jail clothes. But there was no prohibition. They know she was arrested.
Mhm.
So I believe that helps substantiate the date that it was taken and the time that it was taken.
And I think you can ask for the date and time. So, yeah, no, overruled.
Can I see the exhibits?
Of course.
Judge, just for the record, the state has still not received the ordered defense exhibit list that we instructed them to get.
Are there any other defense exhibits? Well, let's close this issue out.
Yes, sir, I'm sorry.
Whiny crybaby prosecutors.
All right, so defense has handed state 103 and 104 back. The question was asked regarding defense exhibits. I don't know what's left. I don't know what witnesses are being called or when, but do you have an exhibit list that complies with Rule 3.220?
I think we gave them all.
It has 360 something items, file folders with multiple pages in each one. That does not conform to the rule. They need to tell us what they are going to introduce specifically.
Well, the rule calls for what do you intend to introduce?
We have them share them with the prosecution today.
Prior to any other witnesses being called.
Yes.
Okay. All right, are you ready? State.
I just still would ask for a list because it's hard for us to, when showing us them, I don't have the ability to recopy them and do all those things like I would have if I got the proper list. And so it's just hard for me to be able to then go find the things, to be able to figure out if they're complete.
So here's what we're gonna do. We're gonna have a mid-trial exhibit exchange. And we'll take a break. Maybe it'll be the mid-afternoon break. I have no idea.
We'll give them a list.
And you're gonna get a list. And if not, you can go through them and you can write on a piece of paper exactly what they are. And if you say, I want a copy, they're gonna give you a copy.
Yes, sir. Thank you so much.
Okay, problem solved. You ready? You ready to go?
Yes.
All right. When we finish, Ms. Benefield, you were on the stand, so if you could reposition yourself, please.
And if we could put the screen down, please. And shut the lines. Thank you.
Yeah. The clerk is going to leave the lights. The clerk's going to leave the lights as is. When you need the lights lowered, then let us know.
Okay. I don't know what you're talking about. 52. I don't need them. Oh.
All right, bring in the jury. Anybody outside of the jury about the case, or did anybody do any research on the people, places, things, or legal topics we've heard anything about? Everybody says no.
No, guys, somebody's
State,
talking to
begin
me.
your
I'm trying to
cross-examination.
respond to their text. Okay?
I would like to just start with a couple of issues.
Trying to read
So
what they're saying.
First, Benefield never punched you, ever. Correct?
Yeah, I think that's correct.
Doug Benefield never choked you, ever.
No,
He never kicked you.
No.
He never pointed a gun at you,
he waved a gun in my direction.
but it was not pointed at you,
It
correct?
was pointed at me while he was waving it at me.
He never came at you with a knife.
No.
Or a club.
No.
Or a baseball bat.
No.
So there are 30 years difference between you and Doug, correct?
Yes,
And you got married after 13 days.
yes,
And you spoke with him about, or organized with him about starting this ballet.
Yes.
And all of the money for the ballet came from him or investors, right?
My mom also funded part of the ballet.
You didn't put anything into it. Money.
Not from my account, no.
Okay. In fact, during this time in South Carolina, you never worked, did you?
He wouldn't let me work.
Okay. When you said in the very beginning he flew you to South Carolina to visit before you were married, he paid for that, correct?
Yes.
Okay. And the cruise you talked about going on, he paid for that?
No.
He didn't?
He did not pay for the cruise, no.
Okay.
Yeah, he paid for my friend to go, but I had already paid for my mom and I to go. So.
Okay. So he paid for your friend to go?
Yes.
And he did not go with you?
Oh, no. Mm-mm.
I want to ask you about the text messages that the defense talked to you about. It's going to be Defense Exhibit 3. I'm going to hand it to you. And I have the entirety of it on a spreadsheet that I'm going to put up, which is State's Exhibit 99. If we could dim the lights, please. And Judge, based on the rule of completeness, state would enter into evidence State's 99.
Did you want to be heard in addition to what we said earlier?
I haven't actually seen the specific message.
Any objection to State's 99?
Yes,
Proceed.
those were yes, guys.
So I'm going to put this up on the board.
I did like all of that. Did he
Behind
actually
you.
ever point it at you? Well, and going back to a comment from somebody before, this is something somebody asked about it being. Brad says abusive, but never hit you before. There's abuse can be a lot of different things besides physical violence. The threats of physical violence is enough. So. That's just something to think about there, chat. Then Sweet Tooth Fairy says 15 months. The tea was tainted with urea to cause a miscarriage on the box. Ah. Okay. And I'm reading that on the website. It looks like something, yeah. Yeah, this is all very sketchy. All very sketchy. Yeah, it sounds like Doug was a hell of a guy.
Mm-mm. We're trying to get it to come up on the screen. Okay. So I would like to orient you to what we're looking at. So on the top line, it gives whether the messages are outgoing or incoming. That would be the third, fourth column that we're looking at. And what I would like you to do is read the body of these as we go through. I'm going to expand it so you can see it. And if you could just read these for the jury.
Okay. One part is just looking at Renee.
Who is that from you or from Doug?
It's from Doug to me.
So from Doug, one part is just looking at Renee. Okay, go ahead.
I'll tell that part to start. The day I met her, I felt her before I saw her. Oh. My ex-husband lived to argue. Renee and I maybe argued 5 times in 15 years, and even then ended up laughing. Smiley face. I'm a clown at heart and love people being happy. That seems like a hard act to follow. Baby. like always being armed. Yes, my love.
And the outgoing messages are you or Doug?
It looks like outgoing is Doug. Yeah, outgoing would be from Doug.
Judge, can we see the date for reference of the messages?
It's up on the screen. So yes, my love, I think was the last thing you said. And then what's the next thing?
Are you doing things that are dangerous?
And you're gonna have to speak up just a little bit.
I'm sorry.
Here.
Are you doing things that are dangerous? To think of all the time that you were not with me and understanding them and how to conduct warfare in them for the kingdom.
Where was he when he was sending you these messages? While you were on the cruise?
I believe he would have been in Charleston.
Okay. He wasn't on a business trip.
I don't believe so.
Okay. Continue reading. All the other people.
All the other people. And then a rectangle. It makes me so sad. And then another rectangle. If I dwelt on it, I would go into rage to remove them from the earth.
And your response to that?
Yes, baby, I hate it. It hurts. He said I could defend myself. You were easy prey for predators.
Well, that doesn't make him sound like a crazy
You're
man.
sweet and want to please people, and they used that.
Wow.
And you said? I'm sorry. And then he said?
You're
I
easy
desire
prey
to
for
exterminate them
predators.
and
Jeez.
hold a
Oh
challenge.
boy.
They are rats
Oh,
that should
no.
be removed.
And you said?
Oh, baby, my love. Yes. Like that night, like last night, just the jerks arguing near you about put me in a sheer murderous mood, but I was stuck and I couldn't defend you. I said, thank you, baby, but I was okay. He said, but could have been a fight, etc. Only you being with me will over time remove images in my head. It is same, and knowing you were taken advantage of in my mind makes me explode with anger to take them out. God made you for me. And I said, yes, baby. He said to enjoy the beauty he did craft on earth. I see Renee as Eva's mom, not my wife. It is strange, but...
Let me pull that back up.
He said it is strange, but there is no emotional connection. I said, well, I'm glad. I just wish I could see it that way.
And you said, I'm glad. I wish I could see it that way. Were you talking about being jealous of his relationship with Renee?
I guess you could put it that way.
Okay. You can continue to read.
I know we both have a battle to fight in our minds. He was sitting on the mantle in the background. I'm crazy, I know. But it just killed my heart. I know I see you in my mind with a bad person with your legs spread and a shitty person choking you out. That haunts me. I love you and I never want you. I'm sorry. Rectangle. Now all I see is some douchebag on top of you, fucking you with your legs, choking you out and fucking you more. Right now I literally want to kill him or them. I said, baby, don't even think like that. He said, you haven't seen the warrior side and you never want to. I said, no one will ever touch me. I am yours. I don't. You are right. I want to see you only as my sweet and loving husband who is done.
What the fuck? What? Yeah, I don't know. I didn't realize I was muted, chat, but oh my god, yeah. Imagine the daughter like, my daddy's so nice. Imagine reading that now. Oh boy. Imagine all of his family reading these. Woo-hoo-hoo. Jesus. Is this guy Ricada adjacent? No, these people are too strong for Nick. Ashley could probably whoop him. Oh my God, this is crazy, crazy, crazy.
Told to me and kind. He said we went from joy and passion to now I'm in a testosterone rage inside. And who is always there and safe? That's what I said. And I said, let's not ruin the day. He said, but kill the bad people. Okay. And I said, tell me that you love me.
I don't know how this helps.
So this
state.
conversation was about things that you had told him that people had done to you, correct? When he's talking about, I'm imagining this, I'm imagining people choke you, he's talking about a conversation that you had had with him explaining that this had happened.
I think he was referring to on the cruise one night I was talking to him on the phone and I was sitting out in the hallway up at the top deck and I was just trying to get somewhere where it'd be quiet so I could talk to him. And it was near, there was some like a bar or something up there, I think, I'm not sure, but people were coming in and out, like maybe a restaurant. And while we were talking, he heard.
Is the answer yes or no? Did
She's saying,
Please allow her to finish her answer, Your Honor.
you finish your answer.
He had heard a couple of guys that were talking loudly and he got upset because he thought these guys were going to hurt me. And so he had talked about then that he imagined that, you know, I was out in the world without him and that people were going to take advantage of me and that it was going to happen to me.
and he was afraid for your safety.
Yeah.
And he was saying that if anybody hurts you or he thinks about anybody hurting you, it sends him into a rage.
Yes.
And that scared you.
I'm sorry.
And that scared you.
Well, as I said earlier, at the time, I kind of, you know, played it off in my head that he was just my new husband who was trying to be protective and like show that he loved me by kind of being, you know, manly.
Okay. So I want to talk about you having a baby. So Doug had a vasectomy removal in April of 2017, right?
Yes.
And you paid for that.
Part of it went on my debit card or my credit card.
And your intention was to get pregnant.
Yes, we had talked about that. Yeah.
Okay. And this was how many months after you were married?
We got married in September, so October, November, December, January, February, March, April. 7.
And was this during this time? You said he had started criticizing you, right?
Mm-hmm.
About the way you looked, your clothes, the way you acted. He was, according to you, he tried to flip a table, threw a chair, right?
Yes.
He would scream at you.
Yes.
He would call you slut and whore.
Yes.
And you want a baby.
I mean, yeah, we were married. We wanted a family.
Oh, whoa. What, really? This is the tack you're going to take right now? You are possibly a victim of abuse. I mean, she wouldn't, if she was in a DV trial and the defense attorney tried that, she would fucking object and lose her fucking mind. Like, wow, this lady is fucking losing the plot. She could have done this a far, far better way. This is no tact at all. That's as subtle as a fucking brick through a window.
So the vasectomy reversal happens. And I believe you said that this baby was a surprise. Is that what you said?
Well, we weren't like planning on it right then. You know.
Were you having unprotected sex?
I suppose so.
Okay. So you knew that unprotected sex would result potentially in a pregnancy.
The doctor had told us that it probably wouldn't work for a while, so it wasn't something that we thought would happen that fast.
Okay. But it did.
Yes.
How quickly? When did you get pregnant?
I guess July.
And right around this time is when you say the incident happened where Doug threw a gun at a wall.
He threw it at me.
Shot a gun at the ceiling. I think you made several allegations, correct?
Yeah, he admitted to it, but yes.
What were you arguing about?
I think Eva was part of it. I don't specifically remember.
And wasn't it true that you had a problem with Eva and you thought she was disrespecting you at that time?
I wouldn't say I had a problem with Eva. There was a lot of tension in the house, but yeah, there's a lot of things going on that are not ideal.
You knew she was 15.
Yeah.
And you knew she had just lost her mother tragically to death.
Yeah.
And you were how much older than her?
10 years, 9 years, 10 years.
And this tension surprised you?
No. I mean, at first he had told me that she was really going to love me and that she was ready to have a woman in her life and that he wanted me to move in quickly because she needed a mom. So he made it sound like she also felt that way.
And you had no feelings of your own.
Oh, I was excited to get to be her stepmom.
And you gave her a shadow box right around this time, correct?
For Christmas, so it would have been in December.
All right. And what was the shadow box?
You want me to describe it?
Yes.
It was like a small picture. It had like deep sides and like the glass was at the front of it. And there was a sand dollar that I had painted and decorated. And I put it on like a black cardstock. And I wrote a saying on it that said something about how like you can be strong through the storms and that, you know, seashells are beautiful things that come out of storms.
And that shadow box is the reason you were arguing.
She wrote Hakuna Matata.
I know it came up at one point. I don't know if that was the reason.
And what was the problem with the shadow box?
Eva had taken it apart and I guess had thrown out the thing that I made and was using the picture frame for something else.
What was she using the picture frame for?
She had put a rose from her mom's funeral in it.
And that upset you pretty badly, didn't it?
It made me really sad.
Oh,
I'd taken a lot of mom's using the
Did she just?
how
I
like
didn't see her walk
and
out.
I
Oh,
painted
we
and
had-
decorated
Yeah.
and I put it on like a black cardstock.
Suffer, Ava, suffer.
You can, I know it came up at one point. I don't know if that was the reason.
And what was the problem with the shadow box?
Eva had taken it apart and I guess had thrown out the thing that I made and was using the picture frame for something else.
What was she using the picture frame for?
She had put a rose from her mom's funeral in it.
And that upset you pretty badly, didn't it?
It made me really sad. I'd taken a lot of time to make it for her and I thought it was special. And
you
Sounds like
began
Ava's a
crying.
bitch.
yes,
And you dropped to the floor and sobbed hysterically.
probably.
You were so upset that she put her dead mother's rose in the shadow box.
It wasn't that. It was that she took it apart. I mean, I would have bought her another shadow box.
You went to Doug and said it was disrespectful that she took this apart.
According to Doug.
Really? She's gonna make these arguments? How dare you get mad this happens to you? Oh my god. This is awful. Listen to this fucking prosecutor. This prosecutor's such a bitch. You know, you have the right to be mad your stepdaughter shit all over something you try to do to help her out. How dare you, ma'am? How dare you? That's how you lose a case.
According to you, you went to Doug and said, she's acting disrespectfully. You need to handle her. She upset me. I'm
Yes,
crying.
she needs to
I
be
don't remember saying
controlled.
that about that.
Isn't it in fact what you were arguing about before this whole incident with the gun in the ceiling?
Is this relevant as it relates to the daughter?
You approach, please.
Yeah, she needs to be patrolled. Ava needs to be patrolled. Adding like a little thought, and like, we can't have that. So,
That argument happened.
here we go.
So the day that this argument happened, you actually at one point were in the car with Doug, right?
Yes,
Okay, you were going to the bank and going to do some other errands.
I believe so.
And the entire time you're upset about this shadow box.
I don't distinctly. The argument kind of came from there, I guess.
And in fact, it wasn't an argument, right? It was you being upset.
He said that like life was out of control and he couldn't deal with the people at home and he couldn't deal with the people at the ballet. And he felt like everything was just too stressful and he was upset with everybody.
And didn't he ask you to stop?
I'm sure at some point.
And you didn't stop
I guess not.
for the car ride? No? Yes or no?
I don't remember.
And you kept telling him you need to discipline Eva.
I don't remember saying that.
And he said, let's just stop talking about this for a while. I need to think.
He was yelling at me.
So he's yelling at you, but you weren't sitting there like you are now, were you? You weren't sitting there like this.
I guess I was buckled into the car, so I probably would have been sitting further back.
And you didn't stop. And you get home, you're still arguing, correct?
He was still yelling at me, yes.
And you're not yelling at all. And the fact that he had a gun with him when you continued to argue in the house was because he grabbed the gun from inside the car to bring his items from the car into the house. correct?
I'm not sure why he had it, I guess.
And it was in a holster,
I believe so.
and you both used to carry guns.
Mhm.
You carried guns on a regular basis.
Yes,
You
ma'am.
have had at the time more than one gun.
Yes, ma'am.
And you actually bragged, as well as Doug, about having guns, correct?
Yes.
And you would go shoot them on a regular basis.
I haven't been to the range since before the presidential election.
Okay. But during the time that you met Doug at a political event, you had one of the guns in your bra.
Yes, that's where I concealed carried.
Okay. So having a firearm in a car or in the house is not that unusual to you.
No, ma'am.
So after you decide, there's this argument that continues on and on and on and on. And you're still asking Doug to discipline Eva.
I don't recall that.
And you say he was waving a gun around and threw a gun at them.
Yes, ma'am.
So he has a gun in his hand, could point it at you,
He did point
but
it
he
at
throws
me.
a gun at the wall.
No, he threw it at me. He missed me.
Okay. And it hit the wall.
Yes, ma'am.
Okay. When was this? What was the date of this argument?
At the end of June.
2017.
Yes, ma'am.
When was your wedding reception?
It was shortly after that, maybe like a week or two later. I don't remember specifically.
Okay. So even though you'd been married before, you were now having a wedding reception.
Yes, when we got married, it was just the two of us.
And at this wedding reception, you had a lot of guests come,
I'd say maybe a dozen. My friends and family came.
and they're dressed up.
Yes.
You're in your wedding dress.
Yes.
And I'm going to show you State's Exhibit 10. I want you to tell me what this is. Or I'm sorry, it's 100. I want you to tell me what this is. It's going to come up behind you. What is this a picture of?
That's a picture of Kevin, Christy, me, and then Doug.
Okay. And is that a picture from the wedding reception that we just talked about?
Yes, ma'am.
I'm going to show you State's Exhibit 101. What is that?
That's a picture of me and my friend Christy.
And is that at the same wedding reception?
Yes.
And State's Exhibit 102. What is that?
It's a picture of my friend Laura and me, and then my friend Christy.
And this is
Okay.
also at the same reception.
Yes,
What's
ma'am.
this do?
State will move into evidence, States 100 through 102.
Any objection?
I'm sorry, I missed it.
Any objection to states 100, 101, 102?
No.
Received.
Thank you. And in States 100, are you scared here of Doug?
No, I would not say.
You said on direct examination that around this time you were living the nightmare. Those were your words, correct?
Yes, ma'am.
Okay. Were you living the nightmare here?
Oh no, not at that moment. No, that was a very nice day.
How about at this moment?
Oh, it was a good day.
And States 102 at this moment.
Same. It was a good day.
Interesting.
So you get pregnant and you decide to move in with your mother. So when do you decide to move in with your mother in Florida?
It was the end of August, I believe. I was really sick, and he brought me down to my mom's house and dropped me off.
Okay. But going to your mom's house was your choice, right?
We decided together. He said that he couldn't take care of me. He was too busy, and that my mom could take care of me better. So I was happy to go.
You needed someone to take care of you while you were pregnant.
I was really sick. Yes.
So you moved down with your mother at maybe August of 2017, you said?
The end of August, I believe.
Okay. But there's still this issue of the injunction in South Carolina while this is going on, this South Carolina-Florida thing, correct?
I'm not sure I understand that
Well,
question.
you said you applied for the South Carolina injunction, or you received the South Carolina injunction right around that time in 2017. Actually, I think you said November 2017.
Yes, a few months later.
So shortly
November.
after you moved in with your mother, a couple of months, you filed for an injunction in South Carolina.
Yes, ma'am.
And we talked about the fact that, or you talked with the defense about the fact that it was a mutual injunction.
Yes, ma'am.
So both parties agreed to stay away from each other, correct?
Yeah, I believe that it was for both parties to stay away.
No evidence was presented at this hearing.
I don't believe so.
None of your complaints were heard at this hearing.
There was like a written, like a filing.
But the judge, other than that, did not hear any evidence at the hearing.
That's correct.
All of that was forestalled because the two of you agreed, okay, fine, we will have this voluntary stay away order.
It was decided through the attorneys, but I believe that was, yes.
Okay.
Yes, ma'am.
So the judge never found that Doug Benefield was dangerous and order this injunction?
I'm not sure what the judge found. I don't know what you mean by that.
There was never a court finding giving you an injunction, other than you stipulated to it.
The judge ordered it. Yes, ma'am.
Okay. And this injunction, actually, part of it says that neither party shall harass or threaten or do those types of things to each other.
Yes,
right?
ma'am.
Okay. So then after you're in Florida, you get a package that you say was in violation of this injunction. And it's a birthday present, right?
Yes,
It's a tea set,
among other things. Yes, ma'am.
and you liked tea.
I like drinking tea. Yes, ma'am.
You drank tea all the time with Doug.
Yes.
Okay. And you opened this tea and you claim that it smelled so strongly that you automatically rushed it to the sheriff's office.
I didn't specifically sniff the tea. It was when I opened the box. The whole contents had a very strong chemical smell.
So you immediately rushed it over to the sheriff's office.
No, ma'am. I immediately sealed it up and I left it in my garage.
For how long?
I don't remember specifically. It was like maybe a day or two. I don't remember.
It was a little bit longer than a day or two, was it not?
I don't remember.
So after this time goes by, you take it to the sheriff's office and you claim that this was a violation of injunction. Right.
It was. Yes, ma'am.
And you also claim that this was all part of Doug's poisoning scheme to poison you and your unborn child.
Hazmat informed me that there was toxic
I don't want to hear what
chemicals in-
someone else told you. I want to hear what you claimed, that this was part of his poisoning of you, planned poisoning.
Well, based off of what I was told, that was the
Yes
conclusion
or
I came
no,
to.
ma'am? Yes or no? What, according to the way you felt, this gift was a part of his plan to poison you.
It concerned me. Yes,
Okay.
ma'am.
This is never a good idea. If you're prosecuting and you're doing this to a woman who's been subject to domestic violence, you've already lost the plot.
So no charges were filed for that, correct?
Correct.
So you filed for an injunction based on the same allegations, right?
When my injunction in South Carolina was getting ready to expire, yes, I filed for one in Florida.
Okay. So when you filed in Florida, about what time was this? What date?
I could give you a ballpark. It was in the spring. I don't remember exactly
Spring of 2018?
when. Yes, ma'am.
Okay. So you had left Doug in South Carolina August of 2017,
Yes, ma'am.
and you filed for an injunction in the spring of 2018,
That sounds right.
but you hadn't been living with him, correct?
Correct.
You hadn't even had any contact with him for a very long time when you filed for that injunction, right?
Well, other than him sending the box and
So what violence were you trying to prohibit by filing this injunction? Everything that happened in South Carolina.
well, I was just hoping that wouldn't happen again.
Okay. And at the same time you did this motion for an injunction, you also did a motion to terminate Doug's parental rights, right?
Yes, ma'am.
Okay. So during this time that you haven't been with him in almost a year, at least half a year, there hasn't been any violence other than you say the T said. You're filing for an injunction all at the same time that you're trying to terminate his parental rights. This is all correct, right?
Sounds correct. I believe.
And you hadn't even had the baby yet,
As of when?
as of the time that you were trying to terminate his parental rights.
I don't remember what the date was, but it would have all been around that time.
And then there's the hearing that goes on for this injunction, right? And this is in front of Judge Moreland, correct?
Yes, ma'am.
Okay. And you had a 2-day hearing on this.
Yes, ma'am.
Partially, it was a motion for your injunction based on these issues, and it was also Doug's motion to be able to see his child, right?
I believe at some point things got consolidated, but I don't recall specifically.
So at this point, Doug had not seen his daughter.
Correct.
And your daughter was how old?
As of the date, like the last court date,
Yes.
about 6 months old.
And had there been any violence towards you between the time that you filed for this and the time when you had the hearing and she was 6 months old?
He had showed up at night in my driveway, but I mean, there's no physical contact if that's what you're asking.
Okay. And was this a time when they were born?
I don't remember the date of when he was in the driveway.
How about, since we're talking about this, let's talk about the incident you talked about where the neighbor said that that Doug was there. Can you tell me about that?
Yes, ma'am. He was outside standing in the yard at night, I guess trying to look in the windows of my house.
And where's this neighbor's house?
She's directly across the street.
Okay. And isn't it true, in fact, that this was very dark? It's very dark out.
Yes, ma'am, it was at night.
Okay. And your neighbor told you that she saw someone in her backyard walking, correct?
But when she confronted him, he kind of ran away.
Okay. She never told you he was at your window.
What she said was that he was trying to look in the windows.
In her yard.
The way the houses are situated, where he was standing looking across into the windows of our house. Yes, ma'am.
And she couldn't see who this person was.
Object.
She told you.
She's asking Ms. Benefield about what the neighbor knew.
Overruled.
She told you she could not identify this person.
She said by just looking, as dark as it was, she had a hard time identifying him by his face, but that she identified his voice.
That's interesting. So let's talk about that. So when she tells you that there's somebody in her backyard, you go to her house, right? You end up together with her.
Yes.
All right.
Not at her house, but yes.
And you play a recording that you've recorded, like a voicemail from Doug for her, right?
She believed it was Doug, and she said that she could probably identify his voice because he had a unique voice. And so I played a voicemail I had from him, and she identified him.
The fact is, she didn't tell you she thought it was Doug. You just asked her if it was Doug.
I believe she contacted us and said that there was a strange man looking across into our windows, and she was freaked out, and she wasn't sure if it was him.
Okay.
I don't remember specifically. I'm sorry, this is a long time ago.
And you play a recording of Doug's voice for her.
Yes, ma'am.
And she goes, oh, that's him.
Yes,
That's
ma'am.
the one that was there.
Yes, ma'am.
So that is the ID that Doug was in her backyard.
I believe she also described his body type, his stature. She said he was wearing a baseball cap, which he often did. So I think that
A lot of
was
people wear baseball caps.
But she needs to allow
I'm
Ms.
sure.
Benefield to clear answer before she cuts her off.
I've been able to follow along, so I'm overruled at this point.
There's a lot of people that are 5'9", right?
Oh, yes, ma'am.
A lot of people that weigh 160 pounds.
Yes, ma'am.
A lot of people that wear baseball hats.
Yes, ma'am.
And isn't it true that this person in the backyard said to her, I live around here. I live here.
Mm-hmm.
Okay.
I believe so. I wasn't there for that part, but that's what I believe she told me.
Thank you. Now I want to move forward to 2019. Around this time, Judge Moreland had already ruled that you could not have your injunction, right?
She denied it. Yes, ma'am.
And that Doug could have immediate visitation with his daughter.
She ordered time sharing. Yes.
Did you start visitation with Doug and Emerson very shortly after that hearing?
Yes, according to the court order. Yes, ma'am.
And you decided you were going to go with him on this visitation?
I offered, and he said he would be glad for me to come. So yes, I went.
This person that you lived in a nightmare with, you decided to go with him on this visitation?
Yes.
Now, the Judge Moreland hearing, when she ruled, she made it very clear that she did not see your side.
Sustained.
You had no faith that Judge Moreland was going to help you from that day forward.
Overruled.
You had no faith that Judge Moreland was going to help you from that day forward.
I don't know. They'd say I thought she would never help me, but I mean, she denied the injunction. Yes.
So you go for this visit along with him and Emerson, and that begins sort of a, I think Stephanie Murphy called it like a honeymoon period or a happy period piece. Would you agree with that?
Yes, ma'am.
Okay. So during this time, you spent a lot of time with Doug.
Yes.
And a lot of time with Emerson.
Yes.
And you weren't scared of Doug at that time.
He was being very kind.
Okay. So you weren't scared of him at that time?
No, I mean, I had things at the back of my mind, but he was being very kind.
So then around summer of 2019, you actually make arrangements with Doug. He's going to move into your mom's house.
He wanted to move in. Yes.
You actually agreed to that.
Not specifically. He didn't really ask my opinion. He told me.
Okay. And then the date that he was supposed to move in, you made plans with him,
Hold on a
correct?
second. Sir, who's crinkling the paper? Is that Mr. O'Keefe? Sir, can you please stop? Thank you. Go ahead.
So during this time, you're speaking with Doug,
Yes.
right?
Yes.
And you're talking with him about moving into your home.
He was insistent that we needed to
The
move in
answer is
together.
yes or no, please. You were talking with him.
She's interrupting the answer.
If the question calls for yes or no, the questioner has the right to expect a yes or no, or I don't know, or I don't recall,
So
as opposed to a narrative.
You were speaking with Doug about him moving into the house
Yes.
and about his things being moved and when they were going to be moved.
Yes, I'm sure.
And at any time
They should have
during this,
smashed
did
her
you
head
say
into
to
the
Doug,
desk. This is so
no, you're not moving in?
wrong. It's
yes.
just like
You said no.
I'm sorry.
You told him, no, he cannot move in?
Yes, that's why he ultimately didn't move in. As I said,
Okay.
I can't do this.
Isn't it true that, in fact, you didn't tell him no, you just weren't available the day he was supposed to move in?
No, that's not correct.
Okay. So you're saying the day he was supposed to move in, He knew he wasn't supposed to move in? Is that what you're saying?
We had a conversation that day and I told him that I didn't want him moving in.
I'm hiding something behind the box. No, I'm up in the corner, out of the way. This is not, none of this is helping the state right now. I don't see the prosecutors doing this and going, ha ha, I've got her where I want her. Yeah. What's in the box? What's in the box? CL juice. Okay, I'll believe you for now. Well, thank you for believing me. All right, let's just keep going here.
Okay. And then you did not take his phone calls. You would not speak with him. I think the word was ghosting. You ghosted him.
I don't know whose word that is, but that's fine. Yes, ma'am.
Okay. But visitation continued.
Yes, ma'am.
All right. And you continued to exchange custody of Emerson where? The sheriff's office or?
I believe at the time we were doing the sheriff's office.
And sometime around this time, you show up to this visitation with an engagement ring on, right?
No, ma'am.
Okay. Who is Dennis Beatty?
Dennis Beatty.
Beatty. Who is that?
He was a gentleman I dated at one point.
And it was during this time that you were dating him, right?
After I told him not to move in, and then we started just doing time sharing with Emerson. Yes, after that, there was a period of time where we dated. Yes, ma'am.
And isn't it a fact that Doug filed for a divorce after one of these visitations?
I'm not sure when he filed for divorce specifically.
Okay. He filed for divorce after he knew that you were dating this other man, right?
Once again, I'm not sure when he filed.
How did he find out? Did you tell him you were dating him?
No, ma'am.
Okay. How did he find out?
I think he was stalking me.
It wasn't the ring on your finger?
It was not an engagement ring. Ma'am.
Well, it was a ring. Did he see the ring on your finger?
I'm not sure what he saw. I wear rings all the time.
Okay. So Doug files for divorce. And all of a sudden you file for, you start a bunch of complaints about his treatment of Emerson. What you say, his bad treatment.
Well, she started coming home hurt.
It's a yes or no question. Did you file complaints about his treatment of Emerson?
Yes.
Okay. And you eventually filed for another petition to get an injunction based on those incidences that you claim happened with Emerson.
Yes, ma'am.
Okay. And you complained about the first time and nothing was done. Is that correct? With the police, no charges were filed, nothing was done?
I'm not sure specifically what you're referring to.
The first complaint that was made
About
Emerson and Doug, you agree that you made allegations.
Jack, can we approach?
Yes.
Yeah, I just don't see how this helps anybody right now. Julie says, ask Doug, oh, wait, I did the world a favor, so he's not here to answer your questions. Cunt. Yes. A ring on a finger means she's engaged? I don't know. This is not, she is sounding like a complete asshole right now. I don't know how this prosecutor thinks it's helping her. Oh.
During this time, did you speak with members of the sheriff's office?
I'm not sure specifically what time you're referring to.
During the time that there were allegations that Doug was abusing Emerson, did you speak to the sheriff's office?
Yes, ma'am.
On numerous occasions?
I would say so, yes.
At least 5?
Probably yes, ma'am.
And during those conversations, you were making allegations that Doug was abusing Emerson, right?
Well, I was explaining the injury she'd come home with. I mean, I wasn't there. I don't know what happened.
Okay, but you were alleging that Doug was abusing the child.
I was concerned after her pediatrician called CPS and said that she thought she was being abused.
Are you aware that pediatricians are required to call CPS when a mother alleges that?
I didn't allege anything. I brought a video to show her at the appointment, and she called
So you
CPS.
Objection.
Thanks for answering.
Well, after showing her a video of some behavior, she called CPS and she informed me that I was also a mandatory reporter and that it would be negligent if I didn't also call and make a report.
You brought Emerson to the pediatrician specifically for this reason, correct?
No, ma'am, she had her checkup.
But you brought this up to the pediatrician.
At the end, she asked if either of us had any questions.
And that's when you bring up, oh, she must be being abused.
No, I I described to her the behavior that I was seeing, and I showed her a video when she came to her own conclusions.
Okay. So you spoke to the sheriff's office about that investigation and other investigations, and about that investigations that Doug was abusing Emerson.
A sheriff usually comes out with the CPI from Child Protection.
And you spoke to them.
I mean, they were there when I was talking, I guess, yes.
And you were talking, making allegations against Doug, assuming that he caused injuries to Emerson.
I'm not sure of my exact words. I was trying to describe to them what I was seeing and my understanding of the situation at the time.
You filed a petition for an injunction based on those things, correct?
At the advice of my attorney, yes, ma'am.
Okay. Whether your attorney advised it or not, you chose to do that, correct?
Yes, I followed the advice of my attorney.
And you were aware that if you went forward on this injunction, that it was going to be in front of Judge Moreland.
Yes, ma'am.
And this injunction hearing was supposed to take place on September 30th of 2020. Yes, 2020.
Yeah, it got moved several times, but that was a date.
Okay. So it was supposed to take place on that day.
Yes, ma'am.
And there were other things pending. Do you know what the other pending items were?
Not specifically.
Okay.
I'm not sure what you're asking.
One of them was Doug's request for a divorce, correct?
Yes, we both filed for divorce at that point, yes.
So Mr. Benefield filed for divorce, you file an injunction petition, then you file for divorce.
I filed for divorce first.
Okay. And then you're scheduled to have this hearing.
Yes, 9:30, yes.
And you're speaking with Doug during this time, right? I mean, we just heard 200 and whatever text between you and Doug.
Yes, ma'am.
So
Yeah.
do you at any
Doug sounds
time
like an
in that
asshole.
say to him, I'm going to go forward with this injunction on Wednesday, on the 30th?
No, ma'am.
In fact, based on those text messages, you were dropping the petition for an injunction.
Yes, we talked. Yes.
No, you talked about it, but you said you were going to.
Oh my
Yes, ma'am.
God.
And that is what the result of the mediation was. That there was not going to be any immediately because you were reconciling.
Yeah, we agreed, I guess, in order to move to Maryland. And the attorneys were advising us to, if we close things down, that it would make it easier, like legal wise, for us to relocate.
So you were telling Doug that's what you were going to do
Yes, we were trying to work things out so we could all go to Maryland, yes.
and drop the injunction.
That was one of the things.
And you wanted him to drop everything, right? The motion to release the report, the dissolution of marriage, you wanted him to drop everything.
Yeah.
No, we filed a joint stipulation so we could get the report.
But then you asked him to drop that, didn't you?
I know we kind of went back and forth with so many things.
Okay. You never had any intention of not going forward on your injunction.
Honestly, it was kind of one of those things that some days I thought that maybe I should, and some days I thought that I shouldn't.
So during this 1 week before you shot, you're talking and you're saying things like, oh, we're packing boxes, we're getting everything together. This whole time, you knew you weren't going to stop that injunction hearing.
I hadn't decided yet.
Okay. Your attorney testified that you were going forward on that injunction hearing.
She was advising me to keep it.
Okay. So during this time when you're telling Doug to bring different boxes, bring tape, you asked him to go to Selby Gardens, right?
Yes, we all went. I think we got lunch. We got Emerson so she could play.
Okay. And you are having conflicted emotions about whether to go forward on an injunction
Yes, ma'am.
while you're out having these types of experiences with Doug.
Yeah, sometimes things are really good and other times they weren't.
Okay. And so how about, let's see. This is part of State's Exhibit 98.
What's
I didn't know what it's doing. I think it's giving you clues that I gotta guess.
Yes, it almost sounds like a conflict.
Get real. Real.
Working mother, not a working mother.
Working mother, not a working mother.
Not a working mother.
Guys, I've been watching the fucking thing, okay? Please don't stop. Oh no, chat. Here's what the prosecutors say. You laughed. Were you truly being abused? That's our next statement. You laughed. Were you truly being abused?
People are really
Oh, no, it's running out of time. House. Real house. White. Housewives of.
And this video was before you shot him, right?
I don't know the exact date.
When was, I mean, in your mind, it was very close to the time, correct?
Yeah, I'm sure it was right around the night. I don't remember when it was.
And during this time that you were having these text messages with Doug and you're planning to move to Maryland, there's no violence going on.
No.
No?
I guess not, no.
He's not hitting you.
No, ma'am.
He's not choking you.
No, ma'am.
He's not shoving you around.
No, ma'am.
So this entire time, there is no violence going on.
I don't know specifically what time frame you're talking about. I'm sorry.
But during this, let's say from 2018 to 2019, when you're not living with him.
I mean, if you classify violence as him like
I'm asking
punching
if
me or
there's
choking
physical
me.
violence
I mean,
during this time.
he could be rough sometimes.
Okay.
Yeah.
Did he ever punch you?
Not during that time, no.
Did he ever hit you?
No, ma'am.
Did he ever use a weapon against you during that time?
Not during that time, no.
So in between the time of 2019 to 2020, where you shot him, was there any physical violence?
Like I said, sometimes he'd be a little rough, you know.
But other than that, he never was physically violent.
He didn't like punch holes in the walls or anything like that, no.
So when I asked you if has he been violent, you said, well, he didn't punch holes in the walls. Is that what you just said?
That's what I just said, yes, ma'am.
So punching a hole in a wall to you is a definition. When I ask, was he violent? Your definition of that is punching a hole in a wall.
I think that is violent.
Okay.
I'm not sure what you're asking.
So hang on just a second. So I want to get to the day that all of this happened. This happened on a Sunday, right?
Yes, ma'am.
And you're moving on, or you have a hearing on Wednesday,
I believe that's correct.
and
Yes,
you're
ma'am.
moving right after that.
I think the actual day of move was kind of in flux. It seemed like it changed 1,000 times.
You're all getting in the car together, not together, but you're driving cars together
To
to go to Maryland.
I believe he was going to be driving the U-Haul and pulling his truck. And I think that my mom was driving her car and I was driving mine.
And you were telling him during that time that you were going to move to Maryland and attempt to reconcile.
No, ma'am.
You weren't telling him that.
No, not in those words. No.
Did you hear Dr. Broder testify about that? That he said that when you were with Doug,
Objection here. Sustained.
so you're denying that you ever told Doug that you were wanting to reconcile with him.
I said I wanted to find a way that we could do things together as a family for Emerson's sake, you know, and that's why we started doing things differently. He wanted to move back in, you know, together, and I told him that I didn't want to do that. I didn't feel comfortable with that.
Did you say that in Dr. Broder's office? In front of Doug?
No, not in front of him.
So when you're with a safe person, a psychologist, you're not telling Doug this.
What? I'm sorry.
You're saying that you told Doug when it was just the two of you that you didn't want to move in together. And you felt safe telling him, I don't want to move in with you. Right? Same.
Yes, we had that conversation many times. Yes.
But you're in front of this psychologist who one would think is a safe environment with Doug sitting next to you. You hear Doug say to Dr. Broder, we are going to Maryland and we are going to try and reconcile. And you don't feel safe enough to Dr. Broder? No, that's not what I want to do.
I would want to make him look bad in front of somebody else.
Okay.
I wasn't going to disagree with him in front of anybody.
Okay. So the plan was to load up the truck, get everything done, and then move very shortly after the court hearing, right?
Yes, ma'am.
Okay. And you had no intention of dropping that injunction. So you knew on the day of that hearing, he was going to know, right?
I'm sorry.
You knew that Doug was going to know that you had no intention of reconciling with him.
We had the conversation many times. I think he understood where I was at.
Okay. You saw the text messages between you and him, right?
Yes, ma'am.
Would you agree that those text messages do not indicate that?
It doesn't say we're getting back together, moving in together.
It doesn't say we're not going to reconcile.
I mean, not specifically. No, I wasn't going to argue with him.
If you got your injunction on that day, September 30th, how would you have moved together?
Speculative.
Same.
What was your plan if that injunction was
Speculative.
granted?
Different question. Over the-
Objection. Speculative.
No, you can approach.
So if the injunction were granted on that day, what was your plan about moving to Maryland with Doug?
I don't know that I really had a plan. I wasn't even sure whether or not I was going to go through the injunction at that point.
So there's something funny.
Take care.
Okay, so I want to get to the night that all this happened. So you knew Doug was coming over.
Yes.
You invited him over
Yes.
to help you move stuff in the house,
Well, specifically stuff in the garage, but yes.
stuff in the garage to the truck.
Mhm.
Right. And he came to your house a couple of times. He came and then left and then came back again.
Yeah, I believe he came twice that day.
And there is a gate to your community.
Mhm.
And when he's at the gate, you had to let him in.
Sometimes, because he was frequent in and out, sometimes the gate remembers license plates and sometimes it opens and sometimes it doesn't. Sometimes he would just follow people in. The gate kind of stays open for a while. But yeah, sorry.
But on this day, you weren't concerned about him coming over.
No, I knew he was coming.
Okay. And when he came over, your mother and Emerson went to the park.
I believe they were headed there. I'm not sure. I think they were down the driveway or on the sidewalk, something like that. They were on their way there.
You weren't so afraid that you wanted your mother to stay there and watch.
No, we were just packing to move.
Okay, so you weren't afraid.
I definitely didn't expect this to happen.
So it was up to you that your mother left.
Yeah, at that time.
Okay. So if I heard you right during your direct, you said he bumped your shoulder twice. Body check. I don't know if that's what you called it. He walked into you with a box, right?
Yes.
And then at the end, you say he slapped you?
He hit me. I wouldn't know how to classify it. He struck me. He hit me.
Was his hand open or closed?
I don't remember.
Okay. And because of those things, you claim that you thought he was going to kill you.
He had never hit me before.
Okay. And you thought he was going to kill you.
He wouldn't let me leave. I tried to leave. He stopped me.
The question is, you thought he was going to kill you.
Yeah.
Okay. Now, when you were in the bedroom, you decided to get your firearm. And it was where?
It was in a storage bin on top of the laundry basket.
Okay. So I'm going to show you State's Exhibit 52. If you could turn around and look at that. Where was your firearm?
It was in the bin on top of the basket.
Here?
That's the basket.
Where was the bin?
It's that right on top.
Okay. So it was in here.
Yes, ma'am.
Why would you have a firearm in there?
I had just emptied all the furniture and everything out of my room, and it was kind of like what was left from my drawers, and so it got put into a bin.
Okay. And that was not your only firearm in that room, correct?
Correct.
You had a firearm in the closet.
My carry gun was in my backpack, which was my purse at the time.
So in this room, with a mattress and a broom and a hamper, you had two firearms.
Yes.
So you go into the room and you grab your firearm. Is it in a holster?
I don't remember.
Okay. And you claim that Doug does what?
He came and slammed the door open. He was standing in the doorway. He said, "You're fucking done."
He said, "You're fucking done." And that made you fear for your life.
Yeah.
Can we turn the lights up, please? Thank you. So he says, "You're fucking done," and you point the gun and you shoot.
I held it out in front of me first so he could see it. And I said, "Stop."
If, Judge, if I could have her step down so she can demonstrate.
You may.
If you could just come down. So Doug opens the door and does what?
I'm standing in the doorway, kind of like this. He said, "You're fucking done." And I hold the gun out in front of me and said, "Stop." He got into this like fighting pose where he like turned sideways. And he was like moving around with his like arms in his hands. And he started like inching forward towards me.
So he why do you call it a fighting stance?
Oh, he looked like a fighter. Like a
Okay, guys, and this right here is why the prosecutor, she has just completely tossed it. She doesn't know how she's going to react. She's not going to help you here. You are literally, guys, I'm listening in the middle of handling other things. Okay? I got it. I'm here with you. This is not going to be seen by anything as the jury other than bullying this woman. They're just bullying her at this point. This is it. They just lost the case. They are literally bullying and humiliating this woman. This is very disgusting. Yeah. This is just, it's no bueno, chat. No bueno. Do not ever do this.
I don't know, like a ninja or something, I don't know.
Okay, so he's standing there, he turns to like this and starts moving his arms around.
Like that.
Well, show me, what was he doing?
And like I don't know, he got like this, and he was like making like fighting motions. I don't know, I'm not a fighter, I don't know.
Okay.
It was scary.
Did he have his hands in fists?
Not at that point, they were like, I don't know.
Was he coming at you like this?
When he lunged at me, he came very quickly.
Okay, so he lunged. Was his fist up when he
I
lunged?
don't remember.
So you start shooting, and he does what?
He kept coming at me.
Okay, so then you keep shooting again. And he falls down on his back.
His legs went up in the air.
Okay, where do his legs go?
In the air.
How high in the air?
I don't know.
Do they go over his head?
I don't know, it's like his feet slipped out.
Okay.
And his feet and his legs went up in the air.
And were you still shooting at the time?
I don't remember.
You can have a seat. So after this incident, you claim that you had swelling to your face, right?
It's going to take a minute. All right, here's the jury. Can you please close up your notes, put them on your chairs. I'm going to ask you to step out for a minute. You can use the facilities. It's not quite our mid-afternoon break, but we'll treat it as such. Please don't discuss this amongst yourselves. Don't discuss it with anybody outside the jury. Don't do any research like we talked about. All right, the jury's out. You can have a seat.
Sorry.
All right, we'll take 5 minutes.
Thank you.
Yes.
So there you guys go. That is all right, guys. I'm on the phone right this second, but that right there. You think she's faking that? I guarantee you that jury thinks that's 100% credible. That was if that was like you guys want to sit there and laugh at her and say that wasn't real. Are you gonna say Kyle Rittenhouse wasn't real? That was Kyle Rittenhouse up there having a PTSD attack. You guys thought Kyle Rittenhouse was real. That was real. And if it's not, good for her, because that was very convincing. This is not how you prosecute a case. So, are you hearing words? Can you? Okay, can you guys not hear me? She's playing. Yes, great success. That's how it works. I'm the victim. I defended myself. That's how it works when you're doing self-defense. I'm the victim. That's how self-defense works, man. That's how you do it. I'm the victim here. Like, duh. You have to be. Otherwise, it's not self-defense. But like, you know, Cedar Rose, you're saying, why are they not objecting? There's nothing to object to. She isn't badgering, and sometimes you're going to let her up there, like letting her get some punches in on your client. Well, you made her look like the bad guy. Sometimes you let your client take a couple of hits. But there's not a whole lot they could challenge right there. That was her just being prosecutor. Those were valid cross-examination questions. And then great success as she cries for herself. Like, yeah, because she thought she was going to die. I mean, oh, well, she's doing it well. She's doing a great job. Prosecutor played right in her hands. And Julio says she's not a prosecutor. She's a prosecunt. Yep. And I can't remember. It says been a member for 2 months. Thank you. Thank you. And then real quick, Shredder is saying if the judge were compelled, could he order a directed verdict off her testimony? No, not like that. Absent like some massive misconduct issue from the state, no. He's gonna have to wait till the end. Aaron says, how convenient that she's seen all the prior testimony. The state's investigator gets to see all the testimony too. I'm just saying, like, yeah, that's how it works. You have the right to confront your accusers. So, just saying. Matt B says she planned this to happen. Okay, fine. Prove it. Prove it. I don't think they can prove that. Yeah, why would you object to the prosecutors going off the rails? Yeah, I mean, she was holding her own. Access, how do they lose a self-defense argument there? They haven't lost it. The state just completely ruined that by looking like assholes. Yes, this is also true. A woman crying for herself? I've never heard of this phenomenon before. The dead wife made it clear he was even sexually controlling. Yeah, it's not a surprise based on the way he talks. So, yeah. Great success says you can't just shoot people willy-nilly. Well, there's no evidence she did that. It sounds like he was about ready to whoop her ass and she didn't want to find out. So, if Doug Benefield wasn't a fucking asshole, he might still be alive. Oh, Ag saying no. How did she lose the stand your ground hearing? She didn't present convincing enough evidence. And that's the thing. This is not a stand your ground case. This is a sketchy. Guys, remember when I talked about these self-defense shootings? Remember when it's like one of these kind of in the gray? Ashley Benefield is really in the deep in the gray zone. She's far from good and far from bad. It's not clear. So it's not a surprise she lost that. It's not a surprise she lost that. And you shouldn't be surprised she lost it. Otto says he didn't touch her and she shot him. He doesn't have to touch her to shoot him. If he says, I'm going to kill you and starts walking towards her and doesn't stop, she can kill him. Luke is saying it's the state's burden to disprove self-defense by clear and convincing. Yes, but she still has to introduce, I was scared, I feared for my life. And at the stand your ground hearing, she didn't do a very good job. It wasn't enough out there. So that's why they lost. And it's the pretrial hearing. She would not have testified. Most stand your ground hearings, you end up testifying. So it's not abnormal. So, all right, guys, let's keep going. Let's keep going. I don't remember Travis Rudolph. I like by name. I don't remember him. What was it about?
All right, y'all can have a seat. Welcome back, everybody. Usual questions. Did anybody discuss the case or anything about the case amongst yourselves with anybody outside the jury or do any research? Everybody says no. You may resume your cross-examination.
Thank you. Can we dim the lights again, please? Thank you. So after this incident, you said you had swelling,
Yes, ma'am.
and that would be to the left side of your face?
Yes, ma'am.
And that would be where? Show me where.
Like in this area.
Now, I'm going to show you State's Exhibit 103. I'm going to put it up on the big screen. Can you tell me what this is?
It's a picture of me.
And when was it taken?
I have no idea.
Was this taken before you met Doug?
I believe so.
And I'm going to show you Exhibit 104. And I'll move it up a little bit. When was this picture taken?
I believe in October of 2020.
Wasn't it taken on November 4th of 2020?
I believe that's correct. I'm sorry.
Thank you. I have no further questions.
Redirect. All right, man. You can retake your seat. Just leave that exhibit there. No, you can take your water. I meant the paper.
Okay.
There you go. Clerk, thank you. All right, defense, call your next witness.
I believe it's Mara Sweet, Your Honor. We're just checking to make sure she's here.
Judge, I think we need our conversation.
Okay. So we can have our legal I'm sorry. So I'm going to let you step to the back so we can have our legal conversations. I'll get you back out as soon as I can. Don't begin your deliberations. You're free to use your phones, but don't communicate about the case with anybody outside the jury. Don't do any research on those things.
start on that? Can the clerk just confirm she got all those exhibits back? I just,
Right, you can all kind of see,
okay,
she
thank you.
count, she counts them on a regular basis.
Thank you. I just didn't want to have it over here.
I'm sorry.
Okay, so we got a proponent, we've got an objection. Is the witness in here?
She's right outside.
Okay, good. I want to make sure she stepped out. Okay, so the defense has called Miss Sweet, who apparently is a former prosecutor in the 12th Circuit.
Yes.
And she, if I understand correctly, she was assigned in the misdemeanor division, the domestic violence division, and the case, the alleged violation of domestic injunction regarding the T-set was assigned to her.
Correct.
And you expect her testimony to be that she intended to file the charge, she was waiting on some receipt,
Receipt of the package.
like a mailing receipt,
Yes.
that would have shown what, the return?
That Stephanie Murphy gave to Detective Gillen.
And then you believe her testimony would be that she intended to file the charge, but then she was transferred out of that division.
She left the office.
They left the office, okay. Because that's one of the temporary assignments that they give to misdemeanor folks. So she left the office, and that's it?
Well, and her training, based on domestic violence training, she believed Ashley to be a victim of domestic abuse, and that Ashley exhibited all the symptoms of domestic abuse. In particular, remaining quiet as a result of intimidation, and going, for example, the state's case is predicated on Miss Benefield going along with Douglas Benefield. For example, on the first parent sharing exchange, and the week leading up to the shooting, they put in those 263 text messages and the video at the restaurant, all showing Miss Benefield in Mr. Benefield's company as apparently happy and not afraid. And abused, those are the classic symptoms exhibited by abused women. They are afraid to reject the abuser for fear of reprisal. And what happens is, after a while, they reach a state of compliance where physical threats are no longer necessary because they know what the potential is. So they become compliant. That's also what Bruce Ferris is going to enlighten the jury on. And I remind the court that this is the state's theory. They have put into play, they injected it, they raised it, initiated it, that because Miss Benefield didn't look scared in the company of Douglas Benefield, and that she was exchanging these text messages with him for the week leading up to the shooting with smiling faces and basically compliant behavior, that shows that her claim to fear of Douglas Benefield on the 27th is a fraud. And we now need to explain to the jurors why an abused woman would act like that and would, for example, not agree to be present at the first parent sharing exchange. When a child is involved, it magnifies the situation, so that the mom, if she's afraid of, in this case, Mr. Benefield, because of prior acts of domestic violence, she's even more afraid for her child. So the mother's going to make it a point to accompany the abuser in an effort to protect her child. That's what we are now obligated to show to properly defend this case. And we can do that through the training and expertise of Samar Sweet, as well as Bruce Ferris.
Judge, first of all, this witness was not listed as an expert, because if she had been listed as an expert, I would challenge the qualifications to be an expert. Just for your honor's knowledge, we did not have a domestic violence unit at the time. I know our office has in the past. We did not have a domestic violence unit, so she was not in any domestic violence unit. Even if she were an expert, there is absolutely no way that she could testify that she felt that Ms. Benefield was exhibiting behaviors of an abused person. I think it's completely improper. And the issue of the decline of the injunction, or the fact that Ms. Sweet intended to file, is irrelevant. I can tell your honor, and for the court's knowledge, it's because when we got the receipt of when that package was sent, that receipt showed a date that was a problem for us. And that is why that case was declined. So the decision was made after Ms. Sweet left the office and we received the receipt. So the would be testifying I believed her and I wanted to file it is completely and totally irrelevant.
Yes, sir. Rebuttal?
Yeah, so the court may recall that Deputy Weber had issued a habeas for the arrest of Douglas Benefield for the delivery of this package. Detective Gillum came into court and told us that he suspended Deputy Weber's request for a habeas. And we have a communication from Deputy Gillum that we got by way of a public records request where he acknowledges plain as day that it was a violation, that it was during the time that the South Carolina injunction was in effect. But he nonetheless refers it to the state attorney's office. This is the assistant state attorney that was working that case. She would testify, we'd like to put her up for a proffer, that she fully intended to file. She believed it was clearly a violation based on the fact that the court.
Well, I'm just saying, if you want to proffer, let's get her in and proffer, because then all these arguments would happen after the proffer.
Okay.
I mean, but I haven't made a ruling, so you can make your argument, I can make a preliminary, you can proffer.
Yeah.
Okay. Mr. Taylor, you didn't go outside. So listen, how about I do this? The jury's out. It's about 3 o'clock. I'm thinking maybe give them a 20-minute, a longer afternoon break. When I do that in the afternoons, I will typically have a deputy escort them down to the jury assembly room where they can kind of spread out. The machines are there, the restrooms, but deputies are with them. Okay? All right, deputy, can you excuse them until about 3:20? We'll get them back up as soon as we can. Thank you. Yeah, it's a proffer.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth. I do.
Cool, man. My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself now. Make yourself comfortable in this seat. Pull yourself up so you're about 12 to 15 inches from that microphone. There you go. To adjust up, down, left, right, however you need it. Speak in a loud, clear voice. You'll hear everything. As you can see, I'll tell you, you're a former prosecutor and attorney. Jury's not here. At this point, the defense is going to proffer your testimony.
Okay.
Afternoon, Ms. Sweet. Will you tell us your full name and spell your last name?
Yes, Samara Sweet, SWEET.
Are you currently employed?
I am.
What's your title and where are you employed?
I am the trial lead of counsel at Lydecker, which is a civil litigation firm.
All right, and you're a Florida bar licensed attorney.
Yes, sir.
At one point, were you a staff attorney for the Manatee County State Attorney's Office?
Yes, I was.
How long did you serve in that capacity?
I was there from 2018 to 2022. It's about 4.5 years, I believe.
All right, and during that 4.5-year stint, was there any special assignment that you held?
I began with the misdemeanor division here in Manatee County. After 6 months, I moved to Arcadia. So I was in DeSoto County, where I started in misdemeanors and moved up into felonies, where I would have dealt with anything from possessions of controlled substances all the way up to child sex crimes and murders.
Specifically, did you have any training in domestic violence?
We did. Every attorney at the state attorney's office does go through CLE's trainings on how to deal with domestic violence victims, because especially when you're working in the misdemeanor portion, a lot of your crimes are batteries and a lot of them are domestic violence victims.
Can you give us an idea of how many cases you handled involving domestic violence?
Oh, I think at one point my caseload was 700 when I was in Arcadia, and at least.
All right, chat. So what do we think right now? Guilty, not guilty? I mean, where do we think we are right now? Is this guilty, not guilty? Because it's done. It's done in my opinion. I mean, it's over. I think. So, I mean, like, how do you come back from this as the prosecutor? I don't know. Yeah, a lot of not guilties here. I'm gonna do a poll, but I'm just asking you guys. Like, I don't know how she comes back from this. I don't know how she comes back from this. I will do a poll. I'm kind of speaking rhetorically as well. Shredder, you can't save polls. Like, they're gone. So I can't compare them. There's no way to save the polls. Joseph says, what was the turning point? I mean, she sat there and basically bullied the fuck out of that lady. I mean, there's no way a jury's going to buy it. I've been not guilty because I don't think they've proven the case, but now they've convinced me she probably was justified in using force. So
A third of those were probably something domestic violence related.
Did you deal with not only abusers, but the abused?
Yes, most of the cases I had as a prosecutor, my victims were abused individuals.
Were the majority of your victims in domestic violence cases females?
I would say a large amount were females, yes.
Were you assigned, while in your capacity as an assistant state attorney for the 12th Judicial Circuit, were you assigned to a matter involving Ashley Benefield?
I was, yes.
How did that come to pass?
So when I was in Manatee, I had the caseloads with all defendants that had the last names with B, V, or I. So Ashley Benefield's case came to me and she was the victim in the case that had been assigned to me for a violation of an injunction.
Do you recall specifically the nature of the violation?
It was a package that had been delivered to her allegedly from her ex-husband.
All right. And the domestic violence injunction that was violated, do you recall from where it had been issued?
It was from out of state. I believe it was South Carolina.
And did you meet with Ms. Benefield?
I did.
Do you remember on how many occasions?
I believe it was twice because when the case first came, there's elements to a violation of injunction that have to be met. We had not yet had all the information, so I did meet with Ms. Benefield, got some more information, and then had to follow up on the investigation and had to meet with her again after that.
Did there come a point in time when you made a filing decision?
I did not. I had left the office before a filing decision was made. I had been moved to Arcadia at that point.
I should have articulated that question better. Had you, as part of your investigation, individually reached a conclusion as to whether or not you felt it justified going forward and charging?
I did. I think I was still waiting on some information to prove if the package had actually been sent by Mr. Benefield. And that was the last information that I had left to my predecessor before I left. But I did think that if that information was given, there was enough to file.
And would it help refresh your recollection if I suggested that you were waiting on a copy of the receipt for the package?
Yes, I was waiting on to see who had sent that. And I know I had been in contact with the officers involved.
Do you recall whether or not you were dealing with Detective Gillum?
That I'm very bad with names, so I do not want to say yes or no, sir, if it was Detective Gillum or not. That does sound familiar, but I might have worked with him on other cases as well.
All right. How was Ashley Benefield when you first met her? Can you describe her demeanor?
Yeah, she was very upset. She seemed scared, worried. She had come to my office and she was crying when she was sitting in my office with me.
There's a poll up.
I did think that she was worried about the package that had been received.
Now, was it your practice generally to always meet with the victims in the cases that you were prosecuting?
Yes, it's office policy.
Had you formed an opinion about the genuineness of the fear that Ms. Benefield expressed?
I did believe that she was in fear and worried about that.
And from the investigation that you conducted, did it vindicate, other than the actual label for the package, the factual representations that Ms. Benefield had made to you?
Can
Want me to restate that?
Yes, please.
Yeah, that didn't come out too good. Did your investigation corroborate the facts that Ms. Benefield related to you?
It did. Yes, there had been a package received. The package, I know she believed had some weird smell coming from it. And my recollection was that had been investigated, but the package had been delivered to her. I think she said it was close to her birthday around that date. I can't remember exactly, but it did. The facts that I had investigated did lead up. South Carolina, when I reached out to them, had said they had given an injunction for her.
All right. And do you recall contacting the toxicologist with respect to the contents of that package?
I did. She had brought me a toxicology report on that meeting. And I did call the doctor Now, in all candor, I can't confirm if that's exactly the doctor, but I did speak to someone on the phone who said that Ashley did have weird things in her blood system at the time that did not correlate to someone's normal toxicology. But she couldn't say from where that had come from, but that there were abnormalities in that report.
And you say you have considerable experience with women who have been victims of domestic violence?
Yes.
Is there a certain pattern in your training and experience that you see in these women?
Yes. So a lot of times we'll have a lot of these meetings involve an abuser. We have the abuser who has abused someone. By the time they're coming to us, a lot of time has passed. So we always want to explain to them that normally we see a cycle. You have an abuser, he does something wrong. Then it's, I'm sorry, I'm very, very nice. They come back. And then we end up again in this situation with more abuse.
Kind of like a hamster wheel.
Yes.
Did you form an opinion as to whether or not in your discussions with Miss Benefield that she fit the profile of an abused woman?
I did. When we discussed, she did seem that she had been isolated at that time. She was very scared. The way she had spoken to me did give eyes. She had mentioned some minor physical issues that had been occurring, but abuse doesn't always have to be physical. Sometimes it's psychological, mental, emotional. And she was in my office when she was sitting. She did seem to be presenting like that.
Is it a pattern and practice of abusers to employ psychological intimidation?
I mean, normally a lot of the times in the reports I would have, we would have something of threats or some sort of information leading up, text messages, Facebook messages, things of that sort.
And let me ask you this. Are these abused women, despite their fear, often in the company of the abuser?
A lot of times I've seen them return back to their abusers, yes.
And have you experienced abused women when in the company of the abuser acting as if everything is fine?
I wouldn't be able to say I've seen them with their abusers, but a lot of times if we were in court trying to present, I would see them come in to defend the defendant that we had or to withdraw claims and that kind of thing.
I guess the point of my questioning is merely because the woman appears content, is that an indication that she's happy in the company of the abuser?
No.
Why is that?
Just, I mean, I have more facts by the time I've seen the investigations, I've seen interviews, things of that sort in our caseload. They might be presenting, telling the judge something, but clearly we've seen, you know, photos of abuse. They've sat and given us recollections of abuse, that kind of thing.
You left the office before you were able to actually conclude and file a charging document.
That's correct.
And as you sit here today, do you know what the disposition was?
I believe it was decided to not move forward, so it was dismissed.
That's all, Your Honor.
Close.
When you were in the misdemeanor division in Manatee, I think you said 6 months.
Yes.
So what was the time frame then?
I know I had started, I want to say April of 2018. So it would have been 6 months from there because I think I got out to Arcadia around October, November-ish.
Okay. And was the misdemeanor job in Manatee your first job out of law school?
No.
No. Okay. Did you work? Where did you work before that?
Before I worked with Eric Reisinger, I actually did criminal defense.
Okay. Okay. So when you talked about the domestic violence training, were you referring to the domestic violence training at the state attorney's office?
Yes.
Okay. And was that the normal domestic violence that everyone is sent to the class?
Yes.
And how long is that class?
I think it's 4 days.
And is there any other domestic training?
I know the office does some pretty good domestic training. They'll do PowerPoints, luncheons, things of that sort. I think there's some, I don't know if they still do it because now I'm aging myself, some field trips to like the TILA and some of those organizations that work with abused women.
Okay. Thank you. I don't have any other questions.
Thank you.
No, I think that's all.
All right, man, could you step back out to the hallway, please?
Yes, sir.
All right. She's out. Proponent, you can start with your, there you go. She's waiting in the ante room. Now we got her in the hallway. Proponent of the evidence, argument.
Yes. So, Your Honor may remember that Detective Gillen made the allegations 2.5 years later, despite the fact that there was no earlier report documenting what he alleged 2.5 years later in any of his 2 or 3 prior supplements, that Miss Benefield acted completely inappropriately, that he did not believe that the
South Carolina domestic violence injunction was in effect because even though the hearing was on November 3rd, the judge hadn't signed the order till the end of the month. And therefore, he countermanded Deputy Weber's request for a capias. This witness impeaches the statement by Detective Gillum because she was the assistant assigned to the case at the time, and she had made a decision that, in fact, she was going to file, but for the fact that she left the office beforehand. She had conducted the investigation, completed it. All she was waiting on was the label of the package, which, interestingly enough, the court may recall, Detective Gillum recovered from Stephanie, but it apparently didn't make its way to Samara's suite until after she left the office.
All right. And the objecting party?
Judge, I would object. I don't think she can testify as to anything she just testified to. I think most of it is opinion, and she is not an expert. And even if she was an expert, she wasn't listed as an expert, so she cannot give opinions.
She's a lay
And
expert.
any
She can
opinion
talk about experience.
Whether someone, as a prosecutor, whether someone violated the law or not is inappropriate testimony for court. A lot goes into filing decisions. The prosecutor has discretion the same way police officers have discretion. To add any significance to that, I think would be completely improper. And so I would object to anything to do with her decision-making with the state attorney's office. And also, as I said, I think there was some information that was gained after she left that played into that decision. But additionally, I think she would not qualify as an expert in domestic violence. And I think even if she could, a lot of those things would be inadmissible anyway, what she would say.
All right. Mr. Taylor, do you have any final thoughts you want to put on the record? Any final thoughts? Rebuttal?
That's good.
All right, thank you. So one of the very things about this case as we've gone along is there's been some very, I think I said the other day, unique legal arguments that have been made. Certainly, I would like to think it's in honor of the Olympics starting tonight that you guys have put me through my mental gymnastics for the last couple of months. You know, another judge that's here in Manatee County, I hear him say this a lot, and I think it rings true. There are some very difficult decisions that we make as judges, emotionally difficult, legally difficult, factually difficult. This is not one of them. This is a very, very clear and easy decision. I'm going to put the part about Ms. Sweet offering any sorts of opinion as an expert kind of to the side because I resolved this matter well before I consider that she wasn't listed as an expert and the Richardson aspects of that. And what I want to focus on is the purpose of allowing these other incidents of violence or threats is, as we all know, it's one of the carve-outs of obviously case law provides an exception in stand your ground and self-defense cases for battered spouse syndrome. Normally, any peculiarities for a particular defendant, PTSD, low IQ, mental health are the ones that come to mind quickly, are not relevant and not admissible in a self-defense case because it's a reasonable person standard. So battered spouse syndrome is the carve-out, and the idea by once the defendant has laid the predicate of the overt act, allowing either reputation, and if it's reputation in a relevant community, we've all agreed, well, should agree, the case law says that the defendant doesn't have to know about that. It's just reputation evidence. On the flip side, whenever you want to get into specific acts of violence, threats, intimidation, and I know our net that we've casted here is beyond just prior acts of violence. There's also been issues of threats and intimidation. It's come in, it's in. The case law talks specifically about why that evidence is allowed and why all of that is not hearsay, because it's not offered for the truth. It's offered to show the jury what did the defendant know at the time that the self-defense was used. And unlike the mental ailments I mentioned earlier or other peculiarities of the particular defendant, this is just to show why the defendant would have stayed, and even if there wasn't an imminent violence at the moment, why that person would feel terrified, and all the other battered spouse. I won't go into the whole thing. So the issue is not, did this assistant state attorney believe the defendant? Did this police officer take a report and submit a capias or not issue a capias and send it to the state as a non-arrest? Did this ASA file it or not file it? Did this ASA believe that the defendant was the victim of domestic violence or not? All of those things are completely irrelevant, not to mention prohibited from the witness commenting on ultimate facts or invading the province of the jury. The issue is not the truth or falsity of the violation of injunction or the shooting into the ceiling or any of those issues. That's not the issue. The issue is, was the defendant aware of these prior acts? Example being that the evidence came in regarding domestic violence by Mr. Benefield against his first wife. The way the defendant learned about that was some sort of text message by or between Mr. Benefield and the former Mrs. Benefield. Clearly hearsay. But why does it come in? Because she was aware of it, and it shows some violent tendencies.
Yeah.
So she can testify about it. She can talk about it. The jury hears about it to help understand what she knew, and this is in the jury instructions, as the attorneys know, what she knew at the moment that this incident was happening. So Ms. Sweet's testimony about whether she believed the defendant or not, whether she was going to file or not, the conversation, whether she thought that the defendant was genuine and legitimately a victim, the testimony that she had some report and she called someone and there were some sort of abnormalities, unspecified abnormalities in some lab test that she, characteristics of domestic violence victims and so forth is just of no moment. So it's irrelevant. It's commenting on the testimony of and the credibility and veracity of other witnesses. It's commenting on ultimate facts. If you want to talk about the expert portion of it, as the defense said, this is all the same things that Ferris is going to testify to. So in essence, I haven't heard his testimony, but what I understood was everything. I believe it was something along the lines of what she's going to testify to is the same as what Mr. Ferris is, and I only say Mr. because I don't know his professional designation. So Mr. Ferris is going to testify to. Finally, on the issue of 403, Ms. Sweet's testimony, the probative value of that is substantially outweighed by the danger of confusion of the issues and misleading of the jury, because it does not matter whether that particular person believes it was a violation of injunction or not. The point is, the testimony is out. It's been demonstrated that the defendant knew about that. She's alleged it was a violation of injunction. There's a dispute. That'll be a factual issue for the jury to determine. But she's alleged it was a violation, which she took as intimidating. And the smell that caused her headache was some sort of physical ailment that would have been caused by the present that was provided. I understand that's her position. State might have a different argument on all that. But this is not even a difficult question. Ms. Sweet is not admissible as a witness. I am glad you proffered, though, because now it's all on there. But no, she's not going to be allowed to testify to what I heard today. Do you have another witness we can call?
Yes.
That was interesting. Really?
We have an objection to him as well, Judge.
Oh, now Mr. Ferris is the ex.
So she's not allowed at all. I get it. But notice he's not fighting too hard that he's not getting her in. He's like, whatever. I think he understands the prosecutor stepped in a hole there. So we'll see what happens, guys. But no, the defense is riding high right now. And it looks like the poll right now, 128 votes, is 17% not guilty, 63%. I'm sorry, 17% guilty, 63% not guilty. 1% has changed from not guilty to now guilty. And 19% were previously guilty and are now not guilty. So, well, we'll see. Let's see what happens here, guys.
Yes. And the state wanted to have a
Judge, I'm sorry. We do have a lay witness that we want to get on. Amy Carlton. She's going to be quick. We need to get her back to work.
Hold on. Amy Carlton. And then I assume, I know that's bad, that Mr. Ferris, tell me, does he have a professional designation? Is he a doctor or?
He's a licensed mental health counselor.
So he's Mr. Ferris.
Former deputy sheriff. His practice and his law enforcement experience has been combined exclusively to domestic violence. He teaches batterers.
I just want to know if he was had a professional designation that I should use. All right. So Mr. Ferris, looking at the time, I would think that after we finish with Ms. Carlton, the Daubert hearing is very likely going to take us to the end of the day. So I expect that we probably start with Mr. Ferris on Monday. Mr. Taylor?
Well, Your Honor, actually, we have some case law that I was hoping would obviate the necessity for a Daubert hearing.
All right. Well, do you want to handle Ms. Carlton first?
Please.
All right.
Mr. Don just needs to go to the ladies' room, so.
Oh. All right.
We'll I mean, if you want to bring them back in, that's fine. If you
So
want.
yeah, we can start working them back up.
Yeah.
I think that would be good. So let me give you guys 5 minutes. If you need to step out, Mr. Taylor, Ms. Benefield, if you need to step out and use the facilities, that'll be fine as well. We're going to start working on getting the jury up. It usually takes about 5-10 minutes.
Thanks, George.
All right, they're gonna skip ahead here. Here we go.
I can do better than that.
Perfect, thank you.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Hello, ma'am. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, or right if you need it. And just speak in a loud, clear voice and we'll hear everything. Can I just move you just a little bit forward?
Okay.
That's perfect. Thank you. Yes, sir, Mr. Taylor.
Good afternoon. Would you tell us your full name and state your last name, please? Spell your last name.
Spell my last name. C-A-R-L-T-O-N.
And your first name?
Okay.
Just tell
I'm
us
sorry.
What is your first name?
Amy with a Y.
Okay, Amy. Or Miss Carlton. Are you presently employed?
I'm presently employed, yes.
Yeah, where?
Where?
Where, for who?
I'm at one of the hotels in the area.
Okay, and what capacity do you serve in at the hotel?
I'm one of the managers.
How long you been doing that?
What was that?
How long you been doing that?
I've been with the ownership for 4 years now, going on 5.
Are you married?
Yes.
What's your husband's name?
Herbert.
Ms. Carlton, were you and your husband Herbert living in Bradenton, Manatee County on September 30th, 2020?
Yes.
September 27th, 2020.
Yes, we were.
Do you recall that afternoon if you were outside with your husband?
Yes, we were.
Do you recall the address you lived at back then?
It was on Newport News Street or Drive. We've been renting. So to be honest with you, I don't recall the exact street, the number of the street, but it was Newport News.
Do you recall, Ms. Carlton, whether or not, what was the reason why you and your husband were out that afternoon?
I have a mini golden doodle, and we were taking a walk.
Did anything unusual occur while you were out with your husband and the dog?
The reason I'm here,
Would you share it with us? What happened?
we were taking a walk, and Newport News is a couple streets over from the incident area. And it was probably 3 houses down where we were. And at the time, my dog was probably just over 1. So I don't know. I'm a big dog lover, and she's my life outside of work with my husband. He and I both heard what I don't know. I didn't know what it to be. And he kind of grabbed my arm, and I kind of got startled because it did sound like gunshots. I don't know. At the time we didn't know what it was. And but we heard one right after the other. And me, because of where I work, I'm trained like the attack or panic mode. I am thinking of myself, sorry to be selfish, and my dog and my husband. And he's looking ahead too. And I just remember being a little bit terrified myself and thinking of myself, my family. And so I remember looking up and telling him, well, let's go, let's turn around, let's go back behind the house, because at the time we weren't sure what it was. And also being trained, you don't know what is to come next. First of all, you don't know what it is. So as I'm telling my husband, I told him, call 911. As I'm telling him that, I'm sorry, I'm backing back behind the house because you don't know what's coming next.
All right, let me ask you a couple of specific questions if I can.
Yes.
You say you heard some gunshots.
It sounded like gunshots.
All right. Now, after you heard the gunshots, did you observe anybody exit a house?
Quickly, as we were trying to make sure of our safety, we saw someone leave the house, a lady leave the house. It was, I don't know exactly, like timing wise, because it's like I said, my mind was going through a lot of things.
Let me just keep you on the questions, okay? I'll help you. I'll lead you through it. You hear the gunshots. The next thing you see is what?
A lady came from the house, and
Describe.
I remember screaming, and That's just the vivid recollection and memory that I have, just the screaming, and I came from the house running to the neighbor's house. I don't remember too much other than the screaming and pounding on the neighbor's front door.
Is it a safe bet for us to say that this lady that you saw exit the house screaming was hysterical?
Yes, yes.
I want you to tell us, Miss Carlton, after the gunshots, approximately how long it took for that woman to come running out of the house.
So I'm not sure I recall. It was within seconds, though. It was, I don't know. I mean, I didn't even have time, like I said, to pursue any hiding places. It was so quickly.
Do you remember speaking to the police about the incident?
We had an interview. Yeah, it was probably 30 seconds, a minute. I don't know, 30 seconds.
Okay. So you hear the shots, and within 30 seconds, a screaming, hysterical woman comes running out of the house and goes to the neighbor's house.
Yes.
Did you hear banging on the door at the neighbor's house?
I don't recall if I remember stating that or not, but I remember the hysteria of the screaming.
Okay. That's all I have, Your Honor.
Can the witness be released?
Yes.
Yes.
Thank you, Ms. Carlton.
Ma'am, you've been released from your subpoena, so you're free to go. Thank you. All right, go ahead and approach.
I mean, okay, wow, yay. Breathtaking shit right there, guys. Breathtaking shit. Okay. Yes, very enlightening. Yep. That settles it guilty.
I do.
All right, so now this guy's gonna get in. Bruce Ferris. We're gonna do Bruce Ferris, not Bruce Ferris, the criminal lawyer. No, Bruce Ferris. No, he is. We're gonna see his voir dire about what this guy can do here. All right. So, guys, remember, this is going to be a voir dire. The jury's not in the courtroom, okay? So this is just him testifying on his own. No jury presence. I mean, it helped her, but it wasn't like a ton. No, all the help came from the state, I think, at this point. So, anyways, well, here we go.
Hello, sir. My name is Judge White. I'm presiding over the case. We're going to have a Daubert hearing. I'm sure you're familiar with that.
Yes, sir.
So just put yourself about 12 to 15 inches from that microphone. Make yourself comfortable in that chair.
Okay.
And we'll get started with the hearing.
All right.
Good afternoon.
Good afternoon.
Tell us your full name, please, and spell your last name.
Bruce Eric Ferris. My last name's Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor. I do individual therapy, and also I do consulting on domestic violence and expert witness testimony.
Let's discuss your education. Would you inform us, please?
Sure. I have a Bachelor of Science degree in civil engineering. I also graduated at the local police academy in Gainesville, and I have a master's degree in mental health counseling.
Do you have any specialized education or training in a specific field?
I do. If you look at my curriculum vitae, I think there's over 100 items listed, where either classes or seminars or teachings and certificate training that I've attended.
And included in that, would domestic violence be a major part of it?
That was the definitely predominant theme of whether it be a specific class or a conference, et cetera, on domestic violence and intimate partner violence. And if you'd like, I can explain the difference.
Please.
Domestic violence has to do with what we might think of people have a child in common or family members. And that doesn't necessarily mean an intimate relationship. It could be two relatives living in the house together. Intimate partner means there's an intimate relationship, a spouse, a boyfriend, girlfriend. So there's a little difference there.
Can try to make sure you're voice in the microphone because it tails off.
Thank you.
Mr. Ferris, have you taught any courses or presentations in a specialized field?
I have.
Please enlighten us.
if you look at my CV, I've given, I think, over 40 some presentations and teachings. For 8 years, I taught a batter's intervention program class to offenders, uniquely that. And for anyone that doesn't know, batter's intervention program is for offenders. It's usually court ordered, part of probation or part of a sentence or part of an injunction or restraining order. It's a 6-month psychoeducational class. I've been trained for that and teach that. I also, I used to teach Governor Lightham volunteers about domestic violence and effects on children. I taught the 8th Circuit staff at the state attorney's office about domestic violence and impact to women and children, and batter's intervention, how to interview people. From 2008 to 2020, I taught at the University of Florida Law Clinic on intimate partner violence to law students about the same type of subject, domestic violence and intimate partner violence and effects, and also enforcement of the law. I also trained police officers about domestic violence enforcement. Currently, since 2009, I've been teaching officers how to de-escalate confrontations as part of the crisis intervention training team. I teach the de-escalation part of that. There's a lot more I could talk about, but that's the nature, and you can see in my CV.
All right, let's talk about your work experience.
Okay, so I have an affiliation with Village Counseling Center, doing therapy, DCF cases, and domestic violence related cases. I used to also work with Creative Counseling in Gainesville, doing teaching batter's intervention program classes and doing individual therapy. I also have my own practice now, and I do individual counseling. Recently, I just looked up, since 2014, I've treated almost 1,000 individual clients or patients as an individual therapist. Work experience we're still talking about.
Yes, sir.
Okay, of course, I mentioned the doing consulting for attorneys on domestic violence and being an expert witness. Are we you're gonna want to know my current work or my past work?
Well, let's stay in the past. How about any experience with the Gainesville, Florida Police Department?
Yes. I went through the police academy in 1993. I was sworn in 1994. I retired from there in 2013. The last 10 years of my career there, I was the lead detective in the domestic violence unit, part of the Investigations Bureau, uniquely just looking at the domestic violence cases, enforcing the law, training officers, doing some public outreach, and being under his task forces.
Can you give us an idea over the course of that time, approximately how many cases you would have handled?
Yeah, I was a lead detective on close to at least 500 cases I looked up were resulting in arrest or charges being filed.
And what kind of professional credentials do you hold?
I'm a licensed mental health counselor in the state of Florida. I have certification to teach batter's intervention program classes through the state. I also received certificates to do threat assessments, domestic violence threat assessments through Jackie Campbell at Johns Hopkins University. Also trained in doing counseling and work with adoptions through Rutgers University.
Have you been the recipient of various awards and recognitions?
Yes, I have. I was chosen by the Alachua Board of Commissioners to be recommended to Governor DeSantis to be on the Alachua County Child Tax Fund, I guess they call it, Trust Fund, excuse me. I've also received various awards as for my domestic violence work through the local shelter. I received a statewide award from Attorney General Pam Bondi and Governor Scott at the time for my work. In 2010, I was awarded and recognized for my work with victims of crimes in the state. There's several other ones. Without looking at my CV, I don't recall them all.
Sure.
I received some recognition of contributions for the work I did with that CIT team. The University of Florida also gave me recognition for training that I'd done with their officers. I was Big Brother of the Year, and for my work with my little brother for about 10 years, I worked with a little kid as my friend. And I was also the Law Enforcement Officer of the Year, as granted by the Domestic Violence Abuse Network in Gainesville.
Are you a member, Mr. Ferris, of any specialty boards, committees, or professional organizations?
Sure. Again, relying a little bit on my CV because of the nature of the question.
That's fine.
So in 2022 to 2024, I was a member of the Rape Crisis Center Advisory Council. I was a member of the American Mental Health Counselors Association, retired member of the Fraternal Order of Police. I was a member of the 8th Judicial Circuit, Florida Family Law Advisory Group, member of the Gainesville Domestic Violence Task Force. as a member of the 8th Judicial Circuit of Florida Domestic Violence Fatality Review Team, as a board member of the Gainesville Commission on the Status of Women, a member of Letcher County High Risk Domestic Violence. I got some recognition for my work as a volunteer with University of Florida College of Medicine. I was doing mobile outreach part-time as a volunteer. I was a member of the University of Florida Male Leadership Committee, again, dealing with domestic violence. I was also on the planning committee for the Sexual Battery Conference in Gainesville for many years. I was a member of the Gainesville Mental Health Consortium, the United Way Community-Wide Strategic Planning Safety Committee. I was part of the working group for leader for domestic violence coordinated community response for local law enforcement and best practices procedure. And I was a member of the statewide domestic violence needs assessment group organized by the Office of State Courts Administrator, Office of Court Improvements.
Have you been recognized as an expert by courts in Florida? An expert in domestic violence?
Yes. Just as a footnote, I've been recognized as an expert in domestic violence, intervention program class, effects of domestic violence on children, and generalized mental health work. I've been involved with about 60 cases, consulting or testifying. Not all of those did I testify. I did testify in over 50 of those cases.
Both civil and criminal?
Yes, both civil and criminal. Majority were in civil. The types of working both for the defense and the prosecutor of the state attorney's office, but the majority were civil.
All right. Would you be kind enough to educate us a little bit? What is domestic violence?
Okay, domestic violence. Excuse me. Domestic violence.
Violence
according
is
to
domestic.
Florida state criminal law is acts of like battery and assault, ag battery, ag assault, false imprisonment, sexual battery, all these different person crimes.
I mean, I will say, since he got done with the CV, it's a very impressive CV, guys. He's got a lot of experience and his prior experience as a cop. So I think he'll be able to accurately explain things, but we'll see.
From one family or household member to another family or household member. So that now the definition is what's a family or household member, and that's people that are married, living together, maybe had a child together, but have never lived together. People living together as a family in a house. It doesn't include, let's say, cousins that never lived together. So it's unique in that way.
And is there another definition of domestic violence?
Yes, and in my practice and in my training, this is a pretty accepted concept that domestic violence is actually a pattern of power and control. And the key word is pattern, that's repetitive. And the criminal definitions, the physical things, those are used by perpetrators or abusers to control their victims. But along with that also is used we often think about emotional abuse or those sorts of things, and they're defined in the Duluth Power and Control Wheel.
Would you explain to us what the Duluth Power and Control Wheel is?
Okay. So the Duluth Power and Control Wheel was developed up in Duluth, Minnesota by a group of researchers who deal with domestic violence. And what they did is they looked specifically at domestic violence cases that have been criminal cases, that victims who came through shelters, DV shelters, and they were looking for what were the tendencies or the tactics used by abusers against their victims. And they developed this power and control wheel. It's used around the country. It's the Duluth Power and Control Wheel is the basis for the Batterers Intervention Program class I mentioned. DCF, Department of Children and Families, has accepted that as a reality, a fact, and they that was the criteria or the curriculum for the BIP class used statewide and actually used around the country and internationally. So there's these 8 inner eye side of the depiction. I don't know.
All right, yeah, let's see if Judge, with court's permission, we put the screen.
Yeah, probably a little bit. That's perfect. Yeah, thank you.
Judge, may I ask you a question? Could I stand over here?
Sure.
Rather than try to do it for you.
Reposition as you need. It's just us.
Thank you. It's a little easier to see this way for me.
Absolutely.
Thank you, Judge.
Oh, you know what though? The only thing is you can't be so far that the court reporter can't hear you, and she's listening to these microphones.
Okay.
So why don't you turn that?
Okay.
And then if you just position so you're facing there.
Okay. Can you hear me okay?
Okay. There
Can
we
you
go.
hear me now? Change that number. So this person. Okay. Okay. So you can see that.
Yeah, I was gonna say, these are.
Yes, thanks for reminding me. So this is the Duluth, as I said, if you look here, Domestic Abuse Intervention Project. And this was, I don't know, maybe 30 some years ago, 30, 40 years ago. And this is the standard used around the country and used for the Batters Intervention Program class and a lot of counseling I do. And this is part of the counseling along with cognitive behavioral therapy is one of the therapies I've been trained in graduate school and my work. So on the outside here of domestic violence is physical violence and sexual violence. And that's covered in the state statutes, the criminal law statutes. Then there's these 8 items that are part of the power of control. And remember, I said it's a pattern of power of control. So that means it's repetitive, a way to get your, it's a way for the abuser to get their victim to comply, to get into a compliance mode. I'll talk about that in a moment. So the first item is using intimidation, making her afraid, using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons. Those are I run into this all the time in terms of intimidation. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy. It's very common. Playing mind games, humiliating her, making her feel guilty, using isolation, controlling what she does, where she goes, who she sees, oftentimes spying on their victims, checking their phones, tracking them, etc. Minimizing, denying, and blaming. I find this in almost all the cases I work. They make light of the abuse, say it didn't happen. They shift responsibility. It didn't happen, it wasn't that bad. It was your fault. So minimizing, denying, blaming. Using children, sometimes put their victim, the mom, in fear of what he'll do to the child or that he'll report her, etc., that she might lose the child. Male privilege, this has to do with the role that he makes decisions in the family or in the relationship and gives her a specific role. Economic abuse, this would maybe be preventing her from having a job or money, or she should have an allowance, etc. And then the last item is using coercion and threats, making or I'm just having problems reading the fuzz here a little, making and carrying out threats against her, threatening, using coercion and threats. So I'm going to sit here, that can stay up, and I'm going to make a few comments about it. So the main issue here that, as we understand the power and control wheel, is these are techniques that the abuser uses to control their victim. And like we say, it's a pattern. So that means it's repetitive. And so what's the purpose of that? It's to get them to comply. And so the victim ends up trying to avoid the perceived danger that they'll. Well,
this Duluth wheel is like 100% real and actually fairly accurate. So like it's a legitimate thing.
If the abuser perceives that they're opposing them, particularly true for mothers that are, not only are they trying to protect themselves, but they're protecting their children. And I found that there's victims of domestic violence tend to get into what I call equilibrium sort of stasis experience. In other words, they avoid the perceived threat, so they the old phrase of walking on eggshells. So they end up being in this compliance, kind of like they don't want to poke the bear, so to speak. So they find this narrow way of coping by going along with the perpetrator and don't want to make him angry at them, because that's when the violence occurs, or the threats, or the emotional, the hardship. And that's exactly what the perpetrator, the abuser, wants to happen. He wants to keep her in line, so usually to manipulate, to get her to do what he wants to do, that they feel a sense of ownership. And they use these techniques to control. They also, the victim wants to appear to be going along. They don't want to anger him. They'll actively hide this from family and society, because if it gets out, he's going to be mad. And I could speak certainly a lot more about that.
Are there, Mr. Ferris, common characteristics that abusers share?
Yes, they could be anyone from any socioeconomic. I've been involved as a therapist and as a detective enforcing the law with all types of society and sexual orientation, from wealthy, well-known NASA scientists, doctors as a perpetrator, to the homeless person, and everyone in between. And in Gainesville, where I worked, we have a great population from all around the world there, and I didn't find a difference other than sometimes attitude. But every socioeconomic group, it's very, and also they tend to be males, but females also. Just yesterday, I took on a new client, spoke to him. His wife's in jail. He has 4 children with her, and he's a victim. So, he's a victim. So there's female abusers and male abusers. Males are predominant. I know when I was working, I ran some statistics on cases, and I found it was about over 2/3 of my cases were males, and 1/3 were females. And some of those, and that kind of reflected also when people would, kind of want to debate that issue about men or women. One thing that always struck me is when realities, the statistics are about the same. Usually the murderers are mostly men, by about 2/3 over the women. So the actual victimization cases and then the actual fatality cases, kind of the statistics I found ran together.
And what do they have in common?
Usually that they want to control their partners. There's kind of an ownership attitude. They use the power and control techniques I described to do that. I also find that they're missing true empathy. I kind of nicknamed it to myself as they're missing an empathy gene. And empathy has to do with the ability to feel feelings. And I find the perpetrators that I've counseled and also worked with in the BIP class, and certainly in my police career, they tend to be very selfish, narcissistic sort of ideas. I kind of image it as many of them, not 100%, but a majority. It's kind of like their point of view is I'm here and everyone and everything around me relates to me. I'm the center of the universe, as opposed to a healthy relationship. There's an equality. I'm being thoughtful and considerate of my wife as she is for me, and there's some balance. They don't necessarily adhere to that. They disguise how they treat their victims. Usually they don't want to let other people know about that, much like the isolation element. They want to keep it. And there's reasons for that. And some of it has to do, they don't want to go to jail if it gets out. And then they don't want, I found this a lot, that perpetrators don't want their victims to get the idea that they're not a good deal, that there's something they're doing that's wrong. So they isolate them from society as such. And they'll put on a real front. I have numerous cases like this, how they treat their victims. There can be, the victims, the perpetrators, can oftentimes be very appealing, and they're very good at convincing people of things. I found a certain finesse amongst those thousands of BIP clients I had, that there were some very good talkers. I'll just leave it like that. But the emotional abuse is certainly what we think of. I've certainly worked a lot of cases where there was broken bones and bruises, etc., and emotional abuse and isolation and coercion, threats, etc. But many of the cases I see, there isn't acute violence. It's emotional abuse. It's these techniques. The question is, can the abuser convince the victim that and put them in fear so they adhere to what they say? If they can create the fear, like this one lady told me, she was in fear of him so much, they would be in a public place and they're separated and they're across the room. And if he saw her talking to a male, he looked at her and she knew right away, end the conversation, move on. There was a fear, and there was no violence in that relationship, but she was scared of him. Also, as we know, as Judge knows, and Mr. Teller, the ASA knows, battery. In the state of Florida, there's assault and there's battery. Battery is the unwanted touching, that's the hitting, the punching, etc. But assault is also a crime. That's being in proximity to someone, showing a threat. I'm bowing up, I'm have my fists up, and the victim has a perception that the violence is going to occur. that's a crime. No marks, there's no scar, but there's fear. And so sometimes there's assaults that are taking place that aren't reported. And if on top of that, if they can create that to go along, that's a common technique that I see happening. It's all about keeping control of their victim. And one real common thing that I've seen is obsessive jealousy. And when I worked with batterers, I was surprised, and I came to learn very quickly that they oftentimes equate jealousy with love. And we all know jealousy can be very detrimental to the object of the jealousy, and also to the person having the jealousy, being obsessed and worried, etc. Love, we all know, is something else, completely different, very kind, considerate, and very empathetic, very different, but they didn't understand that dynamic.
Let me ask you, Mr. Ferris, do they exhibit, with respect to these characteristics in common, their behavior relative to animals, pets in particular? Domestic pets.
Yeah, I understand.
Cats.
So cats, dogs, etc. So there's above average abuse of pets by domestic violence abusers. So I have two explanations for that. One is what I talked about, their missing empathy, that they don't feel for a dog or cat like I might feel. I'm very empathetic. I am in love with Rosie, my poodle. So is my wife, so that means a lot to me. But to an abuser who doesn't have empathy, it's not a big deal for them. They see it as an object. That's one thing. The more important item, especially in terms of power and control, has to do with to get back to the controlling of their victim. If that victim is attached to that pet, and
Hold up, what now? Where the hell is this? You drunk message Turtle Boy? That's awesome. Send me that. I want to see it.
abuse that pet, now I'm putting you in fear for what I'm doing because I'm hurting your animal. So I'll attack that pet as a way to control you. You better not, oppose me again, or you better not leave, or you better not go out with your girlfriends when I say
Why,
you
Matt?
shouldn't, or I'm going to hurt your pet. I'm going to kill your pet even. So it becomes part of the continuum of power and control. The sad part is I've also found that many perpetrators have that same mentality they use against the females, children, in the sense that the women are highly protective of the children. And so he's using the child as a way to gain control over the female.
And what about the abused, Mr. Ferris? Do they have common characteristics as well?
Yes, the majority are female, though, like I say, I treat male victims of domestic violence also. I'm still kind of surprised at times when I meet a new victim for the first time. And remember, for 13 years, I've been getting clients from our local DV shelter as a consultant and a therapist working. So I get kind of a constant feed of them. And then I also have my other sources and attorneys, and just my people know who I am. So they come to me if they're victims. But I'm always amazed at how many don't truly know what domestic violence is. And even I've had I've had clients who don't think they're a victim of domestic violence. They'll know the problem, but they haven't been, I'm refraining from being too graphic because I've seen it all in terms of broken bones and types of violence in families. So they haven't been violently attacked and hit with the 2x4 or something, but I go over the power and control wheel, and they say, holy cow, this is my life. This is what's been going on with me. I remember one crime scene I was at, and had been a victim of domestic violence, and she wouldn't talk to us. And I had a moment to speak to her, and I showed her the power control wheel, and had a moment. There's a victim advocate there too, and we went over it, and all of a sudden it was like an aha moment. And she goes, darn. And I think it was a strangulation case, and she realized, and I've had some specialty training and some certification about being an expert in strangulation with the state, another subject. But she realized that she came within 4 minutes of dying for lack of oxygen to her brain. And once she realized the power and control wheel and how dangerous it was, she opened up and shared information, and that suspect who had left was eventually found. Also, statistics show that domestic violence victims will leave, on the average, about 8 times they'll leave their perpetrator before they finally leave. It often happens. And there's also socioeconomic and ethnic groups that have unique attitudes to domestic violence. This protecting a child for the mother as a characteristic. is very, very significant. I guess I'll take a short moment. There was a particular case that comes to mind. This mother was very abused by her husband, and he made her stay.
I'm gonna object, we just got into a narrative, I think we've established this happened.
Sustained. To the narrative.
Okay.
Okay, so you want me to skip the story?
Yeah.
Sure.
All right. Describe what coercive control in a relationship means.
Coercive control or acts of assault, threats, humiliation, you're trying to create harm, punishment to frighten the victim, much in the manner that we're talking about a pattern of power and control. By creating fear, they work towards, it's all working towards controlling the victim. Of course, like I say, the power and control wheel is the tactics, along with physical violence and sexual violence. And then we get into that appeasement or compliance that I've talked about. They want to avoid the pain of the conflict. And pain can be emotional pain. I've had women tell me, I rather get slapped upside the head, excuse me for the phrase, but then be told I'm ugly or fat, or my self-esteem totally crumbled. And so don't underestimate how important emotional control is in that sense.
Do these offenders always behave violently, or does abusive behavior happen in cycles?
No, as I've explained, it's not always violence. It's perceived violence in terms of the threats are enough to create fear in a victim that because of some assaults or, like in using intimidation, making her afraid by looks, actions, gestures, smashing things, destroying property, displaying weapons. These are all acts of intimidation that affects them and can create a great fear. And because of the narrative they project, the reality that they're living.
Why is it stopping?
As the victim, and they get into this compliance mode, and it's can be very dangerous. There is, in terms of cycles in the industry, I'll call it, we recognize there can be kind of this rain, sunshine sort of a model, that there's acute abuse, and that's kind of symbolic of it raining. And then the sun comes out, and there's like a honeymoon phase with couples, and all the sun, everything's nice. There's no.
Guys, the voir dire is him kind of being able to explain the judge. He knows what he's talking about. He's explaining more than just this case. He's explaining his job. He's really going into the weeds. But that's how he demonstrates his proficiency and knowledge to the court.
Violence or no emotional abuse, and then all that rain with the hot sun, clouds form again, and then the clouds are too heavy to carry the rain, and then it rains again. So there's some relationships, not all, but there's this cycle of violence or emotion.
I mean, do you guys want to keep watching this or no? So, I mean, there's this is it. This is it for the day. There's like 2 hours of this. I'll run it at 1.5 time. Make it a little faster.
Abuse, and then a honeymoon. There's also a generational cycle that I'm aware of, that you grow up in a family where roles are very defined. The male is
a Daubert hearing is it's maybe sometimes pre-trial. It's not automatically pre-trial. It's any time you're doing it. You can have a Daubert hearing in the middle of a trial. This is what they're doing. So no, it's not automatically a pre-trial thing. Typically it is. But this is a guy yeah. And that's a shame. I think he's interesting too. This will be good stuff, guys, for you to know when we do other cases. And also this will be great for Sarah Boone, because this guy's probably better than an expert Sarah's ever going to find. So I think it's helpful in that regard. But yes, Daubert hearings are always done outside of a jury's presence, but you could do them at any time. But it's a very good question, Kat. Very good question, regardless.
The head of the household, the wife doesn't, oppose him. So sometimes that cycle goes, I see it in my clients, from generation to generation until it can get somehow, someone breaks free from that. And maybe that male realizes that's not the best role to have. And a female realizes, I don't deserve this, and they move on. So that's another cycle.
Does the victim, Mr. Ferris, always appear to be afraid or act like they are afraid of the offender?
Definitely not. This gets back to what I've already been talking about. They're hiding that fear from friends, families, and for good reason, in the sense of the consequences of laying it out. And they may not understand all what's going on with domestic violence, but sometimes I've had victims say that they deserved it, that they caused the violence, that they didn't keep the house clean enough. They've got almost a brainwashing going on about what's expected of them as a woman, and they are they found this, I'll call it a dissociation from the facts, mental health term, kind of an avoidance that allows them to comply because of their fear. And so it becomes, no, they don't always appear to be afraid.
So let me ask you this. How common is it for the victims to smile and act happy?
I would object. I think we've got far afield from what needs to be established under daughter. As far as domestic violence, I'll stipulate he has this knowledge as to domestic violence at this point, but I think we've got far afield of what needs to be established.
Judge, I might recall for the court that they played the video of them all in the
I'm
restaurant.
not sustaining. This is your proffer, so
Yeah.
you
Thank you.
you tell me what you want me to know about your expert, and I'll decide what he can say and not. at
Thank
trial.
you. Would you elaborate on how common it is for the victim to smile and act happy?
Very common. And it speaks to what I've already been discussing, that they try to hide abuse from others sometimes for personal reasons. They don't want him to get in trouble. I've had mothers that are financially dependent, and they don't want him to go to jail or prison, because how will they take care of their kids? So they sacrifice themselves. They are afraid of what society is going to say, or they're afraid of the abuser. So especially the afraid of the abuser is a really big part, and that they stay in line. And again, it speaks to this idea of compliance, or equilibrium, as I call it, find the lowest resistance to survive. So they get into survival mode, and that walking on eggshells. And as a therapist, when victims come to me, we've got to kind of untangle this stress and trauma and come to terms with that, because they've gotten kind of in this lifestyle of compliance and all the hurt that comes with that, and how their self-esteem's been damaged. I could go on and on with that subject.
All right. So tell us a bit, if you would, Mr. Ferris, the role that appeasement plays in domestic violence.
It plays a huge role. We could say appeasement. We could call it compliance. We could call it walking on eggshells. We could call it don't poke the bear.
Go along, get along.
Go along, get along. It's all about avoiding pain, and that's the very technique. The fear. I'll use fear as equivalent to pain. That is a way to control. Hence, why this is called the power and control wheel. These are techniques, along with physical violence, that are used to control their victim and get them. And there's an ownership. I've already mentioned a certain ownership, the jealousy, etc. And also, I found some of my abusers become obsessed with their partner, that ownership quality at all costs, and they're just highly obsessed. And it can get various. Actually, I've worked cases where there's been suicide, homicide. That if I can't have you, nobody can have. And if a victim realizes that their perpetrator is capable of hurting them, they're going to go along, or they're going to get on a jet and fly somewhere real far away.
All right. Tell us, if you would, what the impact of a child has on these dynamics.
So the impact to the child, or having a child in the scenario?
Having a child in the mix.
A huge impact. I found who, certainly want to protect themselves and do this compliance. But when there's a child involved, and if they have a strong maternal instinct, they're going to sacrifice themselves to stay in a relationship. I've worked many cases, to my surprise, where there was no reporting of the violence or domestic abuse occurring. And so the woman, the mother, wouldn't seek a divorce, because they knew, typically in our state, if there's no extreme reason, criminal history, drug history, violence, etc., it's going to be a 50-50 custody. So I've had women who have stayed in the relationship, taking the abuse, because she's so concerned that she wouldn't want her child to be alone with that perpetrator. She sees him as a brute or a bad role model, etc.
And might that type of a scenario play out with the woman acting happy in an effort to go along and be in the company of the abuser to protect her child?
Without a doubt, that's the whole scenario. And and there are women that are better at it and more sophisticated at it than others. I'm just finished working a case where her family, as I interviewed, I won't make this long, but there was abuse. He's in prison. She was pregnant. She gave birth while he's in prison. She stayed with him. A couple years later, she was running his business while he's in prison. She finds out he's getting out early in 3 months. She commits suicide. She hangs herself because she was so afraid of him coming back. The grandparents, the maternal grandparents, have the child. I'm working on that custody issue and the criminal case. But the point I'm making is that when I interviewed the parents, the sister, the friends, all these people before the suicide occurred, they didn't know how bad the relationship was. She wouldn't show up at family gatherings, or she'd come and go, or they wouldn't see him. She was totally hiding all that extreme abuse that she was going through. The family didn't know about it till the end, before he was charged and went to jail. So she went to great lengths to hide because she was scared of him. And I believe her going along with him and running the business was all out of fear also. And then she couldn't face it and decided to leave us.
A few questions, if I can, as it relates to domestic violence abusers. What have you found in your experience and education as it relates to their ability to charm and deceive others?
Yes, I found this in a majority of the cases. They want to project an image, excuse me, again, hide the abuse. Sometimes that's their strategy to deceive others because they don't want to be found out. Also, I might add that the recidivism rate, when I was running the BIP classes, I was always surprised. I'm getting the same guy back again. You know, that there's a personality issue here that hasn't been solved per se with some men, and that there's a tendency to abuse over and over.
Is there a unique pattern of denying, rationalizing, minimizing, or blaming the victim that's typical?
It's not only typical, it's in a majority of the cases that I've ever worked. I see this almost in all the cases, I'll say. And if we look at the Duluth Power and Control wheel, there's actually at 5 o'clock.
Hi, Dolly.
minimizing,
Hi,
denying,
Hella.
and blaming.
Hope you guys are doing well.
It didn't happen. It wasn't that bad. It was her fault, which, as I've explained in the past. So that's very typical. It's also a form of gaslighting. That's been in, I think, the news the last 10 years or something. So it's a form of control and gaslighting a victim.
Does it include suggesting that the problem stems from the victim's mental health problems?
Definitely. That's a very common theme. It's also gaslighting. And also, it's in the power and control wheel using emotional abuse. About the third line down, making her think she's crazy. So it's a destabilizing technique. If you've got so much influence over me that you convince me that I'm crazy, then maybe it didn't happen. Maybe I'm wrong. So it's a self-esteem killer.
Give us an idea, if you would, of the barriers that exist to these women leaving the abusers.
Fear of being harmed, certainly, but if they report to victims, barriers to leaving can be, as I mentioned, cultural upbringings or norms, roles. A lot of victims are financially dependent upon their perpetrators and don't know what else to do. They don't necessarily have any other resources. Sometimes when I do trainings, I confront my audience, especially when I've got law enforcement or victim advocates, about their expectations of victims leaving that, perpetrator. You expect her to walk out on the street with 4 kids and she doesn't have a credit card and no family. And, and I kind of go into this a little deeper. I'll avoid doing that now. The fear of losing her children. So sometimes victims have experience with DCF. They understand what can be consequences if it's reported to DCF. So they don't want to report because, and I've been party to this in a lot of cases and termination of parental rights cases I've been involved with, that if she's staying with the abuser and a child, and I like I mentioned, I taught a class for DCF to men and fathers and mothers, and also trained on this a lot, that exposure to a child to trauma is trauma to that children. Separate from the traditional child abuse that we think of hitting the child or not changing the child's diaper or not having food, but actually subjecting the child to the yelling, the screaming, the abuse is trauma to that child. So if a female doesn't report and she's found out, then that can be considered a failure to protect. Now, and she's still a bona fide victim. So now she's being held accountable. Her children might be removed. She's got to go see people like Bruce Ferris for counseling. She's got to do all these classes. So there's and many know this, so they don't want that to be out and about. Also, sometimes I've had women, they still love him. They see the good in him. They feel he didn't have a good childhood, or it doesn't happen often, or maybe I created the problem.
So you mean these aren't split-second decisions?
What specifically?
Do they vacillate sometimes when children are involved?
No.
Should I leave? Should I stay?
I like to think of it as an evolution to leaving. But what's the motivation? If you're in that isolated situation of just he's the one, he's your world. Where's the education? Where's the involvement? That's what the role of a lot of our domestic violence shelters are in outreach, and is to involve and educate. And yes, here's services you can have. Here's someplace you can safely go. But that denial that violence will happen again is not uncommon. That feeling that it was her fault. Religious reasons. I'm always kind of surprised that, and I mean no ill towards any religious group. I don't mean to say that, but I found sometimes ministers or churches, very concerned about marriages or not getting divorced, and they actually recommend or counsel people to stay together that are hurting each other. And so that's an issue. This idea that he will hurt her if she leaves. In this quote, "I'd rather see you dead than with someone else," is not uncommon. And also the total power and control continuum and the use of that to control their partners.
Is there a particular time in these kinds of abusive relationships when violence is most likely?
Definitely. The most violent time is when she goes to leave and he knows about it or he's there.
In other words, when he
That's always the
forms
most
the
dangerous
perception
time.
that the realization sets in that this is the end.
When she eventually puts her foot down and makes that clear, that's, and I know from my certification is doing fatality reviews with Johns Hopkins University, that's in danger assessments, there's a high probability of fatalities or extreme bodily harm at that time. It's very dangerous. When we do many shelters and victim advocates that might be affiliated with the state attorney's office or wherever, they try to establish a safety plan with victims, and that plan will include, when you leave, it's when he's not home. Don't do it when he's home. And also have a safe, unknown location to go to.
Yeah.
I have many stories I could tell of women being hunted down and actually killed because of he knew where they were. And that just the trauma of that, I don't, even though I work in this field and I've been doing it for 20 years, it's hard for me to conceive that cloud over me of being subjected to being violently hurt. And if I am, who's going to raise my child? And will he hurt my child also? It's overwhelming for those victims. And I certainly see that in my practice, my counseling practice.
So let me ask you this as we close. Given your education and experience as a law enforcement officer, tell me, is there a general bias against females by males?
I think there is some different social ethnic groups, different cultures. Like I think I mentioned earlier, ownership of women. I've had, without mentioning the countries, I've been in, like I say, Gainesville is a little stewing pot of people from all over the world. I've run into men who actually thought it was okay to abuse their wife because they thought she belonged to him. And I said, sir, this is America. That's not how it works. So this ownership can be cultural. It can be dictated by social norms, what their parents did. Certainly the media and entertainment plays a big part towards women and male roles in our society.
And where can this bias be found?
Everywhere.
Everywhere
in society.
Including our institutions?
Including institutions.
And would those institutions include law enforcement?
Law enforcement, and of course I worked in law enforcement, and I was always surprised at how I constantly had to, I actually became a little internal affairs detective for my officers who didn't understand domestic violence and had biases. And I was always surprised of the biases and found sometimes they were personal. An officer's going through a divorce, so all of a sudden he's at a crime scene and he treats the female badly because of his own world, not enforcing the law appropriately. But yes, it can be, not, and also not everyone reacts the same way as a victim to domestic violence, and especially with other people. Some people have developed a very fat affect. In other words, they don't show emotion, and that's their coping skill. They actually shut down. They do this dissociative sort of thing. Other people become hysterical and exaggerated in describing. So every person is different. Just because you
Not responsive to questions.
Sustained.
All right. Lastly, do uninformed professionals, in your experience, cops, judges, lawyers, counselors, often fail to recognize the signs of domestic violence?
They do, and sometimes it's because they're not obvious and they're hidden, or they don't understand the dynamic of domestic violence, and they don't necessarily understand that that victim was in fear. And though it may not show, they may be smiling in a photo, or their family or someone doesn't know about it. That doesn't necessarily speak to what was going on.
All right. Now, would you be able to relate these principles to the facts of a domestic violence case with any kind of reliability?
100%.
Have you done that before?
Routinely.
Is that what you in fact do as a professional?
It's one of the major things I do. I might put as a footnote, I'm a therapist. So sometimes clients come to me and I'm helping them with their anxiety and their depression and generalized mental health issues. But many of my clients, because I focus on domestic violence, I'm helping them understand, or the perpetrators, I'm helping them change their attitudes, usually through what I call cognitive behavioral therapy. And I could go on and on.
All right. Could you make that application and its reliability by studying the facts and documents relative to a particular case?
Actually, this is one of my professions.
All right.
I'm hired by the state for cases doing domestic violence assessments, and sometimes I never get to interview some of the parties. Maybe they're not available, they're in prison, etc. In private practice, and also, like I say, through DCF, I've been hired. So I look at the characteristics, what fits, what was there a display of a weapon, was there all these different things. And
would you be able to do the same application with the same reliability through a series of hypothetical questions?
Certainly.
All right.
And if I can, I would admit that I can.
Yep. Finally, let's talk about battered spouse syndrome for a moment. Are there any characteristics in traditional battered spouse syndrome that might distinguish it from an otherwise domestic violence abusive situation?
Good question. So basically, the abuse is the same. I think what makes battered spouse syndrome or battered wife syndrome, different terms through the years. Different is oftentimes the victim still lives with the abuser, and there can be a history of extreme violence or violence occurring and traumatizing the victim. But the techniques of power and control and compliance and fear and how they hide it and all those things are completely the same.
Thank you very much. I have no further questions.
Ross?
Good afternoon, sir.
Good afternoon.
So, I mean, he really kind of addressed it. He's like, I work for the state all the time. So I think it's a pretty good, I think it's a very, 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 very good expert here. So they're going to stomp all over their dick trying to mess with this guy. It's a very, very good expert.
Justified as an expert on battered spouse syndrome?
No, I have not.
Do you consider yourself an expert on battered spouse syndrome?
I consider myself an expert on domestic violence, not necessarily the BSS uniquely. I haven't been recognized by a judge in that, doing that. So I think that for me, there's really no difference other than that distinguishing fact, whether they live there or not, or whether there's been physical violence or not. It's still the same dynamic. The victims are the same.
But you can recognize that the law might make a distinction between those two things, an expertise in those two things.
Well, I think I'm expert enough to understand that. I just haven't testified uniquely in BSS.
And how did you interview did you speak to Miss Benefield?
I did speak to her.
And for how long?
I spoke to her multiple times with a Zoom call.
Okay, my question was how long? How much time did you spend speaking to her?
It varied a little bit for an hour. Most of the times it was 2 hours.
Okay, I need you to add it up. Did you speak to her 1 hour total, 3 hours total?
Oh, total time?
Yes, sir. I'm sorry if my question wasn't clear.
I'm going just by memory. I'd be guessing a little bit here, so I apologize. Could have been I'm just trying to could have been 15 to 20 hours easily.
So you spent 15 to 20 hours speaking to Miss Benefield?
I did.
Okay. And did you review paperwork in this case?
A lot. That's how I came to my conclusions, uniquely from the paperwork.
When you say uniquely from the paperwork, are you telling this court that you spent 15 to 20 hours with Miss Benefield, but you didn't base the opinions that you gave previously in a depot on that time?
That's true. I did not get to do an assessment of her. I was not hired to do an assessment. I did not produce an assessment.
Well, what were you doing for 15 to 20 hours?
Some of it was being a counselor, and some of it was I have a reputation to keep, and I wanted to understand some. Was this really a victim? So, kind of got into a routine of understanding some timeline with her about what occurred and how did it fit the facts that I was reading about.
Well, wouldn't that say
Wow.
if what you just said is you needed to?
Oh, okay. That's gonna stomp all over that. Great job, prosecutor. Well, why'd you talk to her? He's like, 'cause I made sure she wasn't faking it. Jeez. He just kicked her ass.
Determine if she was a real victim, then it must have come into your decision making about this case, whether with that assessment you made. Is that correct?
Could you restate the question?
Well,
please?
you just testified that you spent 15 to 20 hours with Miss Benefield, and part of that was to make an assessment on whether or not she was a real victim. And
No,
so,
not to make an assessment, as I compared the facts that I knew from what I was reading. I wanted some validity, and then some of my time was being empathetic and listening to her.
And-
But my conclusions I've come to that I talk about in the deposition were 100% from the discovery. Those are the items, and I could list them for you if you'd like.
did they include the stand your ground motion filed by Mr. Taylor and the defendant?
At the time, that was one of the items. Certainly, if I subtract that from what the things he quotes in the stand your ground were other discovery items. Doug admitting to shooting the gun into the ceiling, him telling that to his priest, and phone calls and texts. So I didn't need the stand your ground paperwork document to find all those bits of information that I found through looking at discovery.
Well, so the portions of the stand your ground about what happened that night were not in discovery. That Mr. Benefield took a bladed stance and did this.
No, I didn't. Those items were not part of my conclusion. I can tell you I have 13 items I used uniquely in discovery that came to my conclusion on. And it didn't include, and I never spoke to Ms. Benefield about what you just said about bladed stance. I never talked to her about that.
Well, you said you spoke to her to determine if she was a real, I guess to determine her veracity. Is that what you're trying to say?
That's one word, but I never spoke to her about the event of the shooting. Never.
Okay. Did you speak to her about the other things that were in the stand your ground hearing and the discovery from things that had occurred in the past?
I think some of the things did. Yes. As I think about, the as she's going, basically she did some timeline understanding, when they met up until before the event, and some of those items were in there.
And did you develop an opinion on as to whether or not Miss Benefield was a battered spouse? Like as far as battered spouse syndrome, if you would say that she suffered from battered spouse syndrome.
Yeah,
Wait,
I did not
you said
determine
she
that.
was-
I determined that she was a victim of domestic violence,
Yeah, you're not
and that
gonna.
Doug was the perpetrator of that.
Based on
No.
All the
Discovery.
discovery and how it fits in with the
Uh-oh.
continuum of power and control,
Good job. You just fucked yourself.
and her compliance, her fear, etc.
I don't have anything else, Judge. Thanks. Thank you, sir.
Tell us what you reviewed.
I reviewed a deposition that Doug gave, and I had a written version. He makes admissions. He talks about the gunshot. He talks about punching the dog, throwing the gun, punching holes in the wall. There was a letter to his pastor where Doug admits punching a hole in the wall and shooting the gun in the ceiling. There was a domestic violence injunction in South Carolina prohibiting mutual contact in the text of that. The really important piece of evidence for me was Ashley wrote a letter on September 18th, 2017, when she separated outlining domestic violence that Doug did to her. I have a copy of that if you want me to go through the items, but you know, she outlines without necessarily being a domestic violence counselor at all. She talks, it all fits very discreetly into what power and control and what abused women experience at the hands of their abusers. It was, and also for me, if I might say, that was a frozen moment in time. That wasn't something that she said after I met her or something like that. This was from 2017.
And were you struck by the terms of basically art that she unwittingly included in that letter as it relates to domestic violence and the power continuum?
It was it's a letter that I can use in training other people to counsel domestic violence victims, or if I was to work with a group of batterers, et cetera. It's classic.
Okay, what else did you?
Deposition of a neighbor who caught Doug at night in the yard. A text of Doug admitting to putting a tracker on Ashley's car. I mean, these items that show ownership, that stalking sort of items. A text
What?
from his ex-wife documenting him.
Whoa, he put trackers on his car? Fucking A. Wow. Okay. Oh boy. Uh-oh. Uh-oh. Well, guys, when they say bladed, that means he's like turned sideways a little bit. So he's like bladed like this. You're bladed. I was sleeping the 4 times it came out. No, but he verified it there. Isn't it dangerous to give attention to a sociopath? I mean, yeah, but if they're going to kill you, people tend to I don't want to get hurt. Yes, I missed it before, Chad. Okay, I missed it. I don't always catch everything. Jesus Christ. You guys. Jerem wants to say the prosecutors may as well draft a plea offer now. Here's the problem. They're not going to. If I was Ashley's attorney, we ain't accepting it. So. And then Kat Randall is a new member. Thank you, Kat. Thank you for the support. Here we go, guys.
Physically abusing her on her honeymoon. So this gets into his character, and
The question was, what did you review, not his opinion about them.
That's fine. Go ahead. Overruled.
Thank you, Judge. Go ahead.
So here I have all this experience dealing with perpetrators, being a perpetrator to multiple victims. Sometimes when I was a detective, I would, besides my therapy work, and I see that as I interview victims, but quite often my routine, I work day shift. So I come into the department, I go to a detective briefing, I look at cases where the suspect got away. My job was to review probable cause, go make the arrest, or get the warrant. That's what I did. So the first thing I do is I run that perpetrator's name, and I find out there's an injunction, and I'm looking at the charging document that the officer left, and there's no violation of injunction in there. But then I open it up in the court system, and I found it's a different victim. So I found there's multiple victims. And also, to be fair, I'd open up her, the victim's information, and I would find that there's an injunction, but it was with a different guy. So there's some serial victims and some serial offenders. So basically, the fact that he is very strong, and I know we talked about it in my deposition with the assistant state attorney, this text message from his ex-wife documenting how he abused her on a honeymoon it was appalling to me, but it was not an unknown probability. And also it spoke to who am I looking at here? So that was one item. If I could continue. Of course, there was an injunction in Manatee County and some narrative. Dr. Russell, a forensic psychosocial mental health evaluation, I read, I think it was April 30th, 2020. She describes the abuse and domestic violence that Doug did against Ashley quite eloquently. It's quite clear the things she discovered in her she did interview and come to that conclusion. So I found that kind of enlightening. I mean, there were telephone calls and documentation between Doug and Ashley. I've got a date of August 16th, 2019, where he was, controlling, intimidating, amidst of being outside her house, following her. He was gaslighting her. He pulled a gun on his ex. There was a threat that he was going to kill himself with a gun, and there was more. There's more in that without pulling out the document. There was a very significant WhatsApp phone messages between Ashley and Doug, and in that, there's statements about being armed. He talks about warfare, rage, exterminating them, murderous mood, anger to take them out. A warrior side would be, the testosterone rage. He talks about killing bad people. So let's say we could say, was this all true, or was this techniques that to put her in fear of him? Both could be true, actually. I found that very, Dr. Broder, I read his testimony and that he gave, and it was clearly domestic violence was present. There was definitely power and control tactics reviewed by him. The mic blow up, the gun incident was, and I have a quote here, was certainly a frightening experience for Ashley. Yelling, screaming, punching holes in walls. And Mr. Taylor's cross was in that transcript I read. And as you spoke to Dr. Broder, angry temper, very controlling, highly manipulative, very intense. The holes punched in the wall, fired a gun in the ceiling, that, there was an appeasement. That word was even used by Ashley, apparently by Dr. Broder, as a strategy with Doug to protect her child, keep him at bay. This is the very issues I've been talking about. There was text about him kicking the dog and throwing the cat between Ashley and Doug. So all these elements right here, I got my conclusion from. I didn't need anything else. And this is clearly what I base my determination on.
And would you conclude, based on what you know, that Ashley was an abused woman?
Definitely.
Would you?
And I'm going to interrupt you, Mr. Taylor. Abused woman is to say one thing, but who was in compliance mode, that didn't want to poke the bear, that was afraid of what might happen if she opposed him. That's what I get here.
And how, if at all, would that explain, for example, Ashley agreeing to go on a parental exchange between Doug Benefield and her daughter Emerson? Ashley, in the week leading up to the shooting, exchanging friendly, lovey-dovey text messages with emojis and things like that. And Ashley at a restaurant with her mother and her child Emerson in the company of Doug, acting happy.
Totally, doesn't oppose my theory at all, or what I believe was going on. It may be that there's one thing I can say. Ashley did show, from what I've read here and what you're presenting to me, a sophistication to, and maybe that's her performance side for being a ballerina or whatever. I don't know, but she could put up a good front. And this was to keep that warrior side of Doug at bay. She was concerned and afraid, and she was very afraid for her daughter. This is the mother factor. Her getting in that. I guess you referred to the first visitation.
Yes, at the sheriff's office.
Her going along. That's much like I talked about that wife that stays with the abuser to protect the child. The idea of letting him, have custody at that time without, and I don't think, if I remember from documents I read, they didn't have that. He didn't have a lot of exposure to Emerson, and so that was definitely the mother, the maternal instinct, wanting to protect her daughter. And at her own expense, but that's nothing. I'm a parent. I take a bullet for my kid. It's not about me. It's about protecting them. I think that mothers do that. That's what mothers do.
All right. Thank you, Mr. Ferris.
Mr. Ferris, it's always a little bit dangerous when the court has questions, because certainly I'm the neutral party here. But in this kind of situation, in a Daubert hearing, I'm both the finder of fact and the decider of the law. So there are a couple of questions I have. I've said this multiple times. Mr. Taylor, I probably said it in hearings with you. I know you two have heard it. If you object to one of my questions, object. Please put your objection on the record. I have actually sustained objections against my own questions before. So I try to be intellectually honest, and if it's in retrospect, I realize that's not a good question.
You have been good about that.
First, I did not receive a copy of your CV in evidence. It may be in the file somewhere. Is it attached to something so I can find it?
I can give you a copy.
Any objection to me receiving a copy? I assume it's filed somewhere, but I don't know where.
Judge, may I make a statement briefly? When in my past experience, when my CV is presented to the judge, oftentimes I'm shown a copy to verify that that's the complete version.
Sure, we'll see.
Yes,
absolutely. I'll say, Mr. Taylor, there's markings on it.
Yes, sir.
Get back. Is it in the court file?
I don't know if it's attached to the deposition. Let me take a look.
So here it is.
No, I'm informed we don't believe it's in the court file.
All right. And so, sir, this appears correct?
Yes, it does. Thank you for letting me look at it.
State, the copy that I've been given looks like there's highlighting where someone was making notes to highlight certain things to talk about. There's a couple of pages where there's some red pen markings where something has been circled or underlined. Any objection to me taking this and reviewing it?
If I may, it's a defensive burden. My only concern about your asking questions is that they have arrested their witness. And I understand what your Honor, I have a guess as what your questions will be, but that is my only concern. I don't know what objection that would be, but.
I mean, don't forget there's also the general and proper. So you object away.
Yeah,
You know me, I don't mind.
Yes, sir. Yes, sir.
All right, and then you had gone through a list of 13 things that you had reviewed.
Yes, sir.
And I was writing down as we went, and I'm taking notes. I only got 12.
Okay. So do you want me to briefly?
I don't want the narrative portion. I just want you to tell me.
Or you tell me. Okay, I'll tell
No,
you.
it's got to be the other one. You have to say
Okay,
to me.
I'll give you the first 3 or 4 words of each. Number 1, deposition of Doug. Number 2, letter to pasture. Number 3.
A little slower.
Okay, sorry. Number 3, DV injunction from South Carolina. Number 4, 9/18/17 letter from Ashley. Number 5, deposition of neighbor. Number 6, text of Doug admitting. 7, text from ex-wife. 8, the DV injunction. That's Manatee County. Number 9 was Dr. Russell. 10 was the telephone calls between Doug and Ashley. Number 11 was the WhatsApp phone messages between Ashley and Doug. Number 12 was the Broder testimony. And number 13 was the text kick dog through cat and between Ashley and Doug.
Can I just ask to verify, you said phone calls between Ashley and Doug? What did you say?
Yes, from 8/16/2019, I have a transcript of phone calls between them.
Transcript of phone calls?
I believe so.
All right, that's all the questions I had, surprisingly. State, do you have any questions based on my questions?
No, sir. Thank you.
Mr. Taylor, do you have any questions based on my questions?
No, Your Honor.
All right, and is he free to head on back to Gainesville?
Yes, sir.
Okay.
Am I released from my subpoena?
No, this is just a proffer.
Okay.
We're doing a Daubert hearing, so I imagine Mr. Taylor still has you under subpoena.
We have high hopes you'll be returning early next week.
Okay.
So stay in touch.
Okay. And so I'm still under my subpoena.
Yes, sir.
Thank you. Thank you. I do appreciate your attention.
Absolutely. Have a great weekend. Don't forget you've also got your wheel over here. Or was that yours?
That's theirs.
Okay.
I've got mine. Thank you. Thank you.
Safe travels back home.
Yes, appreciate it.
Wait, we're looking to go right at the perfect time, aren't we?
Yeah.
I want to stop and have dinner.
Or pack up my hotel room and put my blue jeans back on, right?
Yes, sir.
Thank you.
Yes, he did, but that's more of like in a southern way than anything.
All right, the witness has left the courtroom. Did you have any other witnesses' testimony or evidence you wanted to put on for the Daubert hearing?
No, sir.
State, did you have any evidence, testimony you want to put on? All right, I'm ready for argument.
So 702 of the Florida Evidence Code, Your Honor, incorporates the new Daubert standard, as the court knows, provides if scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if, and the court knows the 3 requirements, sufficient, if the testimony is based upon sufficient facts or data, testimony is a product of reliable principles and methods, and 3, the witness has applied the principles and methods reliably under the facts of the case. The state's theory of prosecution, although it was changed this afternoon from the release of the Broder report to the injunction that was set for the 30th, has as its predicate the specific behavior of Ashley Benefield in the week leading up to And included in those text messages, as was the video at the restaurant, as well as the state's focus on how Ashley Benefield behaved in the presence of Douglas Benefield, but behaved differently when she was by herself, and how she led Douglas Benefield to believe that she wanted to reconcile, but in private, she clearly disclosed that she did not want to do that and wanted the relationship over. And finally, the instances where Ashley Benefield, as a result of the parental time sharing, accompanied her daughter, Emerson, and went with Doug, that Stephanie Murphy testified to. They were the picture of tranquility, that Ashley was very pleasant, happy to be in Douglas's presence. So what we know and what the record reflects based upon Mr. Ferris's testimony and the Duluth Power Wheel and its model for the evaluation of domestic abuse is that this is a classic sign of an abused woman who is in compliance, who indulges in, as Dr. Broder used the term, appeasement. Go along, get along. It keeps the beast at bay. And now, that element having been injected by the state in their case in chief, we, on behalf of Ms. Benefield, are prepared to meet with expert testimony explaining to the trier of fact, the jury in this case, exactly why the state's evidence of Ms. Benefield's compliance can be dismissed, can be explained, because this is the MO of abused women, women suffering from domestic violence, especially when a child is involved. So here's what, as the court knows, the Oquendo decision said, and it's the second DCA decision, referring to battered woman syndrome. Again, the notice we filed was notice of battered woman syndrome, but I footnoted it because two elements are not present. Those two elements are that Ms. Benefield had left the home and that she had not been physically battered by Mr. Benefield until the day of the homicide. But, as the court heard from Mr. Ferris, it's inconsequential. It is the same syndrome. It is the same abuse. It carries over, and it explains under the Duluth Power and Control Wheel why Ms. Benefield would engage in those kind of text messages 1 week before the shooting, why she would appear happy at the restaurant, why she would accompany her child at the parental time sharing with Doug, why she would try,
I'm sorry.
why she would try to get along, go along. So here's what the Oquendo court said. Well, actually, before we go there, we should go first to the Supreme Court case of Kathleen Wyand versus the state of Florida. This is the case I cited to the court earlier in a memoranda, 732 Southern 2nd, 1044. It was an appeal from the second DCA.
Okay, no.
Yes. No, this is Wyand.
Wyand.
Kathleen Wyand, the Supreme Court of Florida. I'll get to Oquendo next. And the Wyand decision, Your Honor, was March of 1999.
Yes.
The Supreme Court rejected the second DCA's position in the Wyand case and instead embraced another circuit's decision.
Very true, Nate.
And
Very
it turned
true.
on the following question: whether or not there should be a duty to retreat as it applies to a spouse in the marital home. The Second Circuit had insisted on giving the instruction in a homicide case. The Supreme Court said, hey, look, we've learned quite a lot about domestic violence, and we're uncomfortable having a duty to retreat imposed upon a wife because of domestic violence. And it would render the wife's ability to defend herself in the face of battering and domestic violence ineffective. So we're going to reject that. We're going to retreat from our earlier decision that held there was a duty to retreat. And this is what they said about why. It starts on page 1052. And the topic is Section B, implications for victims of domestic violence. And they talk about how much of the public policy in this state has changed based upon increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, severely beaten again. If she managed to escape, other hurdles confront her.
While you're taking a breath, how is Wyan help me decide the Daubert question?
The issue is whether or not he has the credentials. I think we're past that. Unless I'm missing it, I think he's eminently qualified. I think the testimony is such that he's identified the syndrome of domestic violence, and he's explained that it is identical to battered spouse, the only difference being that the wife is not in the house and she has not sustained physical beatings. So this case in Wyan goes on for several pages talking about how domestic violence, the evolution of public policy, and the recognition of the plight of victims of domestic violence needs to be addressed and should be addressed by virtue of expert testimony.
All right.
When you take that into account and you recognize what the Supreme Court is acknowledging, Judge White, about the timeliness of domestic violence.
I've already said I think the judge is going to let him in, Patty. I think he's a very credible witness with a very credible CV. So yes, I've already said that. I think he's very good. I'm just listening to his argument here.
Which is the overarching umbrella, battered two components coming underneath it.
Mm-hmm.
You then go to Acquendo. And in Acquendo, they serve it up perfectly.
And now, if I were him, because he mentioned battered spouse again, the state, I think, opened that door with the whole battered spouse issue, because he said it's got similar issues, similar characteristics. I think the state's opened it up. I would start hammering on that. Let him come in. Let him mention it. Let him mention it.
Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind in the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. And then they distinguish post-traumatic stress disorder. And they hold, as such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. So we know in a homicide case, based on the law and the jury instructions, Ms. Benefield is entitled to introduce specific instances of conduct of Douglas Benefield that are consistent with violence. We have endeavored to do just that throughout this trial thus far, with considerable resistance, but I think we finally started making some progress once the court felt the predicate had been laid. We cannot, this jury must understand, and both the case law that I cited to Your Honor clearly says that it is a proper subject for expert testimony, domestic violence. These jurors must understand why a woman would do what the state has alleged she did, and as a result, they should find her guilty. That is to say, getting along with Douglas Benefield and the text messages that they put into evidence. So, given the credentials that he's established, given its reliability, given the tests that it's been vindicated with and that DCF employs, the Duluth Power Control Wheel throughout the state of Florida, given the fact that this is a domestic violence matter involving self-defense with specific instances of domestic violence, how can I successfully defend if I cannot explain to the jurors the essence of the state's case as to why Ms. Benefield is a malingerer in effect? That is to say, if she acted happy 1 week before the shooting, if she went ahead and got in a car with Doug when they were exchanging temporary time sharing, if she acts happy at the restaurant, then she obviously wasn't scared of Doug. And that's the whole issue. That's exactly what was at play on September 27, 2020, and why Ms. Benefield's perception of Douglas Benefield was so fraught with fear. Otherwise, I'm left with a case that there is, in fact, a substantial explanation to explain that conduct that the jury doesn't understand, as indicated by the case law in the Florida Supreme Court, and will have no idea why Ms. Benefield would have acted that way. And it's an element that the state introduced. We are trying to meet it. That's our position.
All right, thank you. State?
Judge, I'm going to try to bring it back to Daubert, but I do want to address Akendo because it frames my arguments. Sorry. Under the Okendo case, or Oquendo, however you say it, the court carves out, as we discussed at length, and I know Your Honor knows, carves out an exception for battered spouse syndrome, where it's talking about that that it's an objective standard. Self-defense is an objective standard, not a subjective standard, and that the one exception for that, and under Okendo thus far, is battered spouse syndrome. They discuss the definition of battered spouse syndrome, and part of it says, the main part, mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because she suffered from the syndrome, battered spouse syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. The Whelan case also defines battered spouse syndrome. It says,
You want to spell it?
sorry, it's the case Mr.
Wyand?
I'm sorry, Wyand.
However you want to say it.
I don't, W-E-I-A-N-D, 732 Southern 2nd, 1044. It says, I was looking for the page, Your Honor, I'm sorry. I think it's on 1054. It says, as the expert evidence demonstrates, there are many reasons battered women do not feel free to leave the battering relationship. This woman might have been isolated from her family by the abuser. She may not be able to afford to go, and she may realize that leaving is more dangerous than staying. And the reason I cite that is because the state's argument is that despite Mr. Taylor's efforts to make this about battered spouse syndrome, despite his footnote, that is not what this is about. This is them trying to get an expert on domestic violence. This expert, Mr. Ferris, while very educated in domestic violence, is not a battered spouse syndrome expert. He does not say that this defendant, although I find it incredulous that he spent 15 to 20 hours with her and reviewed things that the state doesn't even know what they are, that he only based his opinions on those documents not meeting with her. But nonetheless, if he were evaluating, the reason that's important in the state action is because if he's evaluating her for battered spouse syndrome, which he clearly wasn't because he admits he does, that's not what he was doing. There's only two options for that, and Your Honor's aware of that. That one, if she's evaluated, then they have to file notice and we're allowed to evaluate her. That's not what we're operating under here. So the other one is that their expert must not have evaluated her. And the state would argue that no matter what Mr. Ferris claims, that's an evaluation. The things he did were an evaluation. I believe the case actually, I think it's Hickson, but I could be misspeaking, even says that they're not supposed to be familiar with the facts of the case. He's clearly familiar and has formed opinions, personal opinions, and professional apparently, about the facts of this case. And the reason that's important is because the state would argue that this defendant has failed to meet her burden under Daubert, that this expert is an expert in battered spouse syndrome, that the testimony is based on sufficient facts or data, and that it's a product. I don't think he met any of the prongs as to battered spouse. As to domestic violence, I would admit he certainly has the skill and knowledge. But even then, I don't think that the methods were reliably, it says the witness has applied the principles and methods reliably to the facts of this case. The facts he got were incomplete and evidently biased because some of them include items that were never provided to the state, including transcripts of phone calls that the defense felt were appropriate. So the state's argument is that, one, the only option for them is battered spouse syndrome. They have certainly not met the burden for that. Under Okendo, the domestic violence should not be admitted. And two, that they did not meet their burden under Daubert because they did not satisfy the prongs of Daubert for domestic violence if it were admissible. And I don't know what they expect Mr. Ferris to actually testify to. I think 75 to 90% of what he said today is inadmissible. Stories about other people, those kind of things. The state is of the opinion that his opinions that this defendant is a victim of domestic violence are inadmissible. That's an inappropriate opinion for him to be making. And finally, the main prong that they have not met in the state's opinion is that it says, if the scientific, and I'm citing Booker, but it's from Daubert, the scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or determining a fact at issue. The state has put forth motive evidence and evidence of how she was acting in the weeks before this murder. And it certainly goes to her depraved mind. But the concept of domestic violence and even the concept of the Duluth power and control wheel are not foreign to the average citizen. That an average juror, and this expert, scientific, technical, or other specialized knowledge would not be necessary to assist the trier of fact in understanding the evidence. The evidence is clear, and the jurors are people who are of normal knowledge, and it's a common domestic violence situations, and the idea of power and control, honeymoon phases, those kind of things are common knowledge. So I know I said a lot of ways in which we object, but I don't think they met their burden under Daubert for battered spouse syndrome, certainly. I don't think they've met it for domestic. But even if Your Honor finds that they have, the the state would argue that Okendo would keep that testimony out of this trial, as it's an objective standard, not a subjective standard. Thank you.
Rebuttal?
Yeah. Mr. Ferris was asked directly if he evaluated Ashley Benefield, and his testimony, which is the only testimony that's been brought forth in this hearing, was that at no time did he conduct an evaluation. He was not hired to do an evaluation. With respect to the state's statement about motive evidence, motive is not an element of the offense.
I mean,
however, self-defense is certain.
Yes, basically she's talking out of her ass, because domestic violence is battered spouse syndrome is predicated on a foundation of domestic violence, because a battered spouse suffers a systemic and chronic domestic violence, which creates the syndrome. I mean, she didn't really have much else she can argue, so that's why she's going that way. Under this battered wife, can it work with Sarah Boone? It doesn't. I don't know. I have a feeling Sarah Boone is probably they're probably in a relationship, but they both abuse each other, so it's different. But yeah, Young. I mean, basically they're just fucking making it up at this point. They don't really have an answer, and yeah, she's talking out of her ass. They don't this is never a position they're normally in. Normally they're like, yeah, it's all comes in. It's all serious. We believe all women except this one. There's a reason why there's 2 women prosecuting this. There's 2 women prosecuting this, so they don't look like assholes. Yeah, and then Sky's Neighborhood saying for £5 sterling of the king sterling says, do you think battered spouse defense needs a bit of a legal refresh, such as given our more nuanced understandings of domestic violence? There's always research and discussion on it. It takes to change it up. It takes a lot of research and a lot of time. So I would assume probably in the next 10 years or so, we're going to have changes to an extent, but it's it's a very problematic thing, but there's always research and scholarship being conducted. The prosecutors are grasping at straws. It's beautiful. I know it's hilarious. You love to see it, chat. You just love to see it. And he's got the upper hand right now, so.
Only a material element to be considered. And there is, according to the information that is discussed in the Supreme Court opinion, Your Honor, it is not, and decidedly not, a subject for lay testimony. They could not make it more clear that there are many aspects about domestic violence. In fact, the words that they use in the Supreme Court opinion is that judges and juries do not understand and would benefit from expert testimony. I would suggest to the court, drawing a distinction between Daubert and the case law on battered spouse syndrome, I would suggest that given the facts of this case, an expert such as Bruce Ferris, who could educate the jurors on the impact of an abused relationship, domestic violence, in and of itself would be enough to provide expert testimony to counter the state's position and the issue that they raised about the go along, get along. I think it's clearly beyond the scope of lay people to understand that. And I think that expert testimony would help explain it. So Daubert, of course, doesn't apply any less under those circumstances. However, it would not be restricted to the extent the court wanted to draw such a narrow line and say, for example, okay, well, this is not battered spouse syndrome because for it to be battered spouse, you absolutely must have the abused party living with the abuser, having had physical beatings. If the court wanted to draw a line that narrow, rather than include it under the umbrella of domestic violence, I would still submit to Your Honor that the testimony from Bruce Ferris clearly met the Daubert standard for admissibility
and I would call him as a expert witness on domestic violence. And if the court really wanted to narrow it even further, as it relates to a woman who would choose appeasement and go along, get along, coincidentally, like I think we had 4 psychologists testify in this case so far, and every one of them have used the same terms to describe this phenomenon. I think I need and I should be entitled to be able to explain that to the jurors. And I'm not going to be able to do that without expert testimony. So I think the state combines Daubert with the case law, and Daubert is the procedural vehicle for allowing expert testimony.
All right, I do have some questions.
Yes.
I end the week, kind of as I mentioned at the hearing we had regarding Mr. Ferris before the trial started, whether it was last week or the week before. On July 11th, at a hearing, you said this was not a battered spouse case. On July 12th, you filed the notice of intent to rely on battered spouse syndrome. What is this? Are you arguing battered spouse syndrome or not?
Okay, Judge, once again, I filed that notice with a footnote in the title, Notice of Intent to Rely Upon Battered Spouse Syndrome, footnote. The reason why I told the court this is not a battered spouse case is because technically, Your Honor, battered spouse requires those 2 elements. I shouldn't even say it requires those 2 elements. Those 2 elements are generally present in the battered spouse cases that we've seen. So in my footnote, I said, as it relates to domestic violence. So I wanted to cover both scenarios. I wanted to cover expert testimony to explain this phenomena under battered spouse as it relates to domestic violence, because it's the same syndrome as you've heard. It's the same mentality. Everything about it's identical. But I also felt at the same time entitled, upon meeting the Daubert standard, to just call an expert on that particular issue. And this expert's eminently qualified to explain that kind of behavior. So Daubert is, again, the procedural vehicle that qualifies whether or not the expert is capable of meeting the standard. And that would apply whether it was the battered spouse or just as domestic violence.
All right. So we've got the case law that we've all been discussing for the last couple of weeks regarding battered spouse syndrome, the notice that's required, why it's a carve out, why it's allowed when Okendo doesn't allow PTSD, other cases don't allow significantly impaired intelligence, mental health issues. When I say mental health issues, I'm not talking insanity and so forth. I'm talking about diminished capacity, right? Essentially diminished capacity, because we're looking at a reasonable person. Do you have cases that do not use the word battered spouse syndrome? They use domestic violence victim of domestic violence, and that is allowed in self-defense cases.
Would it be any different, Your Honor, than a criminal case of culpable negligent homicide, the issue being the trigger pull and the weight that in order for the weapon to fire? And you're an expert to testify that the trigger in that particular gun was set to a particular level to try to explain to the jurors why that gun might discharge, and you're not necessarily negligent because of the discharge. Other weapons, if you banged against the wall, might not discharge. This one has a hair trigger. The defendant turned, hit the banister, the weapon discharged, shot and killed somebody else. If that expert met the Daubert standard, why wouldn't that expert's testimony be admissible to explain that? To try and explain to the fact finder who would not have that knowledge that indeed this could be nothing more than an accident that does not rise to culpable negligence, and therefore the charged individual is not guilty. And what I'm saying to the court is that evidence of domestic violence, if it meets the Daubert level, I should be entitled to defend and explain to them why she would engage in this type of go along, get along.
So the answer is no, you don't have a case.
I do not have a specific case on that point. No.
I mean, he's just being honest. You got to work with what you got there. Jason, you're saying, thank you for coming to this trial. How do you think the defense is doing in making his argument from another view? He's doing pretty good. I mean, I still think the way the prosecution handled the cross-examination, they pretty much lost the case at this point. But he's doing all right. He's a very good attorney. He's making very good arguments here.
And so the court knows I instructed Mr. Ferris not to evaluate Ashley Benefield. I had planned if it came in under battered spouse.
Yes, the prosecution has case law supporting him, but
option whereby he
there's
would be
some
given a
facet
series
in.
of hypotheticals based upon facts and evidence.
Excellent segue. That was my next question. I didn't keep track on the clock how long Mr. Ferris testified about.
Why is it
The
stopped?
general properties of domestic violence, the Duluth wheel, cycle of violence, his numerous anecdotes, personal anecdotes, and relatable anecdotes. So if I'm understanding correctly, you are going to seek for him to offer an opinion that Ashley Benefield was an abused person and Doug Benefield was an abuser. Is that correct?
No, not necessarily. That was for purposes of the hearing that we had. It would be my plan if he comes in under the Heenum approach to battered spouse, Your Honor, to just have him educate the jurors about domestic violence and specifically ask him about the compliance aspect that would allow a woman to engage in the type of behaviors that the state has raised the issue about and injected the evidence that they have. I could then give him hypotheticals based on facts that were in evidence under the battered spouse syndrome exception, or alternatively, were he to come in just as an expert on domestic violence, I had him review the discovery materials. As the court knows, he submitted to a deposition by the state under the Heenum approach or under just domestic violence state, as it says in the case law, would have had the option to get their own domestic violence expert. They haven't done that.
My ultimate question was, at one point you asked, can you relate these concepts to a domestic violence situation? Yes. He can study facts and documents. Can you relate these concepts to a situation where you study the facts and documents of a particular case? Yes. But you're saying you're not doing that. You're doing hypotheticals. He's not going to render any opinions in this case.
Correct.
Specific to this case.
If it comes in, yeah, under battered spouse syndrome. That's correct, Judge. I would follow the Heenum approach.
I think it's Hickson. Are we talking about Hickson?
No, I don't think it's Hickson.
No, I know it's not.
It's
I would like to hear that one if you allow it once we're done.
Oh, yes, he's qualified to test about domestic violence, but I think he might. I don't know if he tries to parse it down at all, but no, he's been very good. You had tartar sauce and fresh walleye. Ooh, walleye is always good.
Yeah, it is in Hickson, but the case is Heenum.
My question is this. He spent so much time on these hornbook issues. And the question was asked, can you apply these principles to hypotheticals? But I didn't hear a single hypothetical that's going to be presented, so I could even hear him and consider him and listen and see if he applied the principles reliably to the scenario. So I have no idea, how am I going to make a ruling when I didn't even hear the hypotheticals?
Well, hypotheticals would be based on evidence in the record.
I understand.
I took him up to that threshold and I asked him, could you reliably apply these principles?
The judge is saying, but you didn't give me the hype. Like the judge, I think is saying I know the judge is saying, I wanted you to do the actual hypotheticals. And he didn't do those. Yeah, that's a bit of an issue here. And Ken is also saying, Trying to get a specific BSD expert relating to self-defense of DV, as the judge is asking. Yeah, that's like probably like 1 in a million of them. So, yeah, this is not, they might have a problem here. I would contend the judge waived the issue. It's not his job to elucidate that testimony.
To a series of hypothetical questions if asked. He said yes.
So why didn't you ask the hypotheticals so I could hear them and make a ruling?
Well, I would
Exactly,
ask the
there we go.
hypotheticals, Your Honor, based on what we know is record evidence for.
Exactly. What's in the record? What's been admitted?
Correct. But
Is it your position that all 13 of those items have been admitted?
No, exactly. You see, guys, the judge immediately went to what I was going to bring up. So, yeah. It's a big deal. And the judge's like, it ain't on the record.
Admitted into evidence?
No.
So I would need to hear the hypotheticals to know what you're going to ask about.
Okay, so I would ask the hypotheticals, Your Honor, based upon shooting the gun in the ceiling. Actually, I would ask the hypotheticals based upon the evidence that the state has presented to create the issue. For example, I would ask, in a week's worth of text messages were to be exchanged leading up to a shooting that show emojis and friendly banter back and forth, would that be inconsistent with battered spouse syndrome? I would then ask, would a woman who shares a child and the husband has a right to joint custody, and the woman agrees to go along with the husband when he is with the child, would that be inconsistent with battered spouse syndrome? And he would explain in response to those types of hypotheticals why it wouldn't be, why this issue of compliance exists and is so prominent in domestic violence cases or in battered spouse syndrome cases. I mean, the hypotheticals, I think, are readily available based on what we have record evidence. Now, I might also add, Judge, we've only called, I think, 2 witnesses, so there may be more that's in the record. But to the extent that I'm interested in it, it will relate to this issue that the state is teed up about acting friendly and not being fearful being in the company of the individual. It doesn't mean that they're not fearful.
Hold on.
Once again, Your Honor, I had him review the discovery documents in the event he came in as an expert on domestic violence and was going to speak to that issue.
All right, thanks, sir. All right, State.
I guess based on that line of questioning, I'm still not sure what the answer is to your first question, which is this a battered spouse syndrome case or not? I would argue that it is not, that there's been no showing that battered spouse syndrome applies in this case. And I think that's my first argument. As to the hypotheticals that we did not hear today, the state objects to the hypotheticals being offered to this doctor because under Hickson, if this were battered spouse syndrome, which is really all we have for guidance, it would have hypotheticals are available to someone who has not evaluated her. And I think because I know he said he has not evaluated her, but the fact that he read 13 items in this case, he's wholeheartedly familiar with what the defense believes the facts are in this case. And I think it would then be inappropriate for him to be asked hypotheticals based on what is in the record, because clearly he got a lot of things that are not in the record. That's it. Thank you for letting me be heard.
Exactly. Raw kibbe is a phenomenal dish.
Okay, anything else we need to take care of before I let you go? When do you plan on calling Mr. Ferris?
I'd like to call him first out Monday morning, Your Honor.
Okay.
Judge, you think you're rolling weekend or Monday? Is there anything, I did have a question, is there anything in here Monday morning before us, or can we leave some of the things we've been leaving?
I'm not aware of any hearings Monday morning.
Okay, thanks, sir.
Make sure that one's turned off. It'll run it back.
Thanks for having me here. It's a long day, but good rest.
All right, chat, that's it. We're all caught up. Neat thing is, Monday morning, I will be able to cover this. So we'll get started. That's the good news. So we will get started covering this Monday morning, 8:45. Real quick, yes, cooking does not get rid of CWD. And if you ever want to read about Creutzfeldt Jacob and all that, yeah, CWD ain't no joke. But yes, tartar. Oh, come on, man. You go to like a Lebanese dinner or a Lebanese restaurant, you're going to eat kibbe. Well, you'll survive. You'll survive, man. Jeremy says, once again, the rich gets away with a murder. I don't think so. I mean, she's not like super rich, but yeah, having money allows you to get good experts. Michael says, so what can you testify to Monday morning? I think the judge is taking that under advisement all the way. Luke says, have I seen the Young Thug motions? No, I have not. I have not had a chance to read any of that. I might not till tomorrow because I've got to finish up an appeal. So after the race tomorrow at the Belgian Grand Prix, I got to get an appeal done. So no, I have not. Kibbe is raw lamb. It's really good. It's raw lamb. Well, you can also have cooked kibbe as well. You put it with some tabbouleh and rice and a grape leaf and wrap it up in a grape leaf that's been soaked in lemon juice. Oh my God, it's so good. So, yes, prions eat your brain. Yes, they do. So, yes, prions eat your brain. So that's where we are. It was very interesting today. Like I said, guys, the way the state handled that is not how you should be. That's not how prosecutors should be doing cross-examination. Okay, that is not how you should do it. I think they gave it to her. They gave it to her on a silver platter. So, yeah, we'll see. We will see. I think there's going to be some limits here. I mean, obviously, better spouse syndrome's out the window. He's not going to be able to talk about that. That's out the window, but he's going to be able to talk about things. The problem is there were a lot of problems there. Yeah, I mean, he brought it up. You didn't ask the actual hypos yourself. So very impressive judge. He likes to work. He's totally in charge of his courtroom. Yeah, it is. It is very nice he does that. You don't normally get that, like, to this level. So, yeah, I think there's going to be some limits. I think he's going to do some work over the weekend to figure it out. But, yeah, he's not going to be allowed to do battered spouse, and that's fine. I think we all kind of knew that. So, why couldn't the judge bring him back in and question him himself? Because that's not his job. It's not his job to fill in the gaps. It's like taking a test, Brittany. You know, if you turn in a half-done exam, the professor could call you back in and ask questions, but no. They submitted a test and they didn't have it filled out all the way. So that's it. That's it. So There's going to be some time to consider. He's going to take it under advisement. So that's why the judge asked, like, how soon are you going to have him up here? And they said first thing in the morning. So that guy's like, all right, I got to get on this. I don't have extra time. So he's going to work on it. Like I said, battered spouse is out, but we'll see the rest of it. I mean, he's going to be very helpful to Ashley. There's no question about that. He is 100% going to be helpful to the case. Let's see. Did I miss anything else here? Shredder's a new member. Thank you, Shredder. And then Jeremy, yep, saying the rich get away with murder. Well, I don't think she got away with murder this time. I mean, she killed him, but I think she had a hell of a defense. And if she set it up, she picked the best guy to set it up on, who basically makes it an easy excuse. That's what I'll say right there. The O'Keefe messages, I looked at them. They're yawn. Yeah, Paul O'Keefe texted Turtle Boy. Like, dude, they're like 2 seconds long. Like, there's nothing there. Like, you guys are being, oh my God, you guys are, okay, fine. Here. Like, I'm telling you guys, this is literally like, okay. Oh my God, Paul O'Keefe said, I'm taking you down. I hope you know that you're done. You are going to jail again. Actually, prison this time. I hope your kids are prepared. I look so forward to that. There. That's it. Literally. Wet fart. Popcorn fart. There you go. Like, did you think he was going to admit? Like, yeah, they told me they did it. Like, I'm just saying, guys. There you go. See? Done. Show me that thing. Okay, there. Marvel's bringing back... What the fuck is RDJ? What's RDJ? And I don't know what RDJ is. So... So, what's the total of votes now? Okay, we'll end the poll. So, we have... The verdict now is not guilty, 51%, and not guilty, 26%. People who thought she was guilty, but now not guilty, 19%. So, almost 70% not guilty. And then we have previously not guilty, but now thinking she's guilty, 2%. So it's like a 70-30 split right now. Is Dead Iron Man? Oh, Robert Downey Jr. Oh. Huh. Stacy said, so he had it coming. Maybe he did, maybe he didn't. If he didn't, she set him up brilliantly. Otto, sometimes I'm hostile. Well, no, but a bunch of you guys have already seen it. So you're like, show it. It's like, what, 2 fucking, paragraphs? Like, he literally said, probably 40 words. He said it wasn't like, yeah, Brian Higgins said they were fucking my brother to death in the basement and then threw him out in the snow. There's not enough room for I Could Fix Her on that poll option. The Hollywood stars are no longer possible. That's an issue too. So, access in my defense, I thought there was more than this. I can't believe you didn't go look for it already. No, but the Chris Tyson leaks are going to be interesting if they ever show up. So, yeah, guys, that's it. Tomorrow morning, we got the Belgian Grand Prix. We will be doing that on locals. That'll be fun. I won't be doing anything else tonight. No, Ag, I'm not. Guys, I have not had a chance to do anything fucking around with YouTube. I've had work to do and other things to take care of. So, no, I have not touched any of it yet. Maybe this week. So, with that said, though, guys, yeah. Tomorrow morning, we will go ahead. Brittany says, look at the gun laws Massachusetts passed. I can do that coming up. But we will go. What time's the Grand Prix? It's at 9 a.m. We'll be watching 9 a.m. And then tomorrow, if I get done with everything I need to do, maybe in the evening we'll hang out, but otherwise, no. But yeah, guys, 9 a.m. tomorrow. And then, yeah, Monday we'll be doing this trial because I'll be here. I got work to do, but I'll be working from home. So we'll be watching the last bit of the trial because they'll be wrapped up on Monday and the jury will probably have it. So we're all set, guys. I know they're going to drop the Chris Tyson shit. That should be interesting if you guys want to see some stuff that'll be funny when Chris Tyson gets outed for being a pedo. We'll see. Yeah, that is it. So, my Flash is on tonight too, so he'll be on soon if you guys want to see him. Vices will be on if you guys want to show Vices some love. I know he'd appreciate it. So, take care, everybody, and yeah, I mean, at this point, Ashley Benefield is 100% not guilty at this point. The prosecutor shit the bet on that one, guys. They gave it away. They gave it away. So, till tomorrow morning, guys. I will see you.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy that hated you?